we would really like to see this convention move forward and have a lot of really forward-leaning ways that it can criminalise the full life cycle of that sort of conduct across all countries. So those are a couple of the main opportunities that we're seeing in this convention, and we're really hoping will come to fruition come February. Thanks.
Thank you both so much. I heard a lot there, obviously, but a lot of themes around opportunities for capacity building, opportunities for level setting across governments to sort of move forward on common challenges together, opportunity to deal with emerging challenges, and maybe sort of summing up a lot of this from Claudia's point was that theme of this is only going to be as strong as the parties it has at the end of the day. And I think that's a theme that we'll come back to recursively throughout this conversation. But then to sort of flip the question to the other side, I suppose the much less optimistic side of the question, what are the sort of primary concerns or risks? And I know Ian addressed some of these, but I'd love to hear you both just sort of explore it a little bit more, Mike and then Timea. What are sort of been the pressing concerns and issues that you've wanted to push back on, challenges you've sought to avoid since these conversations kicked off back in 2019?
We have slightly less coordination difficulties here in the room. So. But yeah, so look, Ian did a great job of framing some of the substantive risks inherent to this process, and I think we would largely agree with that from the U.S. side, that there are significant potential risks for abuse if we do not achieve the appropriate level of conditions and safeguards on the sharing of evidence and other forms of international cooperation. Also risks of abuse if we do not carefully describe the scope of criminal conduct that is appropriately considered to be cybercrime that should be addressed at the UN level and should be the sort of focus of international cooperation. I want to also sort of highlight some of the political risks, though. There was, as Ian described, a long process prior to the initiation of this treaty negotiation where there was no consensus as to whether there even should be a UN convention on cybercrime. And the United States was one of the many states that, in fact, did not think that the time was ripe to negotiate such a convention. However, when the General Assembly decided to initiate the ad hoc committee, I think there was a real risk at that time that this negotiation could proceed in a way that would sort of privilege and prioritize the interests of states that would seek to use a cybercrime convention for purposes that are not consistent with international human rights and other important protected interests. And so the United States has sought, since the initiation of this process, to engage in a way that protects against the negotiation going in that direction. And that includes, for example, negotiating modalities that incorporate multi-stakeholder voices in every stage of the process to the greatest extent possible so that we are not losing sight of all the interests that are at stake. And similarly, I think that there is a risk if we don't engage seriously in this process of communicating to states that are developing states, that are members of the Global South, that the countries that are already part of the Budapest Convention, that already have the capacity to fight cybercrime, are not attuned to the real concerns that they have about increasing their capacity and ability to combat cybercrime. And so we have also been very mindful in these negotiations that we need to take seriously the real concerns that those states have, not only about ensuring that we are protecting human rights, but also that we are providing effective tools for international cooperation that all member states that are negotiating in good faith believe that they will be able to use to actually increase their ability to effectively combat cybercrime.
Well, as usual, I'm being turned to say what are the things that I don't like, and I quite feel comfortable in that position. So happy to share a couple of thoughts, although much has been said here already by Mike and Ian and Bryony and Claudia also to some extent. It's public record that ICC spoke out and spoke up against having such a convention when the conversation started on this. We've advised that perhaps there might not be a need for something like this. And that came mostly out of concern of not creating an instrument that perhaps duplicates what's already out there, already in UN documents and elsewhere, such as the ONDOC and UNCAC and some of the other UN documents, but also not to go against the grain of established good practices, such as the Budapest Convention. So, of course, then the process moved forward, and as it moved forward, we engaged, and we engaged mainly for one reason, is because we saw some of that positives, the potential as well, that Bryony talked to, that this can become an instrument that level sets conversation on cybersecurity and cybercrime in fighting this common threat that we all have. And that it can, if done correctly and with caution, really become an effective instrument that can increase international cooperation between national law enforcement and prosecutorial agencies to reduce the incidence of major cyber-dependent criminal activity as a priority, and of course an instrument to protect the victims of such crimes. So this is why we engaged, and we engaged quite heavily in the process since the beginning. A couple of things that at that time were our concerns, and I think quite a few persist at the moment as well, was the scope of the treaty, the scope of the conversations in the negotiations, and we really advised that in order to make this an effective criminal law instrument at that time, the scope needs to be really precisely and narrowly defined, and it needs to start, I think Bryony said already this, it needs to start from elements that are common across jurisdiction. It needs to start focus on crimes that are well defined and that are defined the same way or seen the same way across jurisdictions. So this element of dual criminality was very important for us. Also, what do we mean by cybercrime? I think it's one of the things that we're still discussing it in the process. But I think that's what we said at the time, and what was our concern at the time also, let's start small, let's start with things that we can agree on, and move from there, because we've seen throughout the process, as Mike alluded to, we were skeptical in the beginning, but we really see the value, especially for states and communities that don't really have much in their current legal system that can help address some of these issues. They don't have the capacity. They really are looking at the UN to start setting some of these things in place, to have that normative guidance. So it's better to start with something well-defined and that is actually can become a helpful instrument, especially to some of these jurisdictions and these communities. And of course, we feel that the private sector has a lot to offer there in building that capacity. So I'll leave it at that now. I'll have a lot more concerns to share a bit later, perhaps.
No, that's, I think, a great place to start. I heard concerns around rights protections. I heard concerns with not conflicting with existing international instruments, in particular the Council of Europe's Budapest Convention on cybercrime that I think almost 70 states are currently party to. Issues potentially with the scope of the treaty, what is going to be criminalized, what is not criminalized. These were concerns that began at the beginning of this process back in 2019, and after years of deliberations, though, rubber has started to hit the road. As last June, we now have a draft treaty that has been released. And so for the benefit of the entire IGF community, I'd love to hear from our panelists, and this is not directed at any one in particular. So maybe we start if there are any comments online, and then to see if there are comments in the room. What are the things that folks should know about the current draft treaty? Are there major wins, whether it's towards the things of cooperation that we wanted to see, or against some of the concerns that were just outlined in there? And are there sort of immediate areas for concern? And maybe we just start with the government voices, and then Timea, we can circle back on some of the concerns for industry in a bit.
Okay, well, if I may start, John, I think that at this point it might be a bit too early, because even though we've been already negotiating with this and have gone through two drafts, and like Ian said, they doubled in size on the last session. Now in November, by mid-November, we should have a new draft that will be published by the chair. In this draft, the last session basically took us through seeing a bit what was closer to consensus, what was further away from consensus, and that should prompt this new draft. So I think we should wait to see what will survive and what we will not in this new draft before we break our heads thinking what should be or should not be a concern, because it may not even make it to this next draft. Thank you.
I'll jump in as well and be a little bit, while I definitely respect Claudio's caution, perhaps I'm a little bit more optimistic. In the draft, I think some of the good things we saw was a very limited list of offences, which has been something that we think is quite important, to be very clear on the types of offences that all countries should criminalise, and it's been very focused in the first draft, so we're very glad to see that. We also saw clear investigative techniques for how to investigate cybercrime, and quite clear articles on how countries can cooperate. The things that we think could be improved, perhaps is the way of phrasing it, is it's not clear how these different chapters interact with each other, and that goes to the scope question, which Timea also mentioned. And how the list of offences interact with the investigative techniques in the convention, and also with the international cooperation mechanisms. We, from Australia's perspective, the conditions and safeguards around some of these procedures are still lacking, and we would like to see them strengthened. And we were also disappointed about the capacity building chapter of the convention and the technical assistance. We thought that could be beefed up quite a bit as well. And just one point for the internet governance community in particular, you talked about major wins, and one of the major wins that we saw in that draft, and in fact in the conversations that we've been having in the ad hoc committee, is given the long history of this process, at the very beginning there were a lot of concerns early on that the convention might try to stray outside of its mandate and into issues around the governance of the internet, the technical management of the internet, regulating telecommunications and internet service providers, and regulation of industry. And we have managed to avoid that risk now, and from our perspective, and hopefully for the internet governance community perspective, that is a really major win.
Thank you both so much. Mike, I don't know if you have anything to add to that.
Thanks. I won't belabor the point, and I think I largely share and adopt Bryony's comments. I'll just add that in terms of wins, so this is sort of boring on the one hand, but significant nonetheless, which is a large portion of the draft that was produced in June draws on existing language from other UN criminal justice treaties, and not all of that language may be appropriate for a convention that's being negotiated 20 years later or in the context of cybercrime, but it is, I think, a win because it is language that has been widely adopted in the UN system, is understood by practitioners at all levels very well, And to one of Bryony's points, I think guards against the committee steering into uncharted waters in a way that could be problematic or create ambiguities in interpretation. And then the other thing I'll note is that as much as we certainly continue to align ourselves with those who believe that the human rights protections and conditions and safeguards on the significant powers contained in this treaty need to be stronger, one of the areas where this draft treaty has already gone beyond existing UN criminal justice instruments is in the inclusion of explicit reference to human rights and the incorporation of an article on the importance of protecting human rights in the context of exercising the other obligations and authorities contained in this treaty. So there's still a lot of work to do, as Claudio mentioned, and a lot of uncertainties as we look forward to the next round of negotiations. But there were some significant things to like about the draft that we saw in June.
Thank you all so much. I'm going to come back to you on the industry side in just a question or two, Tamea. I think that's really helpful in setting the stage for where the conversations have come up to, or at least what that initial draft has said. And it's a point well taken, Mike, that by sort of drawing from existing language from other treaties, that you can hopefully go some way to reducing some of the ambiguity that was highlighted as a concern in the risks area. I do want to remind you, we just had more folks coming in the room since we started, as we're the first session of the day. We are going to have a bulk of time to spend in a sort of audience Q&A or just comments from the IGF community. So as we think about what the panelists feel like the IGF community could benefit from knowing or being looped into, if you have comments in response or questions about that, please do keep those in mind, and we'll have time for that in just a bit. And that goes for folks online as well. Please stick those questions in the chat if you have them. But picking up on, I think, what Claudio had introduced, which is that since that draft was released in June, the most recent thing that has happened is there's been a 6th round of negotiations, I believe, in New York. So maybe first back to you, Mike, and then we'll go to Bryony online to bring us up to speed on what that round was like and what we sort of expect to be the impact of that on a forthcoming draft that Claudia mentioned we're likely to see, it sounds like, late this year. Do we expect major changes, and where do we expect the process between now and sort of the next session to look like, and what do we sort of paint a picture of where this goes from here, I suppose?
Yeah, easier said than done. I mean, I think, again, as Claudio already noted, we're all waiting to see where things go from here. And has already been observed, the draft sort of grew to double its size in the last round. So the chair at the beginning of the last round had urged member states to focus on using her text as sort of a basis for sharpening consensus. That was not the road that we took. In fact, many member states introduced a lot of proposals that had been previously considered and rejected at earlier stages of the process. And I think that that was not well received by other member states, unfortunately. So I think coming out of the last round, it was clear, as Ian observed at the outset, that the committee has still not been able to reach consensus around some of the fundamental issues. And I think that perhaps is connected to what Bryony already observed, which is that so far in its work, the committee has, up until this last round, considered each element of the treaty sort of discretely and independently of the others. So if you want to take a sort of glass half full perspective, a positive outcome of round 6 was that it was the first time that we finally started to put some of the pieces together. And Bryony and her co-facilitator actually ran a extremely intensive informal process at the last session to help figure out how the different pieces of the treaty dealing with the scope of its application might actually relate to each other. And there has since been an effort to connect that scope to some of the other important elements of the treaty, most notably how it interacts with human rights and safeguards. So we're starting to put the pieces together, but we're awfully late in the day to be just getting to that point into the negotiations. I guess the last thing I'll say is just in terms of nuts and bolts. So we expect, as Claudio already alluded to, that there will be a revised chair's text circulated publicly sometime in November, that member states and other stakeholders in the process will be able to read and react to, and that will tell us a lot about where we are going into the next round. My view is that despite the lack of consensus, there was nevertheless a lot of clarity as to which proposals in the last round have a path to consensus and which ones don't. But it is really in the chair's discretion right now what will go into the next draft, and that will be sort of the basis for our continued work in January.
And Bryony, over to you online.
Thank you. Mike's done a very good effort of basically saying everything that was written on my list, but just to add a couple of points, I think from our perspective, the monstrosity of red text that we came out with at the end of that is something that we are taking with a grain of salt. To be honest, we are looking, as Mike said, there are a lot of proposals in there, some of which were made for political or tactical reasons rather than substantively an attempt to garner consensus on substantive issues. So we're very much taking the chair's first draft text and looking at how those negotiations played out. We expect to see some changes to that chair's first draft text. We had some really in-depth conversations with the majority of countries engaging in really good faith and really trying to improve the text on things like child abuse, data protection, the safeguards, the human rights, law enforcement powers. And we can see that there are improvements to the chair's text that can be made there, and that a majority of countries from a broad spectrum, a really diverse spectrum of countries, are really keen to see. And also on scope. So I think that the scope question is absolutely key to where the next draft lands, which, as Mike said, hopefully will be coming into our inboxes in November. And as Mike mentioned, I did have the honor or perhaps the punishment, I'm not quite sure, to co-chair informal negotiations and sessions on scope with my wonderful Jamaican counterpart. And we did have a lot of divergent views on this really fundamental aspect of the convention. What does it cover and how should it work, and which bits should work with which other bits of the convention. There are several potential out-of-the-box options that we've been thinking about in that informal, and then also that I know other countries have been considering. And there are definitely conversations still going on outside of the formal negotiations before we're expecting that draft text from the chair, hopefully to influence how that looks across the spectrum. And I know that this is happening not just with the scope question, but also with some of the other articles that were of keen interest to other countries. Data protection, I know conversations will be continuing to be ongoing on the sidelines there, and Australia is very keen to talk with countries and stakeholders on the child abuse articles as well. Yeah, so a lot of work happening in the background. It's not just coming to New York for 2 weeks and sitting in meeting rooms in a UN basement for 20 hours a day. It's it's constant.
Thank you both so much for that update, and that certainly sounds like really important work on that kind of theoretical red teaming of the text as it currently exists. And it sounds like there is no shortage of work to be done between now and what is the last scheduled session of the AHC process that will be in January. Despite that, I know the IGF, to Mike's point, we're always a half-full community kind of community. To me, I'd like to bring you into the conversation though here as well. From the business community side, are there major concerns with the current draft as we've seen it, and what were those?
Thanks, John. Indeed, I think I agree in parts with Claudio's sort of optimistic outlook. It's been difficult to sit in that room in New York in the summer and look at how that text really started bleeding red from all parts. But I do share that optimism that some of that we're hoping it clearly doesn't have consensus. So we might be able to look again back at the chair's draft and see how that negotiation in New York maybe moved some of those bits forward. But I personally am hoping that we don't have to be concerned with all extra 40 pages of text that ended up in that negotiating draft in New York in the summer. So looking back into actually what private sector had concerns with when the chair's draft came out in June, and what we think that hasn't moved quite forward to the negotiations at the end of the summer, are three main buckets. We have a lot more to say, but I think there's three main buckets that are important. One was already mentioned by my government colleagues here on the panel, is how does the chapter on scope interact with the chapter on safeguards, the chapter on international cooperation measures, procedural measures. It's quite unclear, or it was quite unclear in the chair's text as well, whether we have different scopes for different parts of the text. We would argue it's better to focus the same scope across the entire text, especially when it comes to evidence sharing, data access, and some of those other issues. That's the general point, but my government colleagues have really spoken to that. Point number two that I think was something that we really talked about a lot in previous negotiations and also in our submissions into as a reaction to the chair's draft, as some of the issues that would in effect prevent private sector to properly cooperate with governments, with law enforcement agencies, prosecutorial agencies in making cyberspace more secure. And that is looking at some of the jurisdictional issues and conflicts of law. As some of the parts of the text stand at the moment, private sector is really being put in the middle as sort of a ping pong between potential inconsistencies in approaches across jurisdictions and laws that are not defined the same way or don't expect the private sector to cooperate the same way. What do I mean by that? There are many instances when the private sector is asked by a certain jurisdiction to do something that if they would comply, it would break the law in a different jurisdiction. So what does a service provider, a data custodian, supposed to do in that situation? And is it really up to them and their legal teams to decide whether or not they can or cannot do that and who to comply with? That's one. And two, is there a way for the private sector to be able to enhance the trust of their clients and consumers when they're being prohibited from sharing that information back in a transparent way to their users and to community at large? And I don't mean this, you receive a request from a government and you immediately publish it. Of course, there's ongoing criminal investigation processes. There's things that we obviously know in the private sector that there is a certain amount of secrecy around certain of these conversations that is helpful to law enforcement agencies and to conduct their work in a proper manner and truly do fight some of these crimes that we're talking about. But there needs to be some sort of limitation to that. And the current draft, as it stands, I don't think moves that forward. And I go back through this, the segue to my third point. It is a bit unclear in the text at the moment of what are some of the data access obligations or requirements that the current treaty wants to put forward that would, again, obligate the private sector. There are very broad expectations as of when and how the private sector should disclose the data of their clients and users. And not necessarily very clear safeguards or process points in there to share the details of what data, to whom, how long should be disclosed, who has the authority to ask for it, who has to underwrite that request. Is this a judicial process? Is this an automatic process? And then again, you go into issues like interception, real-time interception of traffic data, content data, that is put there as usually a special investigative procedure, and that is very seldom used, but at the treaty as it stands now, it is up there with the general use procedures. Again, I think our concern from the private sector on that regard is what should be there as a level setting sort of normative instrument that UN texts are, to help move some of these processes forward, or are we writing a treaty here that legitimizes certain uses that are really outside of the norm, but puts it up there as a menu to choose from? So again, these are our three main concerns, but I do want to end on a positive note, just so that I'm not always the the person that gives the negatives. I think there are a couple of positives in the text that we do like. Mike mentioned human rights safeguards that are there. Again, I'm talking in comparison with other UN instruments, but I think there is a step forward that those are actually being mentioned and are being mentioned in a bit more consensus-ready way that I've seen in a lot of the other processes that I've been part of. I've recognized the chair's efforts in limiting the scope in her draft. I think that was a really, really good start. The fact that the treaty draws from other treaties and criminal justice instruments, I think is a positive. I would add a caveat here, though, just because I am the one that brings in the concerns. Other treaties that this convention is being based on also have annexes and have explanatory notes that go much more deeper into the safeguards and protections. We don't have that. I'm not even sure that we are going to ever have that. So we need to be clear that when we lift from those texts, we consider that in conjunction with other parts. And then the last thing that hasn't been mentioned before, and that goes to your point on what should the IGF community know. This process, as it stands, I think is one of the most inclusive UN processes towards stakeholders that I have ever been part of. It's not ideal, it could be strengthened, but I do have to note that, and I think it goes to thank a lot of the member states who were negotiating the modalities, and to thank the chair. Those who have applied to be accredited to observe this have all been accepted, and ever since then have all had the chance to send in written notes, to come to the meetings. The chair sets aside time, again, in the limits of possibilities, to hear from us, those of us in the room. The UNODC NGO unit really goes out of their way to give us opportunities to talk to members on the side. So if you are concerned or interested in multi-stakeholder inputs, I think there are ways to do that. And again, this is just a call. If you are a private sector member and you haven't been accredited, talk to us. We're always very open to hear from others. But I do have to end on that positive note. I think that is very helpful.
Thank you so much for the comprehensive overview, and also always for ending on a positive note. Taking off my moderator's hat and throwing on a Microsoft one for a minute, just to, I think, co-sign a lot of what you just said, and in particular, honing on that last set of concerns you had around data access. And I think, our leading concern is how do we keep this to be an instrument that can be focused on facilitating government cooperation that was outlined in sort of the opportunities portion of the discussion at the outset, as opposed to being a data access treaty. And that some of those sort of data access elements that you outlined there, Timea, would, kind of ironically or unfortunately actually undermine the ability to sort of prioritize and effectively address what are serious crimes and what are the ways in which we can streamline our sort of data access processes that currently exist. Back on with the moderator hat, one major concern from sort of the civil society community and human rights defenders in particular since this process began has been the risks that a resulting treaty here might criminalize speech, in particular the work of political dissidents or other human rights defenders across the globe. Does the draft as it currently exists set appropriate safeguards so that more authoritarian interests won't be able to criminalize such activities beyond their borders in a third country that may well be a party to the treaty and where that sort of free speech concerns might be externalized? I'd ask maybe Claudio if we could bring you in here first online and then maybe back to Timea for your thoughts here.
Thank you, John. Well, I think we have an advantage here, and it is that the Assembly General mandate for the ad hoc committee established that its decision should be taken by consensus. And if at some point in the process we decide that there has been enough attempt at reaching consensus and it's not going to be possible, then if a vote should take place, this vote would be won by a 2/3 majority. So, on the one hand, taking this into account, I don't think there's the slightest possibility that any provision that would limit or hinder human rights, like you mentioned, will make its way into the final text of the convention. And then on the other hand, I'm fairly confident that we will end up with sufficient safeguards to prevent misuse or abuse of the criminalization provisions and procedural powers of the convention, even though they may not feel right now as enough, like Brian has said. I think because of this decision-making process, if this is ever, first of all, if this is ever going to fly, we need to try and find this consensus, or at least we need 2/3 of the member states to agree on it. And back to my original point, this is only going to be as useful as the number of parties that end up using it. So that's again why we want to avoid getting to a vote, because if there is a vote and we end up with 2/3, then that's the ceiling that we're going to have. It's only going to be up to 2/3, and then for whatever time it takes all these countries to ratify this convention. So again, I'm very confident that that will not be a major risk, even though there may be parties that would be inclined to have loosely defined things that could eventually be used, maybe not in a way that some of us would not like the way to be. I very much doubt that will be the case.
Thank you. I agree a lot again with Claudia, and thank you for bringing some of that hope and optimism into this conversation. I don't even think it's necessarily a safeguards issue. I think it's more of a scope issue as a first instance, and then we can go into the safeguards, of course. I think I'm going back to the basics here, but we have always said this should be a criminal justice instrument that focuses on cyber-dependent serious crime. Now, online speech is not cyber-dependent, it's cyber-enabled, one. And I think if we go from that premise, then I agree with Claudio, it shouldn't even be an issue in this conversation. Two, freedom of speech is something that is fundamentally important to the private sector, and we are great proponents of that. However, we are aware, especially those of us who work across jurisdiction, on the online that goes beyond national borders, that it is very difficult to define what freedom of speech means when we have so many different legal definitions in different legal systems of what can and cannot be talked about, what is the limits to freedom of speech, when does that end, and where do other human rights and fundamental rights start. As long as those things are not clearly defined across multilateral settings, I think it's very unfair to put, and I'm sorry to be this blunt, it's early for me in the morning, it's very unfair to put private sector in the middle and say, you solve this. You'd have to take it down, you have to enable it, you didn't do it well, you didn't check it. It's difficult to put that in the middle because we end up in the space that I mentioned a couple of moments earlier. You are asking the private sector to break the law in one jurisdiction to respect the law in the other. It is an impossible situation to be. I'm not a human rights expert, so there's a lot more to say on this from that perspective, but I think I want to leave you with that. First of all, this is a scope issue, and we need to solve it at that. And secondly, in the procedural matters, I think it's subject to a lot more multilateral conversation before we ask other actors in the chain to operationalize it.
Thank you both so much. I'm going to put everybody on notice. I'm asking one more question here before opening it up to questions either in the room or online. As Tamea noted, she's not a human rights expert, and I don't think we have one on the panel. And if we have one in the room who would like to respond to any of these questions, provide additional depth, please do so. Or if you have additional questions to put to the panel, please do so. And that includes online, so Pavlina on notice to please help us moderate that conversation if there are questions in that space. And similarly, as you're a speaker from civil society properly, please feel free to chime in at the outset of Q&A if you have responses to anything that's been said currently. But one more question for our panel before we turn to Q&A. Is that one of the challenges in combating international cybercrime has been safe havens. Countries which seemingly turned a blind eye to cyber criminal activity taking place within their border, whether that's a capacity issue or simply because that activity is not targeting victims that are within those borders. For whatever reason, reports of those of criminal activity taking place that is actionable is frequently not having action taken against it. Do we see the current draft of the treaty or any of the sort of trends of where we see the draft going as being likely to prompt governments to take further action against those groups, whether that's a sort of capacity building or a sort of political effort that could be, prompting things in a more effective direction? And I might ask Mike and Bryony to respond to that, and maybe Mike, will start with you, and then Bryony online.
Sure, thanks. So, John, I think you already sort of sketched out some of the elements of my response, which is, I think if it is a capacity issue or a prioritization issue, then I think this treaty could, if it's the kind of treaty we want it to be effective in addressing some of these safe haven issues, because the treaty will provide for sort of the leveling up that Bryony described in the necessary investigative techniques and procedural measures the country should have in place, the harmonization of criminal legislation, and then I think most importantly, the availability of technical assistance and capacity building so that states who may have the will but not the means to combat cybercrime in their jurisdictions, will have increased resources and an elevated sort of priority on combating these types of crimes. But that will not solve the issue of political safe havens. And this treaty, I think, again, as the United States and many other states envision it, is intended to be a criminal justice instrument that should be sort of practical and narrowly focused on criminal justice issues. And so we have actually very deliberately not used the ad hoc committee as a forum to address larger questions around, responsible state conduct, whether online or in the sort of appropriate oversight of actors within their jurisdiction. And so there are certainly other forums in the UN system and otherwise where those critical issues are being addressed and need to continue to be addressed. But the sort of political questions around state behavior and providing safe haven for criminal actors are outside the scope of the AHC process from our perspective.
And over to you, Bryony.
Thank you. Yes, you've both basically said what I was going to say, but I am going to be a little bit more controversial than Mike on the second part. I do agree completely that countries that don't have the resources or the ability to effectively combat cybercrime, this convention has a lot of work to help them combat cybercrime emanating from their territory. But the other category, countries which actively permit criminal activity to emanate from their territory, is a much more complicated issue. And I very much agree with Mike that it is important to keep separate the way that we deal with and talk about these issues, the behavior of states in cyberspace and responsible state behavior versus the behavior of individuals and criminal groups, which we're dealing with under this convention. But I think that this convention can assist in a way in the way that we deal with states who are actively permitting those sorts of behaviours to come, because it can have an effect of setting better international legal standards, and it can have the effect of setting more normative behaviours around what states should and shouldn't do. And this leads us into, for any international lawyers in the room, when we're talking about responsible state behaviour, we're looking at due diligence and those sorts of issues as well. So I think while we want to keep them very, very separate, there can be an effect from this convention if it's done well and if it's done properly, because it is harder to hide in the shadows when you have very clear rules, when you have clear law, and when you have clear norms in place. And that can potentially have an effect there.
Thank you so much. And we welcome the provocative responses always. And so with that, there are mics in the room if anyone would like to propose a question or comment on anything that has been discussed already or that should be discussed. And Pavlina, also over to you if there are questions online that you could either read out or if there are comments that you would like to make on anything that has already been said. And if not, happy to move forward with some other structured questions that we have here.
Thank you very much, John. So I do not have questions online. I do have very brief remarks from a position as a civil society organization which has been accredited to the process and participated to the process. And I just wanted to take this opportunity. At the same time, as I take my minute, I do support everyone who connected online to send their comments, because this is a very experienced, esteemed panel and a great opportunity to get your questions answered. So I highly encourage everyone to send their comments or questions. For an organization which has been part of this process, especially since the early drafts emerging. What is very interesting as a bigger picture is a very strong agreement on among multi-stakeholder voices. And to mind that multi-stakeholder voices are very different voices. There are very different voices coming from civil society, from human rights organizations, also from private companies and research organizations. And these voices oftentimes do not find this kind of unison and united positions. Here at the multi-stakeholder community and the cybercrime negotiations really found broad agreement on key priorities and positions. So this is something to pay attention to, because obviously there is a lot of experience and expertise from this variety of voices across regions, which are pointing to issues which may be problematic in the emerging convention, and also pointing to the way where it should be going. I would also like to pinpoint the great cooperation between different groups, and this is something which already builds trust as part of multi-stakeholder community, but also with the states, and that will be very important as well for the implementation period of the treaty, because after the February, after the session, the concluding session wraps up in February, we'll then move to another part, and I wouldn't like to take us there already because there are too many important moving parts to put together until then. But building kind of trust between the actors will be very important for really delivering the results for people on the ground. I would also like to highlight the support which Timea mentioned earlier to multi-stakeholder community from UNODC and their civil society unit. As a stakeholder participating in several multilateral processes related to cyber, Cyberpeace Institute very much appreciates the modalities which are pulled as part of this ad hoc committee on cybercrime, which allow us to participate fully in the process. And I also believe, just to conclude my points, that stakeholders are showing the value of the participation. We have seen so many organizations being deeply involved in these negotiations and bringing a lot of capacity and a lot of information to this process with their in-depth research to support their proposals, their recommendations, and positions in the process. So I think it's also a very important occasion to see how these multi-stakeholder communities and state can come together to mutual benefit of informing the final product as a treaty.
Thank you so much. And we have a question in the room.
Hi, thank you. Thank you for the great discussion. I wanted to ask something about private sector involvement. Thank you for the great comments already. It's obviously very complicated, as already mentioned, because private companies have multinational interests, and apart from that, these are dynamic over time, and it's very difficult to monitor them because new multinational interests can come into a company, and publicly that information isn't going to be available for some time before the company is already aware of these changing priorities. The issues that we've mostly been talking about today are around detect and respond activities in cyber, and on the detect side, private companies are already sharing threat intelligence data with each other in order to better tackle their internal problems. Is there appetite for a kind of voluntary model of data sharing from these organizations that wouldn't kind of require them to submit information, but rather they can submit it to some sharing platform already, or is that not deemed strong enough? And on the response side, yeah, I think the issue of asking companies to do takedowns, that's very complicated. Is there any appetite for kind of, or any discussion of UN cyber peacekeeping, which to my understanding, I'm not an expert in the area, is still a very kind of academic concept at the moment. Is there any kind of resource or interest in that activity?
I don't know if you have strong thoughts, otherwise I'm happy to jump in too.
Sure, thanks, John. And I might ask you to also, from a perspective of a company, ICC is a collective of a lot of companies. So I will not speak to any one company's strategies on how they're being dealt with. I hope you can bring in some examples, John, if you can, from your own. Companies are very committed, obviously, not only to make sure that their systems themselves are secure, but that they help others in their chains to try and secure cyberspace. But I think here we're talking about cybersecurity, not necessarily cybercrime conversations that are quite diverse issues when we talk about them in the UN world. What I think is the most important question is timing. around disclosures of these vulnerabilities and information sharing. I think it's when do you do that is very important, and where do you do that is also very important. So you can detect a vulnerability, you can notify perhaps your own chain, but the moment you do this publicly, you've put out the vulnerability for exploitation. And patching up those vulnerabilities, first of all, within your supply chains up and down, but then with your users, it requires time, it requires a lot of attention, and acting fast is not only on the good side, it's only on some of those that might not have the best intentions as well. So it's very difficult, I think, to expect or even mandate companies for immediate public disclosures of vulnerabilities. It is an instrument that is out there, we're aware of it. I think private sector and the public sector is in constant conversations around how to do this best. There's a lot of value in these disclosures, and we subscribe to that. I think the issue is timing, and the issue is the means, when does that become public and when does that become private? That's the other one side. On the content question that you've asked, I was on a panel earlier, and I believe it was Vince Cerf, if I'm not quoting him wrongly, who said just on one platform, I think it's on YouTube, there's 400 hours of video material uploaded per minute. 400 hours of video content uploaded to a platform per minute. How do you deal with that? So I think we need to think a little bit about there's no way in physical human time to deal with that unless you use technologies such as AI, for example, to try and mitigate some of that. So I think companies are very engaged in doing that, but there will never be a moment where we will have no harmful or content that is not. It's just like security. I think an ideal online content world will never be. It's an elusive goal. We need to be aware of that. Perfection doesn't exist. Total security doesn't exist, neither in the physical world nor in the online world. There are tools, and I think companies are very committed to working together towards those tools. And for example, in the online content world, GFICT does a lot of good work. If you are not familiar with them, I encourage you to look into. That's one example that might be a good idea.
I think it's a great question, and gets to, what can be solved with a treaty, and what also fundamentally is not going to be solved with a treaty. And I think that actually underscored a lot of the messaging at the beginning of this, which is there's a lot of challenges in addressing growing, cyber security issues that you kind of alluded to, but also just broader cyber crime, where the sort of doesn't pivot around do we have the sort of legal instrument. On the detect side of what you were describing, though, companies already do an incredible amount of information sharing across that ecosystem, both formal and informal, depending on the structures that are there. That's not to say that that's entirely sufficient, and it's certainly evolving. But what's really encouraging is if you talk to our security teams, and really I think most major technology company security teams, is a customer of one company is a customer of another company as a customer of another company as far as they're concerned. Competition kind of fades away pretty quickly, and there's a fairly robust community of information sharing on an informal level there to corroborate what they're seeing as it relates to criminal activity, or even just more sophisticated actors' threat activity. So that's good to see. It's important to remember, I think, when we talk about what kind of information sharing institutions and obligations should exist, that it's a resource-intensive process to be doing the kind of information sharing and mandated reporting that you'd be talking about. And so trying to think about what kind of information is critical to be reported, and when, and what the narrow sort of rationale for that is, so that we're prioritizing those resources, I think is always important. On the response side, I similarly think it's probably really early days on like a sort of UN cyber peacekeeping capacity, but we certainly, on I'll just speak for the Microsoft side, I do a lot through civil actions to do, takedowns of, botnets and other malicious infrastructure as it exists on our platforms, using the civil courts to sort of gain the authorities lawfully to do that. We also have robust relationships with law enforcement agencies around the globe that have sort of been independently established over time, and I don't know that there's. I think something like the cybercrime treaty negotiations, as they currently are structured, might augment and improve some of those collaborative capacities across jurisdictions, and so hopefully that could be one positive way this could be influencing that. I don't know if Mike, you have anything else to add?
Yeah, I just want to pick up on one theme that you were just sort of getting to there, John, which is from the sort of law enforcement and cybercrime perspective. I think one clear message that has emerged in the ad hoc committee negotiations is that many states think that there is a sort of two-class system in terms of voluntary cooperation with the private sector. That there are some governments that the private sector is willing to work with, the United States often among them, but other governments that do not believe that they have the same sort of privileged access to information sharing and collaboration on a voluntary basis with the private sector. And that's not to cast blame. I think you already noted that there are sort of capacity and prioritization issues on the private sector side. It's not just a government issue, and the private sector is often taking into account very real concerns about how information that is shared may be used by the government that is requesting it. And so, I think an opportunity that we have in, again, the context of the Cybercrime Convention is, as we've already discussed, to set minimum standards for how information is to be protected and used, so that whether it's information that's being provided on a compulsory basis pursuant to a mutual legal assistance request, or information that might be provided on a voluntary basis, more countries may have more access, not because companies are being compelled necessarily, but because they have brought their systems up to a level where your companies, other private companies, may have more confidence that information that is shared will be used in an appropriate manner. So I think there is an opportunity here to harmonize and raise levels, as we've discussed, in a way that might facilitate both voluntary and compulsory information sharing.
Thanks, and thank you so much for the question.
Thank you very much. Also, my kind colleague here pointed out I should have introduced myself. I'm Matilda Road from British Standards Institute, but ex-private sector. So yeah, thank you.
Glad to have you here and glad to have the question. Are there any other questions in the room or online? Please take the mic.
Hello everyone, my name is Anastasia Kazakova. I'm a Cyber Diplomacy and Knowledge Fellow from Diplo Foundation. This is a civil society organization. We focus on capacity building. I do have a question. If the November draft from the chair sort of will be adopted during the 6th session at the IHS, how will be the next process organized? I assume that there will be next stages with the ratification of the adopted treaty. And my question is, do you see the risk that if the text is adopted, there would be the risk that the text would not be ratified with by the member states? Thank you.
An important and forward-looking question. I don't know if either Bryony or Claudia would like to jump in there first. Otherwise, I'll put Mike on the spot.
I wanted to answer the last question.
Please do both.
But I promise to talk about ratification afterwards. No, I wanted to take off my cybercrime hat and put on my responsible state behavior hat, because I am the head of Australia's delegation to both processes, and just note that in the security space, when we're talking about threat intelligence sharing, there's a lot of work going on in the United Nations First Committee on this, and I would very much recommend having a look at that. We're looking at sort of all sorts of things around a potential threats repository where threat intelligence can be shared voluntarily between countries. And from Australia's perspective, we'd really like to see the private sector and other civil society involved in that. And we do have norms of responsible state behavior in cyberspace that do include vulnerability sharing and reporting and things like that. So there's a lot of work going on in that part of the UN, not in the cybercrime part of the UN. And just to comment on Tim Ayer's point around timing being key, I think one of the other really key issues for any sort of data sharing when we're talking about cybersecurity is trust. And it's building that trust between governments and the private sector, and between computer emergency response teams, and between others who are working in that space. So that was my answer to the first question. But on the ratification question, which is a really scary question, to be honest, because it is looking forward past the negotiation of a text, and it is assuming that we will have a text on the 9th of February that we're all comfortable with, hopefully. And if we get there, and I think that is an if and not a when, then what happens with that? We'll assume that it has been adopted by the ad hoc committee by at least 2/3. Hopefully we won't have to go to a vote, but maybe we will. After that, it will go to the UN General Assembly for adoption there, and then be open for ratification. And I understand that there are a couple of countries who are proposing that they might hold a high-level signing ceremony as well. So that's sort of the plan of action for next year. But one question that is still up in the air at the moment is how many countries need to sign on to the convention before it actually comes into effect, how many countries need to ratify the convention. And that is still definitely something that is being negotiated and will have an effect on when the convention, if the convention is agreed and adopted by the General Assembly, when that actually takes effect, and how many countries need to ratify it before then.
Thank you so much. Pausing to see if there are any other questions, either in the room or online. Please take a mic.
Good morning, everyone. My name is Samira. I'm from Sri Lanka, working for Dialog Asia, a telecommunication company. I'm from private sector. So we do have, cybersecurity business vertical running. But my question is on different thing, like maybe there in Sri Lanka, we are trying to, pass the online safety bill, and that is at the parliament level. So I'm trying to understand. Now, let's say this UN cybersecurity treaty, if that is adopted by a member state, how that would support, or how would that add value to the efforts, like maybe passing the online safety bills, that kind of efforts what we do, how that would support the member nation. I want to just panelists expert views on that.
Not sure who might want to take a crack at that first.
I'm happy to, if that's helpful.
Sure thing.
It's a really interesting question, because there is this confluence between cybercrime, online safety, online harm, cybersecurity, and how it all fits together. And it's always hard, because we pull this apart in government and put it in different legislation. We pull it all apart in the UN and stick it in different committees. But at the end of the day, we're talking about keeping the internet free, open, secure, safe, reliable, and that does have a really close interaction. So I think when I'm not sure exactly about the content of Sri Lanka's online safety bill, but looking at some other online safety legislation in the region, often it includes things around education, aside for everyone uses to keep them safe online. It will include things around cyberbullying. Some legislation does that, around combating the non-consensual sharing of intimate images, around keeping children safe online, protecting the elderly, and some basic cybersecurity requirements as well. So those are the sorts of things I'm imagining are in your online safety bill. But if I'm wrong, I'm sorry. But I think the ad hoc committee and the convention here does add value, because it provides it has a chapter on prevention, which does go to a lot of that work on education and cybersecurity. And we're also hoping that it will include an offence for all countries to include on preventing intimate image abuse, which is non-consensual sharing of intimate images, which is something that is included in many countries' online safety bills. And so we're hoping that that would also be something that adds value there. But really, it's that prevention side of things that is often set up for in the online safety bill. And we have a full chapter on prevention in the current draft of the convention. So that would be the biggest link.
Thanks so much. And anything to add, either from Claudio or Mike, on sort of the interaction between domestic legislation and the AHC convention? Great. Well, then I think we have one more question in the room, and then I've got a lightning round to close this out.
Good morning. I'm Joyce Hackney from Chatham House. Thank you for your, for the discussion, and great to hear the optimism from the state representative on the panel about the future of this process. We talked a lot about the scope of criminalization in the convention, but what we didn't talk about, I guess, is the scope of application of the international cooperation chapter. And as we know, at the moment, the direction that the draft took is that keep the scope narrow, criminalization narrow, but open the international cooperation chapter up to be able for countries to be able to share evidence on the crimes included in the convention, but also serious crimes more generally. And serious crimes is defined as crimes with at least 4 years of imprisonment time. So that raises the question about, the scenario where, authoritarian countries, for instance, can use this provision in order to share evidence on something they consider as serious crime, which often, as we have seen in the world, they use cybercrime laws to define online content as serious crimes. So how concerned are you about this risk, and what will you do in order to avoid it? Thank you.
If I may,
please
begin here. I think that the basis of all this evidence sharing for any crime or serious crime, because there's still it's still an open subject, but it's on the basis that it's dual criminality, like Brian said at the beginning. So it needs to be a crime in my jurisdiction for me to be able to cooperate with another country with this evidence. So otherwise, if it's a political crime, there will not be any evidence sharing. Just as an example.
So I agree with Claudio on that. Of course, that doesn't necessarily fully address the concern of two authoritarian or repressive governments having dual criminality on an offense that other countries believe shouldn't be an offense in the first place or shouldn't be a serious crime. And that's where we get back to the point that several panelists have already made, which is the linkages between the scope and other provisions of the treaty. So many countries, Canada perhaps most prominently in the last round of negotiations, have emphasized the importance of having provisions in the treaty that make clear in various ways that there need to be safeguards in addition to dual criminality that are sort of universal as to the limitations on the ways that the treaty might be abused to support the prosecution of offenses that are in violation of human rights or otherwise, discriminatory or contrary to other important sort of values and principles. It remains to be seen, how those concepts will be incorporated into the treaty. Obviously, that's what we're all doing here and will be doing in the next round. But I do share some of the optimism that I think other panelists have expressed about the modalities that we have giving us the opportunity to achieve an appropriate balance on those issues. And I also will just say, I think the trade in the scope between narrow criminalization and a slightly broader range of cooperation, I think is still an effective one. I think we are better off, generally speaking, with supporting the idea of broad electronic evidence sharing than we would be if we were still mired in debates over the sort of long list of potential cyber-enabled offenses that countries would otherwise feel the need to criminalize at an international level in order to get the range of cooperation that they think they need to be effective.
Thank you both. I think the point is really well taken to consider not just what would an implementation of this treaty look like in a context that you are familiar with and comfortable with in terms of the prevailing sort of governments and values, but also how might it be used and employed in two countries that have wildly different sets of values in play. That does bring us very close, and in fact at the end. So I just. Perhaps one last, for 20 seconds each, how are you defining success at the end of this process as we sort of rapidly approach the last round of negotiations? And I will start in the room, and then we'll finish online with Claudio, and then Bryony with the last word.
So I'll, fill my glass halfway again. I mean, I think in some ways we've already succeeded in the sense that we have taken what was a divisive process that we did not support at the beginning and established modalities of participation for both member states and stakeholders that are inclusive, and that, whatever the challenges, have fostered a very expert-driven and wide-ranging, sort of diverse participation in 6 very intensive rounds of negotiation. So whatever the sort of outcome is, the process really has been valuable, I think, regardless. But I'll also just endorse what other panelists have said. For the treaty to be effective, it will need to be consensus-based and widely subscribed. A criminal justice treaty doesn't work if it doesn't have, near universal subscription from UN member states. And so we need to always keep that in mind, and a treaty that has only a small number of ratifications will not be a success.
Basically, Mike has said most of what I wanted to say. Success really looks like we need this process to conclude with an effective instrument that supports international cooperation between national law enforcement and prosecutorial agencies to fight and truly reduce the incidence of serious cybercriminal activity online. That can only be done with a narrow scope and focusing on the commonalities and adopted by consensus that actually not only goes into signing and ratification, but actual proper implementation. Otherwise, I think we've wasted, 4 years?
Claudio, over to you.
Yep, I basically agree with what Mike and Timea said. And I think that at the end of the day, the success or failure of this, the way I see it, it's the combination of the usefulness of the provisions that finally make it into the text of the convention, especially the procedural ones, which are the tools that we need for investigation and cooperation. And the combination of that with the number of states that ultimately ratify it, because of what I've said a couple of times.
And Bryony, the last word to you.
Thank you so much, John, and everyone. It's not a secret that Australia was initially skeptical about the need for this convention, and I think there are quite a few people in the room who had that initial view, but we were convinced and have been convinced over the last few years by the potential opportunities that this could be one of the most worthwhile things that is done in the UN on any type of issue in cyber this decade. But we are very far from realizing that level of ambition. So to be a little bit pragmatic at the very end, for me personally, success for this process is if we don't break anything that's already working. And if we do that, then I think we've won compared to where we were at the beginning of this process.
Could not have said it better myself on any of these fronts. Thank you so much to all of our panelists. Please join me in giving them a very large round of applause. And thank you all. Thanks again to IGF, and have a wonderful rest of the week.
I was like, oh, yeah, so many people here. Yeah, absolutely. And we were also talking, I had worked a lot with, before Marine had this one, it was Dave Heavey. And so we worked a lot with Dave, and Dave was a big supporter of Georgina, because they've been, so, but Brianna was, I think she was right after Dave. Yes. And where are you now? So I have my own firm, but I'm doing consulting. So I'm still supporting them. So. Oh, cool. But I haven't done as much on the cyber with them, mostly because I'm working on other policies. So we just completed a data protection policy. I'm based in the U.S. I'm always been based in the U.S. But there does a client I'm working quite a lot with in other countries. And, so I work with the project in Ghana, working at some other ones. So I work on a variety of different ones, but that's one of my clients. But I've been to many of your sessions when you were chairing that.
I mean,
that panel, that working group.
yes, 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 yes.
Because I don't think you're working, you're chairing that anymore, do you?
The cybercrime one.
Yeah.
No, not anymore. Because I did it for like such a, for a very long time. I thought like better.
Yeah, I don't think I have your
I'll
card.
give it to you.
Yeah, and then now, and you know, the secretary of the ICT, Stephen McIntyre, is chairing the working group on cultural tourism.
Yeah, 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 exactly, exactly. It kind of like, goes in circles, isn't it?
Right. Yeah, so he's doing that with, and she was just at the GFCE event in Fiji.
Yeah, yeah, yeah.
Everyone was at Fiji. Like,
Well, I know. I heard like a lot of people who kind of came straight from Fiji.
I know, that's what Chris Painter did. And
Yeah, well, that's what Chris Painter did.
And Sylvia Cadena.
Yeah, yeah.
A lot of people came.
Yeah, and a lot of people are going to Singapore after this, including myself.
Oh, for what's in Singapore?
So Singapore, there's the Singapore Cyber Week.
What?
Singapore Cyber Week. They do it every year, but we're doing our monthly. Yeah, we're gonna be there for the next.
Oh, sorry.
Yeah, we're still trying to get government to sign on to Budapest, but the problem is it's either justice or foreign affairs, and they have to run
Yeah, 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 yeah. And it gets stuck and
it gets stuck.
yeah, yeah.
But it was to happen more now.
Yeah.
It got pushed into the current assembly in this area.
Yeah. Right.
And that is the action.
Yeah, yeah, yeah. So, there's some hope there. We'll see.
You know, it's all for all countries.
Yeah, yeah, yeah.
Right now, the action
Yeah.
is going to be accepted by all countries.
Yeah,
So,
exactly. Exactly. Some movement there, some
there'll be
progress.
movement. It's always trying to push it. But, it's just, when it's
Everything takes time.
and when you're not, and when it's not in your control,
Yeah, absolutely.
it takes even more
Well, very
time.
nice to see
Nice
you.
to see you,
Judith.
Joyce.
Yeah, and I'm sure we'll be,
Yes.
we'll see each other now. I'm gonna go because I'm supposed to chair a session. Oh, here we go.
Yeah, I'm going to another session too. It's like,
Yeah,
I can
yeah,
only
too.
stay for a few minutes because I have to go.
Good, good.
But
We'll see you around.
Yeah, they're supposed to be sharing the screen, but I don't see it. There we go.
Okay. Good morning, everyone. May I please ask you to take your seats? We're about to begin. So good morning again. My name is Joyce Hackmey. I'm the Deputy Director of the International Security Program at Chatham House, and I have the pleasure of moderating this short but very important session looking at the Universal Declaration of Human Rights and mapping it to cyberspace. And this is the result of a report done by the American Bar Association's Internet Governance Task Force that is co-chaired by Michael Kelly, who's sitting on my left, and David Satola, who is joining us online. So Michael is professor of law at Creighton University in the US, where he specializes in public international law. And David is lead counsel for innovation and technology at the World Bank, where he specializes in connectivity and cybercrime prevention strategies. In addition to the two speakers who will be presenting the findings from their research, we also have a discussant with us today, Peggy Hicks, who is the director of the Office of the UN High Commissioner for Refugees. So, oh, sorry, what did they say? Human rights, okay, for refugees. So welcome to all of you. So we have half an hour together. So the way we will do this is we will hear first from Michael and David about the research, which has been just published in volume 26 of the University of Pennsylvania Journal of Law and Social Change. And then we will hear some reactions from Peggy and perhaps a question to the speakers, and then we'll end the session. So without further ado, I will now turn to Michael, and just a quick reminder that this session is being recorded and can be downloaded from the IGF website. So over to you, Mike.
Okay, thank you, Joyce. And if we could bring David Satola up online, he is also presenting with us. Christina, please advance the slide. We want to start with a New Yorker cartoon because they can mean anything. In 1993, you see the famous cartoon of the dog saying to the other dog on the internet, "Nobody knows you're a dog." That was 1993. Today, in 2023, this cartoon was updated. Remember when on the internet no one knew who you were? That's a paradigm shift. And we're going to talk about another paradigm shift in the field of digital human rights that's coming up with the advent of AI and the revolution that is on the fringe of happening. Christina, please advance. Why are we interested in which human rights are manifesting online? Well, because that's where we spend most of our time. This Pew Research Center poll from 2019 demonstrates that daily, over 80% of us are online almost all the time. This used to be a generational format, but as the generations go forward, we see that that is compressing at the far end. You can just look around the room and see who's on devices of one type or another. So you live your daily life in physical space, but you also live your daily life in digital space. And that's not always, or even mostly, work space. Human rights manifest in both sides of this equation. The question is, which ones follow us from physical space into digital space? How do they manifest? How are they regulated? How are they defined? And then, of course, the other end of that is how are they enforced? Christina, next slide, please. The Universal Declaration of Human Rights, as you all know, recently celebrated its 75th birthday, which is a huge passage to mark. It's made up of both freedoms and rights, and these come about in multiple contexts. Freedoms you're familiar with: speech, movement, assembly, religion, freedom from discrimination. Rights you're also familiar with: equality, privacy, security, work, liberty, democracy, education, property, fair trial, and nationality. But in digital space, these rights really are rendered meaningless or less useful if you don't have core rights that exist to actually animate them. And by core rights, we talk about connectivity and net neutrality. What good are digital human rights to you if you're not online? Not much. What good are digital human rights to you if you're not online meaningfully? And that, of course, is the net neutrality discussion. Again, not as much, and that certainly implicates the equality prong right out of the box. The other thing that we look at from a framework perspective is whether the normative equivalency paradigm is the right paradigm to think about the transference of human rights from physical space to digital space. The normative equivalency paradigm is basically moving the rights into a digital format without really altering them much. Other paradigms have been proposed out there. Probably the one that has gained the most attention is actually according human rights to digital entities themselves. But you get into all kinds of definitional issues in that regard, and I'm not sure that we're there yet. I don't know that we're going to be there soon, but it could be on the horizon. Nevertheless, we don't take a stand on this, which paradigm is the appropriate paradigm in our research, because our research basically creates a matrix. And so it is a mapping exercise that hopefully will be useful to policymakers, human rights advocates, and jurists as well. Christina, next slide, please. Exhibit A is the right to be forgotten. This, in our physical space, is the right to privacy. And it's confirmed by the European Court of Justice to exist in digital space, much, at least in 2015, to Google's consternation. This was a case that was brought by an individual in Spain who wanted some content delisted from search results about him because he had already served a criminal sentence for fraud. Spain, of course, has a very forward-looking social justice mechanism for rehabilitation, and people are supposed to get a fresh start after they emerge from the criminal system. But people kept looking up the one article about this individual that tainted his ability to do that. This was litigated all the way up to the European Court of Justice. The ECJ said, yes, Google, you are required to effectuate and moderate this human right on your platform and delist material that is irrelevant, no longer useful, or mistaken. Google's argument, of course, was, well, this is censorship, and shouldn't that be the job of a government, not a corporation? The ECJ confirmed, no, actually, Google, it's your job, because we're telling you it's your job. And so Google found itself not only in a moderation role, but an enforcement role throughout the EU or throughout the global Google reach was later litigation that I don't have time to go into today. But the internal corporate process that Google had to set up to actually have a company moderating human rights in digital space was one where they had to figure out what is the interplay between humans and algorithms. And we haven't even inserted AI into the process at this point. But review committees for each EU member state were set up. Now there are over 5 million web page delisting requests since the advent of this process. And the vast number of them implicate content on social media, specifically YouTube, Facebook, and Twitter. So now you're in a situation where you've got a company not only defining, moderating, and enforcing a digital human right on a space it owns in cyberspace, it's actually moderating other companies' content, right? Because when Google takes down a delists an item on Twitter, Twitter's affected. So now you've got cross-pollination happening. And is conversation happening across those platforms and across those corporations? Not at the level that it should be. So this raises obviously a larger question on the propriety of corporate enforcement, which of course is by terms of service. You agree when you read every line of those terms of service before you click accept, which I know everyone in this room does, that you will comply with what the corporation thinks about your content that you're uploading onto its platform. Christina, next slide, please. We selected here a half dozen articles from the UDHR. You can look at the University of Pennsylvania Journal of Law and Social Change article for the complete matrix of all 30 articles, just to give you a bit of a comparative perspective. Article 1, freedom and equality, manifests usually as connectivity and net neutrality. Codification is in progress in some states, not in others. In the United States, you see this going back and forth in a bit of a ping pong ball fashion between administrations. The Obama administration moved forward on this. The Trump administration moved backward on net neutrality. The Biden administration is now moving forward again, not unlike some other areas of law. Article 12, which I just covered, the right to privacy, manifests as the right to be forgotten. It's codified as an EU regulation. EU member states enforce it per the European Court of Justice, but Google is the actual arm. It's under court order, though, to do so. So there's an interplay between the state and the company. Freedom of movement we'll come back to. There's an asterisk there. Article 17, the right to property digitally manifests as property in lots of different ways online. If it happens to be intellectual property, well, there's a treaty framework for that through TRIPS. And so this is regulated by states and enforced by states. But if you look at speech and assembly, Articles 19 and 20, with speech, it's access to social media platforms. And the regulation is via the tech corps and your terms of service. And it matters whether or not it's a public corporation or a private corporation. If it's a public corporation, there's likely to be a process. If it's a private corporation, well, Elon Musk decides whether or not you get your speech rights on his platform. With Assembly, it's access to groups, again, via terms of service. The reason we marked Article 13, and there are a couple of other articles, is that there are no positive regulations in this area yet. There's no positive digital manifestation of this as a right or a freedom yet, frankly, because it's assumed you have freedom of movement across the internet. Well, that assumption is incorrect, and what it does is it leaves a gap. My British colleagues are familiar with the term mind the gap. Yeah, mind the gap, because in the absence of this, that leaves room for negative regulation. And authoritarian regimes can wall you off from certain areas of the internet and restrict your freedom of movement in digital space. So we have to look at these gaps as well as where regulations are positively manifesting. Next slide, please, Christina. Okay, here are your corporate protectors of internet human rights. And I'm just going to kind of pause this here for a minute for you to take a look at these guys. Google, of course, we saw resisted its role as an enforcer and definer of digital human rights, but it is doing so, and I think it's doing so effectively under court order. But I think, you know, the Microsoft approach, where the company actually embraces something about human rights. You all remember a few years ago Brad Smith calling for a digital Geneva Convention. That voluntary embrace of their new role, policing cyberspace, I think is where we need to go if we're going to get effectively at the 20 to 25% of human rights listed in the UDHR that have corporate fingerprints on it. Next slide, please. Maybe we trust those guys more than we trust this guy. The broader context, if we back up a few paces and we look at the back and forth between multi-stakeholderism versus multilateralism as the effective paradigm for internet governance, and we're all here in a multi-stakeholder environment. Authoritarian regimes want that replaced with the multilateral approach, where only states are sitting at the table, not companies, not civil society. I'm civil society. I'm with the American Bar Association. Although I don't represent their views at this conference, I would not have a seat at this table if the authoritarian multilateralists had their way. Why should big tech care? Because they will lose their seat at the table. The conversion of them from objects to subjects of international cyber law will have a profound impact on them and on their bottom line. Russia's draft cybercrime treaty, which some of you were in the room prior to this, listened to for an hour and a half, when it was first introduced, was criticized as the beginning of the end for multi-stakeholderism. It wasn't really so much about cybercrime as about possibly repressing human rights. Whether it undermines the Budapest Convention and whether or not it could suppress digital human rights, the valiant people working on this through the UN process are discussing in New York City and Vienna every few months. And although the prior panel struck an optimistic note on that, I'm not sure I completely share it. And so this opens up all kinds of other issues, the broader issues. And that's why now is the time to crystallize what these digital human rights are, and secondly, what big tech's role is in defining, regulating, and enforcing them ahead of the coming AI revolution, because that will change everything. There will be a paradigm shift when AI actually matures to the point that creativity-based AI platform regulation replaces logic-based algorithmic platform regulation. Let me say that again. When creativity-based AI platform regulation replaces logic-based algorithmic platform regulation, that's the sea change. And we have to get ahead of that. We have to get ahead of that for defining digital human rights, and we have to get ahead of that for defining the roles of companies in this process and convince them that it's in their interest to do so. Just as an example, a policing example, AI will be a more effective cop for companies policing their platform because it's much more difficult to get around. You can get around a logic-based algorithm. But the bad side of that, if you just flip it around, is it also can be a more effective tool for authoritarian regimes to repress your digital human rights. Just like everything else, this is a double-edged sword. And I should pause and let David chime in, Joyce, I think, if there's, yeah.
Thank you, Mike. Thank you, Joyce, and thank you, Peggy. I think in the interest of time, we should probably move ahead to the commentary and hopefully leave some time for questions at the end. The only remark I would underscore that Mike already made is the kind of multi-stakeholderization of the enforcement of human rights that we've seen. And it's on our slide 7, where we see that actually the human rights are being examined and enforced by private actors. And this was something that I don't think anyone anticipated back when the Internet Governance Forum started. So with that, I'll turn it back to you in Kyoto. Thank you.
Thank you very much, David and Michael. And now we turn to you, Peggy. Since I messed up your introduction, why don't you introduce yourself and share your views on what's been said? Thank you.
No problem. Thanks so much. Yes, I'm Peggy Hicks. I work at the UN Human Rights Office in Geneva, where we're focusing on many of these issues, and very grateful to Michael and David for taking this look at digitization of human rights in their scholarly work. It's a theme that we talk about quite a bit in Geneva. And it's been many years now since the Human Rights Council first said that the human rights that apply offline apply online. But what that means in practice, of course, has yet to be worked out. And it's really interesting to look at this mapping approach that goes through the different articles and really looks at, what are some manifestations of how that is developed in real terms. Now, part of the reason we talk about the human rights framework as being so relevant in the digital space, I want to emphasize, and that's because you focus, Michael, on the battles between a multi-stakeholder and multilateral approach. I mean, part of what we think is crucial about the framework of human rights is its universality and the fact that it involves legally binding obligations that the vast majority of states have ascribed to already. And so we avoid using it at our peril. It's part of what can help us work through some of these challenges that are presented by the analysis that we've heard. And it also already includes accountability mechanisms. And one piece of it I really want to emphasize, which I think is quite relevant to the research here, is, for example, frameworks like the UN Guiding Principles on Human Rights, which really link up the company responsibilities to the legal obligations that states have. So under the guiding principles, you have 3 pillars. One looks at how states have a responsibility to regulate how companies impact on human rights in their actions. And then, of course, it has the chapter that's best known goes through what do companies need to do to better respect human rights, including understanding and mitigating risks that are within their supply chains in different ways. And then the 3rd pillar relates to accountability and remedy on those sides. And one of the things we've been really working on within our office is there's been a lot of work done on how those principles apply in industries like extractive industries or the apparel industry, but what does it mean in the context of the digital space, software applications that are mass marketed and used, by millions of people globally. What does a tech company have to do with how that software might be misused at some point in time? So we've been working with a community of practice of a number of the largest tech companies to really work through some of those issues and figure out how we can better have them take on some of these responsibilities that are outlined in this report more effectively. But I think it also goes to this tension that the mapping shows of, how much responsibility do we want at the corporate level, and what do we want states to do to better tell companies how they ought to handle things. So a good example is the terms of service that you referred to. It is the case that companies set those terms of service, but there are things that they are legally required to do within them in terms of unlawful content that might be on their platforms. So, how far do we take those relationships, and what are we looking for from governments in terms of content regulation, I think is a big question. Before I close, I have to say that one of our big concerns is that governments go too far in that regard. And that's what we've seen playing out. When we look at content moderation related legislation globally, the vast majority of legislation that's been adopted across the globe tends to overreach and do more to undermine human rights than to protect them. So it allows and almost pushes companies to take down too much speech because they want to repress opposition or dissent or free speech in various ways. So we have to be very careful about what we ask governments to do and what we're expecting of companies. But in both places, we have a lot of work to do to make sure that that digitization process goes forward as we'd like to see. And I agree, the Cybercrime Convention is an interesting area in which some of these issues are playing out. We see some of the potential overbreadth in some of the work that's being done under the Cybercrime Convention is similar to what we've seen in other efforts to legislate online speech in areas like counterterrorism efforts, where sometimes those statutes as well are used in an overbroad way to repress rights. So those are just some initial comments, and thanks again for the efforts.
Thank you very much. We have 5 minutes, maybe a little bit more, to kind of have maybe a quick
Sure.
discussion. But maybe sort of like a follow-up question to you, Peggy, and maybe Mike, if you want to respond, and David as well. You talked a lot about, first of all, you sort of both outlined the complexity of this issue and the kind of the very big importance of getting the balance right, and in terms of who should the onus fall on, and how do you kind of get to a place where the responsibilities are clear. And in the context of what you described, you talked about some of the practices that some autocratic countries are following in terms of suppressing dissent and not respecting human rights. But we also see some regulatory approaches and initiatives coming out of liberal democracies suggesting some human rights concerning sort of approaches, from breaking encryption for obviously legitimate purposes and so forth. So how concerned are you about that, and how responsive do you find these countries to the concerns that you raise with them, whether in a kind of national context or more globally?
I think it's a really good question, and one that we're, not only our organization, but I think many of the civil society organizations that are here today are really looking at that. I think part of what tends to happen is that governments naturally and understandably, rightfully, want to adopt legislation that works in their context. But the reality is that those models are then exported globally in contexts that can be very different, where there is not the same infrastructure to support and ensure that those laws are interpreted and used in a human rights respecting way. The example that's always given is the German NetzDG statute, which was replicated in a variety of ways in a variety of places. But we worry about that now, and the point that you made on legislation that will potentially allow for client-side scanning, for example, which we see as incredibly problematic given the importance of end-to-end encryption, is a really good example where we understand the concerns that are leading to that type of legislation, but feel very strongly that adoption of measures in that direction could have really deleterious impacts globally, and could lead to a much broader problem with the limitations or undermining of encryption.
Thank you. And Mike, if you can answer this question
Yeah.
while also addressing what could be done in order to sort of understand and avoid those unintended consequences.
Right. Well, at base, and this, of course, is hand in glove with the policy approach from the United Nations. By virtue of the fact that you're a Homo sapiens, you get the same bag of rights. Doesn't matter what your race is, your gender, your religion, or whatever. And everyone is theoretically bound by that in physical space. Now we know that's not always true, and that always doesn't play out. But what about in digital space? Does everyone get the same bag of rights by virtue of the fact that you're a digital Homo sapiens? Well, what is a digital Homo sapiens? Is your avatar, Peggy, going to get the same rights that you do, or Joyce? Or does your Facebook account go on after you die, and does it continue to have the rights that you enjoyed while you were alive? We're in a new frontier here, and it is a huge balancing question, but it also is a definitional question. Where are we? And that's why the definitions need to be nailed down before the AI revolution comes, and it's coming very quickly. So there's a temporal component to this that we really have to be mindful of.
Thank you. David, are you still online?
Yes, I am. If I could just add one very quick comment, and it hopefully relates back to something that Peggy mentioned about the universality of rights. And I think one of the things that intrigued Mike and I when we went into this research was, does the migration of our daily lives into cyberspace in any way challenge that very, very basic concept of the universality of rights? And while we recognize that context matters, and again, to Peggy's point about, the Brussels effect and other national or regional laws that have been exported and incorporated out of context, does that also pose a threat to the universality of rights online? And so we don't have the answer to those questions, but I think they're worth thinking about. Thank you.
Thank you, David. And maybe one final question to you, Peggy. You mentioned the Cybercrime Convention, and the OHCHR has been quite active on that front, publishing sort of commentary and making some observations on the content and how the convention is proceeding. Can you share with us sort of your latest view on where the process is? I don't know if you yourself cover that specifically or not, but maybe sort of share with us what you think about where we are at the moment and what sort of, where do you think we might be heading?
Thanks. It's a good question, but I smiled only because I don't think it's a 1-minute question. It's a bit more complex than that. We do still have some issues. We've been raising consistently some concerns over how the convention might have the same sort of overbreadth problem. The fact that the types of offenses that are included are those that are punishable by 3 to 4 years, for us, for example, is something that raises questions, because we see people being, put in prison for a single tweet for 3 to 4 years. So, I think there are some concerns that are still there in terms of criminalization and in terms of the breadth of investigative powers and the effective safeguards that need to be there. But of course, as has been said, the process is still ongoing, and there'll be lots of opportunity for those who share with us those concerns, including a number of states, to put them on the table. And hopefully the negotiation process will continue in a way that moves the convention in the right direction.
Brilliant, thank you. And I guess maybe the silver lining from all of that is that the process has raised awareness about the complexity of the issues and the kind of, the potential sort of for abuse when it comes to not just the procedural powers, but also like a very broad scope of criminalization. So I think with that, we will end the session. It was a short session, but very important. Thank you, Michael, David, and Peggy for joining us today. And thank you for everyone who attended. And yeah, we'll see you later.
Thank you.
Single
I'm fine, thank you. Yeah, you.
What time is it? Okay, okay. Hello, testing, translation, 1, 2, 3. What do you want me to say? Children's rights. Overcoming regional inequalities. Testing. Hello. Testing. Is it good? Okay. More? Okay, we're about to start our workshop. We're testing. Testing the translation. Hello, good morning, good afternoon. Is it go? Okay. Deu?
Tava tocado?
Deu, né? Okay. So, hello all, good morning, good afternoon, or good evening. Please be welcome. We are starting the workshop Children's Digital Rights, Overcoming Regional Inequalities. For those who are following us online, there's the possibility of simultaneous translation within the transmission channel, okay? So I'm Maria, representing Alana Institute, an NGO from Brazil which aims to honor children on and offline, and it's a pleasure to be here. Moderating this panel with me is Manu Halford, who's keeping up with the discussion online as well. And acting as a reporter online, we have Thais Rugulo, also from Alana Institute, whom I would like to thank a lot in advance for her work contributing on a very critical thinking for this panel organization. So to warm up the discussion we're proposing now, I bring some context elements from Brazil. We had a very hard year in Brazil. The effects of the digital world impacted directly on the life and security of Brazilian children and teachers in schools. Attacks were organized in digital platforms against children. Adolescents were recruited and local socio-economic vulnerabilities were exploited to cause hate and violence. Today, we had one new attack at the school in Brazil, for which we are very sorry and mourned. Misinformation invaded the online debate and made families and children extremely anxious about their own safety. This chain effect was expanded because of the business model and design of digital platforms' privilege, and even profit from violence controversy. The proliferation of betting models that promise social ascension through the exploitation of money. The dissemination and dependency of mostly northern edtech models that consume and share Global South children personal and collective data for commercial exploitation and lack transparency. Those are all complex social issues being faced right now. We, as the global majority, have our own complex problems that come from an historical socio-economic context, and because of that, legislation, implementation, and public policies for child rights need to address context and specific social issues. Because of the special vulnerability of children, the digital environment can present both opportunities and risks for them, as we know. In this regard, national and international efforts have been mobilized to promote a safe and rights-enhancing digital environment, the most important being the General Comment number 25 from the Committee of the Rights of the Child. Nevertheless, the lack of national regulations governing the online environment makes children's digital experiences highly vulnerable to social, cultural, and economic contexts, particularly with a prevalence of discriminatory processes that disproportionately affect countries in the Global South. In Brazil, civil society is working hard now to approve a regulation inspired by DSA, which brings rules for the protection of children on platforms, starting from the demand for transparency and accountability. So this session aims to discuss paths to a safer digital environment for children, regardless of their location. To achieve this, recently approved policies and their potential for global impact will be analyzed alongside the remaining obstacles that need to be addressed for effective regulation, especially in countries of the Global South, taking into account especially the application of General Comment number 25 in Latin America. Now, I'd like to present two quick videos where children from Brazil contribute with their perspective on issues that they face online and opportunities as well on the internet. Please, Manu. Oh, someone else. No sound? You're facing sound trouble, sound issues, but... Yeah, just a second, sound issues. Yes, I think we may go strictly to our debate and then we try again to run the videos. Is it okay? Do you want to try once more? No. No, no, no. Oh. So sorry.
Você achava sua infância legal?
Incrível.
Porque você vivia antes da internet. Aí você achava muito mais legal.
O Metas falou com crianças de todo o Brasil para saber como elas imaginam o mundo antes da internet.
Um sem internet, né? Quase ninguém ia saber de nada. Não, imagina, coitado das pessoas, né? Sim, às vezes eu penso e falo pra mamãe, nossa, como vocês conseguiam, quando vocês estavam com febre, o que vocês faziam? Muito ruim, ninguém podia jogar nada, não podia assistir vídeos.
Legal e sem graça ao mesmo tempo. Porque antes da internet, todo mundo olhava no olho, as crianças não ficavam assistindo por tanto tempo no celular, brincavam.
Bem, era um pouquinho melhor, porque as pessoas não tinham que se preocupar com a sua imagem social, né?
As crianças brincavam mais, em vez de ficar assistindo desenho, jogando jogo no celular, tablet. Os adolescentes não ficavam toda hora mexendo no celular. Porque a internet, depois que lançou, ficou na cabeça de todas as crianças e ficou o vício maratônico. Um vício, assim, do tamanho de dois mundos se juntando. Elas brincavam de coisas que dava pra brincar, tipo peão, esconde-esconde, pega-pega. Porque na época era pra brincar na rua, não tinha problema, violência, hoje em dia tem.
Eu acho que antes da internet as pessoas prestavam mais atenção no mundo em si.
As pessoas iam na casa das outras, não precisavam falar por chat. E também, né, as pessoas não precisavam ficar naquele vício de comprar o celular novo que lançou.
Como seria se não existisse mais internet no mundo?
Horrível, difícil, impossível. Assim, o mundo, claro, não ia acabar, mas eu ia ficar meio preocupada, eu ia.
Nossa, só de falar já me deu uma tristeza.
Eu iria desmaiar.
Eu simplesmente ia começar, cadê a internet? Onde ela foi?
Não iria nem pensar na vida. Não vai ter nada pra fazer, aí vai ter que ficar quieto em casa.
Eu ia ficar no quarto sem comer, sem fazer nada, 5 dias. E aí depois desses 5 dias eu teria que superar.
Ai, eu ia ficar bem chateada.
Construía robôs e mandava usar os robôs para construir internet.
Eu acho que sair mais, ficar ao ar livre, andar de bicicleta, andar de patins, skate, essas coisas.
Eu ia ficar só no leve o dia inteiro. Se eu parar pra usar um pouquinho no banheiro, eu vou fazer um pouquinho.
Se a internet fosse um brinquedo, que brinquedo seria?
Seria um ursinho com uma tela na barriga do ursinho.
Mas tipo um robô assim, que você pergunta um negócio pra ele. Ah, o que tá acontecendo, ou sei lá, o que é isso? Daí ele te responde assim, blá blá blá, tipo um Wikipedia.
Provavelmente seria um boneco, só que não um boneco básico, entendeu? Que ele andava sozinho, que ele tomava água sozinho, que te dava o que você pedisse.
Eu acho que seria aqueles telefones que a gente ganha quando tem 4, 5 anos, que você faz e digita números qualquer e aí toca uma musiquinha.
Acho que a internet seria um brinquedo bem grande, assim. Um brinquedo que desse para todas as pessoas brincarem.
Um carrossel, porque um carrossel roda e a internet também roda para todos os lugares do mundo.
We have one more. Is it possible? Is there another one? Ah, thank you. There is one more? One more video.
Eu acho que tem duende no meu celular escutando minhas conversas e me mandando anúncios de coisas que eu nem preciso.
E foi assim que o cartão de crédito estourou esse mês.
Eu desconfiaria de algum hacker. Os hackers, eles acabam sabendo da sua vida. Duendes eu sei que não, né? Mas eu sei que tem pessoas que vê todos os nossos dados, que eles ficam guardados.
Cara, tenho 30 anos e vejo coisas na internet que realmente me fazem muito mal.
Fico quieto para não me acharem um velho chato.
Mas sempre vejo coisas que eu sei que são ruins e parecem maldade. Tem alguns vídeos que magoam. Racismo, né? Já devia ter acabado.
Nesses dias eu vi um vídeo, né, da mulher, ela oferecia um presente surpresa ou dinheiro, né? Aí quando eles iam abrir, era uma banana ou um macaco. Ah, eu acho que foi uma maldade, né? Também ela só fazia com crianças e com pessoas negras.
Vi um vídeo no TikTok me prometendo uma carreira de modelo.
Eu estava acreditando, até minha família também.
Mas o perfil começou a pedir Pix. E mais Pix.
Era golpe.
Quase acreditei também.
A minha tia, ela deu lá na tela dela, clique aqui para retirar seu dinheiro. Aí ela clicou e deu vírus no celular dela.
Comecei a acreditar nessa história de aposta online. Perdi todo o meu dinheiro.
Não pago mais IPVA. Perdi o carro também.
É isso, a casa sempre ganha.
Não dá para acreditar que tem gente divulgando isso livremente. Coisa de doido aí, que o cara foi apostar, perdeu tudo.
Teve uma vez que eu instalei um jogo que influenciadores estavam postando muito, que estava ganhando dinheiro, só deu errado e eu tive que trocar de celular.
Com esse dinheiro que eles ganham, é todo o dinheiro que os pobres vão perdendo ao longo das apostas, né? O pessoal pode até trapaçar e você não sabe.
Okay, that's it. Thank you. These videos were produced by Alana and Lunetas, a journalistic portal focused on childhood and are part of our advocacy efforts to put kids first on the online debate. So to kick things off, I'll give the floor to Mrs. Mikiko Tani, who is a member and immediate past chair of the UN Committee on the Rights of the Child. She's an international human rights lawyer and a practicing lawyer of family law in Japan for over 30 years, with a focus on women's and children's rights. She has published and taught extensively in the area of international human rights and on issues impacting children. So Mikiko, thanks so much for being here today. Could you please start by telling us how you see the importance of the adoption of General Comment number 25 for the committee, and how was the work of its adoption? Thus, how do you see the right to non-discrimination in relation to the digital environment? Please, you have the floor. Thank you again.
Thank you very much for the introduction and also having me on this panel. So for those who don't know much about the Committee on the Rights of the Child, let me begin by sharing with you a little bit about the committee. So you may know the UN Convention on the Rights of the Child that was adopted by the UN General Assembly in 1989. And the convention established the Committee on the Rights of the Child to monitor the implementation of the convention by the state parties, those countries who ratified the convention, which is now in 196, so almost universal ratification. And the committee is composed of 18 individual experts like me, and we review the country reports periodically. And however, the country report and reviews and the recommendation after the review is country specific. So from time to time, the committee also adopts the documents which are called general comments, focusing on particular rights or the issues which are relevant to the children's rights under the conventions. So in 2019, the committee decided to draft a new general comment on children's rights in relation to the digital environment and adopted it in February 2021. And I was one of the members of the committee's working group on General Comment 25, who drafted this new General Comment. So the committee's decision to choose this topic was because of its recognition of importance of providing guidance on how the child rights under the convention should be promoted and protected. What are the obligations of states and responsibilities of business sector? How children should be empowered and supported. How parents should be also supported. So in 2019, we already saw the digital were immersed in children's daily lives. And we thought that because, as I said, that the convention was adopted in 1989, so we need to show how the convention applies to the now children's lives. Because children live in online and offline, seamlessly. But when the General Comment 20 was adopted in February 2021, we realized that its importance was much more than we originally thought. You may understand several reasons. First of all, it was because of the impact of COVID-19. We witnessed the increasing impact of online on children's lives in both ways, positive and negative. Positive, of course, for example, the continuation of education by remote learning. Negative, of course, we all know, longer time exposure to online. And so the longer time on online for children also means that more exposure to online bullying, online sexual exploitation, exposure to harmful content on online, and also impact on health. And also, we witnessed that existing discrimination was expanded because of the more use of online. Post-COVID-19, digitalization continues. So when the children don't have the access to digital, which means that children are excluded from certain services, for example. Also, we recognize that humanitarian situation, emergency situations, due to the disasters and the conflict, many more children continue on move or are displaced internally and cross borders. Living in refugee camps and other countries, need for the children to access education, health services, information, identity documents, etc. is significant, and the digital plays a critical role. So this is about the importance of the General Comment, and we are very happy that the committee adopted GC25 in 2021. But I'd like to highlight the issues related to the topic of this workshop today, regional inequalities that were experienced by ourselves, I mean by committee members in the drafting process. Because I said committee decided to draft this new General Comment in 2019, and generally we put 2 years in drafting process. So the second year of our drafting process was affected by COVID-19. So the committee couldn't meet in Geneva in person, so we continued our work online. And this was a very useful experience in my view, because we really realized by our own experience that there are other challenges some committee members were faced, such as the difficulties or high cost in accessing internet or even electricity. Lack of interpretation, which was not provided online, time zone issues. Some members in some regions, particularly in the global south, were more affected because of the access issue, connectivity issue, high cost issue, and time zone, and language, I would like to add. So coming back to the General Comment 25, the right to non-discrimination of the child is recognized as one of the general principles of the Convention on the Rights of the Child. So naturally and unsurprisingly, the GC25 recognizes digital exclusion as discrimination against children, but identifies other issues beyond just a simple access. The committee states that, I quote, "The right to non-discrimination requires that state parties ensure that all children have equal and effective access to the digital environment in ways that are meaningful for them. So states should provide free and safe access for children in dedicated public locations and invest in policies and programs that support all children's affordable access to and knowledgeable use of digital technologies." So it's not just access, digital literacy and education are also very critical. But next point, what is further important in my view is that committee said, children may be discriminated against by their being excluded from using digital technologies and services by receiving hateful communications or unfair treatment through the use of those technologies. Other forms of discrimination can arise when automated processes that result in information filtering, profiling, or decision-making are based on biased, partial, or unfair obtained data concerning a child. So because of the time constraint, I will jump to the topic of this workshop, regional inequalities and how to overcome these challenges, which were not really addressed in the GC25. So what I'm going to say is just my personal reflection, not on behalf of the committee, I have to say. Okay, so 3 points. First, who are accountable for those regional inequalities? Who has responsibilities? I believe that global policy integrating regional inputs is necessary. As I said, the committee reviews country report and make country-specific recommendation to each country. The committee cannot address the whole issues such as regional inequalities. I believe international cooperation in providing financial technical resources and support for capacity building, multilateral, multi-sectoral approaches are needed. And so the SDGs process, World Summit on the Information Society, Internet Governance Forum like this, and Global Digital Compact are very, very important global policy space. Secondly, participation of stakeholders whose rights are affected, in particular in the Global South, is critical. So how we can ensure child participation from the Global South when the global policy is discussed? Cost, access, language, information, a gap, all these need to be addressed to ensure meaningful participation of the children and young people from Global South. Finally, child rights impact assessment. This is, I believe, the area that business can play more role. When the business do child rights impact assessment, it has to include extraterritorial impact of the business models and practices affecting the children outside the territory. And also transparency. When the business discloses information, it has to be in a language which can be understood by the children in various parts of the world. So that's my contribution to this workshop. Thank you very much.
Amazing. Thank you so much, Mikiko. Thank you so much for your words and your work. General Comment 25 is really central for us to move forward. I'll quickly give the floor to Lily Edina, who's a PhD student in information technology and a contributor to technology communities and speaks widely on issues related to internet with a particular interest in women and youth inclusion. From Ghana, okay. Thanks for being here, Lily. And my question to you is, what are the specific challenges and risks that children and youth from Ghana face nowadays on the internet today? Or nowadays and today. And what kind of international collaborations can be mobilized to promote children's rights to non-discrimination when using digital products and services, while still keeping contextualized and local protagonism? This is so important. Thank you, Lily. The floor is yours.
Thank you, and good morning, good afternoon, good evening to all those who are also joined us online. So my name is Lily Edina Mbochwe. I'm from Ghana, and I'm also now I live in the US pursuing a PhD in IT with a focus on privacy. As you shared, the work in the past has been pretty much along the lines of inclusion for youth. And when we say youth, in the past, it has bordered along the lines of people who are young professionals or people who are probably just past the teenage age. But when we talk about child protection and child rights online, then the issue of involving children who are lesser than the teenage age comes into play. So I'm going to be sharing what are the things that we've seen in the context of Ghana when it comes to child rights online and the things that are hurdle and how we can together rally support through international corporations and partnership to make some of these things, to overcome some of these things so that children are protected online. Now, the issue of child rights online in Ghana is a mixed one, stemming from the fact that there has currently been an active increase talking about awareness creation to ensure that people know what it is that's an issue, and especially for what we call the group of people that we call technology caregivers. So if you've ever had a child come to you and ask you how to probably put on their phones or how to access a game or how to access a software, you are a technology caregiver. If you guide your parent or an educator that guides children how to use some of these things, you are a technology caregiver. What we've seen currently is that there are issues around digital literacy, as was mentioned. And in Ghana, one of the biggest one is also just people learning the whys behind what the things that are online. How did they maximize the use? So for instance, if you were on Facebook, that is a good place for you to connect. But do you know if your data, your privacy is being breached as a tech caregiver, so that you can also guide a child to be able to probably be online properly? Now, what we see is the illiteracy that comes from, and I put illiteracy in code because there is the enlightenment, but not really the understanding that we see with people who are users, especially with the children. So the first specific issue that I'm bringing up is the issue around the digital literacy, and this also would be side by side what you know as access. So even though people are connected online, there is that huge gap still standing, and it's not everyone that is connected. So with a few people who are online, you also want to see how they're using the online spaces correctly in such a way that their rights are not also trampled upon even in the online scenes or the platforms they're on. Now, another one would be the issue of cyberbullying. For instance, people are online. I mean, they know that they're able to, for example, children would probably be doing competitions online with their friends. They can do TikTok challenges, and somebody says some things that probably would hurt them. It internalizes, and they brood over them too much, and probably would think about self-harming. There is that issue also of exploitation, because a child posts something, somebody says, hey, I have this for you. Are you able to meet me here for this and this and that? For somebody who hasn't been taught how to properly handle some of these things and sift through, who knows, there may be a next target, and the result or the end of that simple, hey, I've got this for you, would be probably, it will be one that is huge, and parents wouldn't be able to handle it, even can the child also. And I think that we see, though, is also just around, I mentioned exploitation, the cyberbullying, and there's also where there's the content abuse. Sometimes it stems from just understanding of the content, and children are caught up sometimes, and they probably wouldn't be able to backtrack and see how far they've gone with something that probably was misinformation or disinformation, and they're caught up. And online, they get all the bashes again, and they get all the, there's a bullying that comes out again, and then it just goes back to where they feel like they don't deserve to be on those spaces, and nobody is there to protect them. Now, these are some of the things that we see, but there's also, like for the tech caregivers that I mentioned, parents who are sometimes even helpless, educators who are helpless. And that's where we have the awareness creation and education that should be wide, cut across. Someone said that people who are supporting children know enough to be able to help them, and children are also taught in a way that they also can consume content and understand with actionable steps for them to get around some of the things that they encounter online. I know for a fact that my niece, who is 12 years, because she knows that I'm in IT, she thinks I have all the answers. Thankfully, I know some. Her mother also knows some. But the thing is, there is that constant, what should I do? and there's that problem. If there was a place where they can get resources to learn, who knows, it will be helpful. Now, looking at this in the context of Ghana, there is also the Ghanaian government stepping in right now to try to do things around just child protection. So there is the National Child Online Protection Strategy that was launched, I think, the year, I don't have it right in my mind, but that's just a way to rally some support to say, we know there are harms online, there's a strategy we are looking at. Now, the implementation is a place where it gets a bit shaky. There's also the ratification by the Ghanaian government for the AU Convention on Protection and Welfare for Children Online. Helpful, but again, there's the implementation aspect. Now, we come to the part where there's legislation existing for areas of child pornography in Ghana, but it's not in its entirety covering everything that children can be exposed to on the online spaces. So for international communities and what they can do to support the Ghanaian context, it will be that support to enact laws that are all-encompassing to a large extent, covers different scenarios, different contexts, not only what you know right now as child pornography. There's also the need for, or if there's a support that can be gotten from international organizations to help local organizations. I know one of them that does amazing work is a child online protection, I think, program or something. There's a name for it. It's led by somebody called Awo Aidam. She's very vocal on why children should be protected and rights that should be upheld online, but they can make use of things like support, technical assistance, financial aid to push further the work that they do. There's also, for international support, there can be one around just getting more contextualized let's say, legislation and helping the Ghanaian community to contextualize some of the things that are in the international jurisdiction for the country. That's because there are different scenarios for pretty much every place, and what may work in Ghana or probably in Brazil, we probably would need to be tweaked in a way to fit the Ghanaian context. So all these are ways that we can essentially have support from the international bodies and still push what is local and help people to understand the things as it affects us the most as Ghanaians. So I'll stop here and probably would continue when we ask some more questions. Thank you.
Thanks so much, Lily. Inspiring reflections based on your experience and the efforts being made in Ghana. Thank you so much. So now to bring us comments on the regulatory differences between the global north and south and the protection of children online, we'll listen to Sonia Livingston. She's a full professor in the Department of Media and Communications, London School of Economics and Political Science. She has published 20 books on media audiences, children and young people's risks and opportunities, media literacy and rights in the digital environment. She directs the Digital Futures for Children and Global Kids Online with UNICEF. Unfortunately, due to time zone differences, it's 3 a.m. in UK now, Professor Sonia won't be able to join us live, but she recorded very kindly her participation. Please, let's see it.
Hello, my name is Sonia Livingstone. I'm a professor in the Department of Media and Communications at the London School of Economics and Political Science, and I'm sorry that I can't be with you in person today for this really fascinating conversation. Much of my time as an academic and researcher these days is concerned with children's rights in the digital age, and I thought I would begin by saying something about the key findings from my research in mapping the risks and opportunities for children online. And I do this work as part of a large-scale research networks in both Europe, originally funded by the European Commission, and also internationally as part of the Global Kids Online project together with UNICEF Office of Research. So I'll say a little about the findings and then something about the implications for regulation and whether there's anything from the global north that could be learned in the global south. So for the findings, I would say in both Europe, but also internationally, and we work through Global Kids Online increasingly in the global south and across all continents. It's always hard to summarize findings from so many researchers and so many children over time, but crucially, the world is full of divisions and inequalities. And what we see over and again is how those inequalities perpetuate from offline to online settings. And so it is really vital to begin as a researcher, but also as a practitioner and policymaker, with a recognition of the incredible variability and inequality that divides and differentiates among children, both within countries and between countries. As countries around the world gradually gain more internet access, there are all kinds of debates about how children should be provided with this access. I think it is now taken that it is part of children's rights. It's certainly a really crucial means by which children access their rights. What research shows is a challenge for policymakers, because it shows that as children gain more access to the internet, they both encounter more risks and more opportunities. The two go together, and the really challenging question is whether we can allow and find ways for internet access to maximize the opportunities that children encounter while also mitigating the risks, because without those kind of efforts at mediation and management, children will gain opportunities, but also risks. I find when taking research into policy and practical contexts, it isn't always clear what are the anticipated, desired, or actual outcomes of interest. A crucial one that we see as the research community is that children's encounters with risks may or may not result in actual harm, and that what matters is all the protective and vulnerability factors that make up their lives. And in fact, I could say the same for opportunity. You can provide children with digital opportunities, but that doesn't always translate into benefit, because again, the protective and vulnerability factors serve to undermine some of the opportunities to benefit and cause a range of challenges. So generally, what I could see from the research world is the importance of having up-to-date and disaggregated evidence that really reflects the diversity and complexity of the conditions in which children live and the different circumstances that define their lives. In many contexts, researchers are doing their best to use this evidence to overcome moral panics and media panics, to ensure that policy interventions are really carefully targeted according to need. And evidence is also very valuable to evaluate which interventions or which programs and policies work and which ones don't, so that we can really begin to build on past experience, successful as well as the failures, and ensure that policy and practice improves. In the Global Kids Online project, we're really committed to the idea of comparative evidence, that we have the same measures used in different countries and contexts, so that we can really set a kind of baseline against which different national and regional interventions can mark their progress. And so I'd refer you to the Global Kids Online Toolkit, which has worked very hard with partners in many countries to try to develop measures that are really effective and that speak to policymakers in those different countries. I was asked in preparing this session to say a little about some of those policy frameworks that we have been taking our research to. And here my experience is more European, and the question is whether that has some value for policymakers in the global south. Clearly, we have an emerging European model. It has its own history and its own kind of cultural shaping, and I think it's a question for debate, and I'm really glad we're debating it in this session, to determine in what ways others could learn from the European model, and in what ways that might be inappropriate and a different model is needed. I think really strongly shaping the European model has been for a while now, the emphasis on data protection through the General Data Protection Regulation. And if I was asked one thing that I would recommend, I would say that now that the internet runs on data, increasingly driven by data, ensuring effective data protection in any country might make the biggest difference to the realization of children's rights as well as everyone else's rights in that country. And I could point here to the spread of what are being called age-appropriate design codes internationally, regulatory formats which seek to protect and empower children in different digital contexts, but focused on data protection and the children's data subject rights, rather than, let's say, on content regulation, which often seems like censorship and can lead to problems precisely for that reason. So I think there are interesting questions for any country about whether the regulation of data can curb some of the commercial exploitation and algorithmic excesses of the attention economy and find ways to harness children's best interests in a rights framework also to their data subject rights. I don't think that's the only interesting thing about the European model, and perhaps one other point I could mention here is the recent Digital Services Act, which seeks a risk assessment, a risk-assessed mechanism for thinking about the protection of consumers. I'm sure there's a lot of discussion of the Digital Services Act in this Internet Governance Forum. But I think the focus on risk assessment rather than, as it were, heavy-handed top-down efforts to control technology, the emphasis on transparency, accountability, and provision of remedy, all of these are really crucial ways of ensuring that regulation is fits the circumstance and serves to empower the user. And I would exactly tie that back to the child rights agenda and the evidence that I mentioned earlier, because what we hear from families really everywhere is the desire to kind of tailor the digital environment to suit the family's choices and culture and to fit with the particular needs or risks that children face in different circumstances. Maybe just as a last word, it's been a learning curve for me to work with colleagues here and elsewhere in thinking how to build child rights into internet governance. And I think there are some emerging models. One that I've worked on is the idea of child rights by design to really harness the already underway efforts at privacy by design, at safety by design, and security by design to really think holistically about the full range of children's rights, including their civil rights and opportunities, their rights to privacy, and of course to protection, and to think how can we embed all of those in the design of both the digital tools and services they use, but also digital policy that serves to realize their rights. So child rights by design might be an idea that I would like to leave you with, and I only wish I could participate in today's discussion further. Thank you.
Professor Sonia, always so amazing bringing us researchers' thoughts and innovation, which are very useful for all of us. Now, to talk a bit more on data protection on South, especially, an inseparable topic to this discussion, we have the online participation of Valdemar Gonçalves Ortuño Jr., the President Director of the Brazilian Data Protection Authority. Thanks for joining us, Valdemar. Hope you're there already. My main questions for you are, recognizing the importance of the Data Protection Authority in protecting the digital rights of children and adolescents in Brazil, We would like to understand two levels of consideration. The first of it is how is the National Data Protection Authority incorporating Brazilian children's rights into its governance, oversight, and fiscalization process? The second is this process in any way influenced or inspired by international mechanisms or the actions of all other data protection authorities? In other words, digital platforms regulation in the global north can impact regulatory frameworks in the south? And if yes, is this good? And third, last but not least, what are the main challenges that the authority faces in the day-to-day activities regarding children's rights? Please, Mr. Valdemar, the floor is yours.
Bom dia ou boa noite. Obrigado, Maria, pelas perguntas, pelo direcionamento da nossa fala. É um tema importante. Antes, eu gostaria de parabenizar a Lili, a Sônia, a Mikiko, pelas brilhantes apresentações. E lembrando que no Brasil, depois de amanhã, nós comemoramos o Dia das Crianças. Na nossa autoridade, hoje, nós trouxemos os filhos, as crianças que compõem a nossa família, a NDPD.
We invited our children and the people who are part of our family in NPD, and this is a topic that we like to discuss. We discuss ardently aspects related to processing of personal data of children and adolescents and their rights are directly and indirectly considered in the ANPD regulatory processes. For example, directly speaking, it was the subject of a specific statement on the legal hypothesis and appears as an item on the 2023 and 2024 regulatory agenda. Indirectly, it is a point that can be verified in other regulatory processes as occurred with the legitimate interest guide, which counted on specific topics about processing of personal data of children and adolescents. Regarding inspection processes since May 2022, ANPD has been conducting inspection processes and personal data processing carried out by the social network TikTok. The process focuses on personal data processing of children and adolescents and is developed in two fronts. The first one is effective age verification to prevent TikTok from processing data from people under 18 and under 13. Second, proper data processing of people between 13 and 18 years old, especially for your feed, dedicated to targeted advertising and the legal hypothesis used for relatively capable people. The ANPD carried out steps such as sending letters to TikTok requesting information on how data is collected, for what purpose, which are the legal hypotheses, if the data is shared, and if there is any age control tool, in addition to holding many different meetings. And as one of the products of this work, a technical note was published with a series of determinations for adequate children and adolescents data processing by TikTok. It includes a review on age verification mechanisms, a review on privacy policy, and reviews of cases in which legal hypothesis chosen was chosen by the execution of a contract. You can find information in our website. Furthermore, in May 2023, an inspection process was initiated against 7 teaching platforms and tags. The first one, Centro de Mídias de Educação de São Paulo, Descomplica, Escola Mais, Estude em Casa, Explica aí, Manga High, and Stu. Those are platforms that became here really important after COVID. So the process aims at investigating children and adolescents' personal data collection and sharing by ad techs or advertisement techs, that is, online advertisement companies. The ANPD carried out measures such as issuing letters and holding meetings. The answers to these questions and other documents are on the process of analysis by the General Inspection Coordination. Now, if we are inspired by international mechanisms or other data protection authorities influence us, in other words, digital platform regulation in the global north can impact regulatory frameworks in the global south, we can say that one of the steps planned for any and all regulatory processes is performing analysis of international experiences, including regulatory impact analysis provided for in Decree 10/411 from 2020, and this is something mandatory. We have to analyze experiences from different continents. We know, for example, that Europe has a great history related to privacy, like the GDPR, and it influenced immensely our LGBT. But it's evident that while regulating our law, we need to observe the reality of our country. It is important to highlight that the Brazilian society has its own characteristics and it's much complex and diffuse. In Brazil, we have more than 200 million holders, which exceeds any European country. Personal data protection is something new compared to the time the subject has matured in other parts of the world. Europe formalized personal data protection in the 90s. It started as a recommendation, and here in Brazil, our general data protection law has been created for 5 years, and we almost achieved 3 years of the regulatory body. In this short period of time, our contribution as a regulator meets the best global practices, not ignoring the characteristics of Brazilian society. One of our main projects is precisely to analyze different scenarios and build a Brazilian regulatory model that meets the desires and needs of our population. Of course, we do not ignore good international practices, and we are attentive to what is working internationally. Furthermore, social participation is extremely important in the regulatory process. And the ANPD, since its creation, has made efforts to hold hearings and public consultations in which we listen to all the interested parties, national or internationally. We do this to guarantee legitimacy to our regulatory process. And finally, the main challenges that the authority faces in its day-to-day activities regarding children's rights, I would say that it involves protecting children and adolescents' personal data. The challenge is immense in Brazil and around the world, not only because of the complexity of the topic and the need to make privacy protection compatible with the promotion of digital integration of these small holders. Of course, this generates benefits, but also It is related to the importance of this population for the economic activities. Unlike previous generations, children are being introduced to the digital environment at an increasingly earlier age. And the personal data of these holders is not necessarily restricted to data consciously shared by them. It also includes data that can be obtained from their activities in the digital environment through cookies, location data, and other type of metadata. And it can even be done based on exposure from their parents. Many children and adolescents are not sufficiently literate or capable of understanding the implications of the digital environment, especially with regards to privacy and the use of personal data. To comply with the 2023 regulatory agenda item relating to children and adolescents' personal data processing, the main challenges we have been facing are being mapped out, but I can highlight issues related to techniques for measuring consent or measuring age of users of internet applications, impacts of digital platforms and games on the internet, on data protection of children and adolescents, serving the best interests of children or adolescents' personal data processing, and finally, possible risks that may involve children and adolescents in the scope of data protection in the digital environment. Maria, 1/4 of Brazilian population is made up of children and adolescents. So it is a priority of the National Data Protection Agency. So protecting the data of these children and adolescents is a central concern. Thank you very much for asking Brazil to share our status in this brilliant event. Thank you.
Oh no, please. Could you go on? Thank you a lot. Hello, everyone. I would like to thank Valdemar. It's very interesting and very important to have the Data Protection Authority saying that child's rights is a priority, and we as a civil society are following this work and following the EdTech case, the TikTok case, and it's very, very important, and with kind regards, we thank you, Valdemar, for such a complete statement. I'd like to thank all of the panelists. Actually, now we are going to open the floor for some conversation, and I would just like to make a few remarks that, as we've seen from Mikiko's speech, from Lily's profound speech on the reality of Ghana, on Valdemar's challenges, what do we see? That in the Global South, we have socio-economical challenges that impact the children's life and create similar but different contexts for the digital challenges that we face. Lily talked about digital education, the need for digital skills, but it was also talked so much about platform responsibility. And for instance, in data protection issues, we had a situation where WhatsApp had terms of use that were more protective of European children than of Brazilian children. This is the inequality and the discrimination that Mikiko was talking about that is in the general comment. So how do we think about this? How do we think about this responsibility? And just to come up with something from Brazil, we have Article 227 in our constitution that says that protecting child's rights is a responsibility of the state, of the society, and of the family. So this is a responsibility of all of us, and by society we understand the platform responsibility to actually take active measures, transparent measures, and have accountability on what they are doing to actually improve child's well-being and experience on the digital platforms. So with that said, now I would like to open the floor, and I see there are some Brazilians here, and I know English can be a difficulty, so if anyone wants to talk in Portuguese, we will translate. We are very, well, we want to invite you guys to talk to us, not only the Brazilians, but everyone, but just to open the floor for all of you. Thank you very much.
Hi, my name is Wilson. I am youth in Brazil. I speak português. Vou falar em português. A minha pergunta são 3. Ai, que bom poder falar em português nesse evento, gente. Pelo amor de
I'm going
Deus.
to ask 3 questions.
Primeira
It's so
pergunta vai
good
para
to
o
be able to
Unicef,
speak
pensando na perspectiva de
I
regulação
am
de plataformas
going
que
to
têm
ask about
proibido
platform
temáticas LGBTQIA+,
regulation.
a partir da
Platforms that
perspectiva de
have been
defesa dos direitos de
forbidding,
crianças e adolescentes, como, por
LGBTQIA+,
exemplo, o caso COSA nos Estados Unidos,
on
que tem vetado, né, temas como LGBTQIA+, por dizer que isso influenciaria os direitos de meninos e meninas estadunidenses.
His first question is he wants to know about the LGBTQA plus rights and how this may collide with actual regulations that we have right now. For instance, in United States with the Kids Online Safety Act, we have this discussion and this tension about how child rights standards could be used to actually veto or take down LGBT content because of conservative groups advocating for it.
Posso fazer em inglês, amiga? Vou no meu aqui, vamos lá então. The second question goes to Lily. How do you use technology as a way of emancipation the identities of children and adolescents from the online context, especially from the perspectives of the Global South? Three questions is... agora eu vou falar em português, porque é para o rapaz da NPD mesmo. Okay? A minha terceira pergunta é, pensando na perspectiva de regulação de plataformas no Brasil, eu queria compreender qual tem sido a ação da NPD na perspectiva principalmente de acompanhamento e monitoramento de checagem de dados de idade, porque isso gera, né, tem uma correspondência com dados de crianças e adolescentes. Então, eu queria saber se a NPD tem olhado para isso e como tem acompanhado esse debate. Obrigado. Thank you.
Thank you, Will.
And just for the floor, his third question was about how the Data Protection Authority in Brazil is following the age verification measures and debates because this impacts the whole ecosystem. Sorry, just Will, could you clarify the second one for Lily? She just wants to understand a little bit more. Yeah, you have the floor. Thank you.
Okay, thank you. Hello, I'm Stephen Foslu. I'm from UNICEF. So firstly, thank you for the very interesting interventions. I had 2 questions, please. The first is, I'm looking at digital regulation, like all of us around the world. It seems like we're at a point where there's a lot of regulation happening globally. One around child protection, and this seems to be looking backwards. I mean, in the US, this is one country, but it's quite interesting that this year alone, there are over 140 state-level, mostly state-level, regulations, or proposals rather. And most of them won't be passed, but there's this kind of crazy rush, and a lot of it is looking backwards towards social media. And at the same time, we have AI regulation that's very much a hot topic here especially and everywhere, which is interesting because this seems to be more forward-looking, which is encouraging. So I wanted to know if you agree with this reading, that we seem to be in a time of heightened attention around digital regulation. And then secondly, this point, the topic of today of how do you get some sort of, do you have models, if you put it this way, of how we get, like the general comment, you have certain standards or certain measures that you would like in regulation, but at the same time, countries need to respond to their local context, you know, like the colleague from Brazil said. So do we have models where we have kind of consensus on a certain level, the minimum standards almost, of what we would like to see for child protection and empowerment, but at the same time, kind of differences that talk to the local context? And I just ask that because, you know, we generally think of regulatory fragmentation as a bad thing, because there can be fewer protections for children and less knowledge sharing and resource sharing. But at the same time, there's almost an inevitable level of fragmentation because countries are different. So yeah, your thoughts, please. Thank you.
Thank you. Thank you a lot, everyone, for the questions. So we have one question about the Kids Online Safety Act and LGBTQ rights and how can we think about balancing this. Another question about emancipating the identities of children and adolescents from the online content, especially from the perspective of the Global South. This one specifically for Lily. A question for Valdemar and the Data Protection Authority about age verification, fiscalization measures, and what the authority is doing with it. We have a question about the regulatory tension that we are seeing in the world right now, and they cited AI and other emerging technologies. And the last question about, do we have global standards that we can actually apply, but seeing the local contents, and how can we do this balance between local and global? So to wrap up, I'll send specifically to everyone to make your final remarks, but also answer the question with this. Can I invite Lily to start?
Right. So I'm going to start with the question about how to use technology to emancipate identities of people in the Global South. So we have seen that technology, in essence, helps us to augment let's say, advocacy for children, and allows us to, if we're doing something in a small scale, it can help us to scale it up. Now, for what I think that we can use technology, how I think technology can help us in this space is the education creation, awareness creation, and also aspects of just maybe online support, or what we call you know how we have a hotline for places. You can do child support hotlines. So those are the ways I'm seeing those things as a way that we can help. Technology can help us to be able to emancipate when it comes to like just children, things that are issues for them online, and to provide support for them. Now I'm saying this against the background of how people encounter issues and probably do not know how to address them. So if they're new or they're equipped with knowledge, don't know how to better act. If they didn't know, is there support for them to like help them go around what situations are existing? So I'm thinking in those areas of the just education, the awareness creation, and support that exists. Technology can help us do that, but in essence, we also have to know how to make sure that we are using it rightly. If somebody needed support online and somebody lied about being a support, that means a child has gone back into the hands of a predator or somebody that can harm them. So all of those things about literacy comes into play for us to be able to sift through what is right support and how we can also find the right information. There is this upsurge of misinformation and disinformation online. We can find the right things online with technology, but it will be hard for anybody who couldn't know what is right and what is wrong. So all those things can be found online, and technology can help us to, in that way of education and awareness creation and support, to be able to help children who probably have identities and issues around just rights online that are probably trampled upon. I'm going to attempt the question around regulation, and I hear that there is a heightened conversation around regulation, and I see it across board. Everybody talks about emerging technologies, talks about privacy, talks about security accompanying them. Now, what it looks like is there needs to be that balance. There is regulation to a certain extent that can stifle innovation, that can stifle even use of technologies for things that will be essentially helpful. The conversation now about regulation looks as though it should lean more towards what we see as what are general guidelines. How can you contextualize for your particular scenario or situation where you are in the world? And for that to be helpful or beneficial to a community, there needs to be the presence of what we know as a multi-stakeholder representation for people to be able to put forward what it is that is helpful for them and from their background, and say that from our perspective, we want this to be added. It just promotes inclusivity, it promotes equitability, and just representation there. So regulation is pretty much on top of things now, or on top of the conversation now, because of the security issues you're seeing, privacy issues you're seeing. But there has to be the conversation going in such a way that in the long run, it's not stifling innovation and just even used for people who could benefit from just maximizing technologies if they knew how to. So in rounding up, there is the support that we need, that people can share best practices, learning from across the globe. That will be helpful for everyone. And so I'm pretty much all in for what is happening. How can we put some things or replicate some of these best practices in other countries for the Global South and for Ghana, for instance. And so let's keep the conversation around sharing resources and support open. And who knows, we can move forward in the next year or two with some of the things that we are seeing as issues in Ghana around awareness creation, literacy, and just access. Thank you.
Mikiko, would you? Thank you very much. So first of all, about the LGBT, I LGBTQ plus rights. I think this is one of the examples why it is so important to approach this whole issue in a comprehensive, holistic way. And I think the Convention on the Rights of the Child provides such a legal basis for the comprehensive approach. Because when we talk about, for example, the protection of the children from harmful online content, what are the harmful contents? So always value judgments comes in. And so we really have to think about when we talk about harmful, we also need to understand the children's rights in a holistic way, including the non-discrimination against those children who are LGBTIQ children. And for those children, the online access and the digital platform is so important to access the information and to get connected. And so we really understand that aspect as well. And the age verification, when the committee drafted the General Comment 25, there was a lot of discussion about the age restriction or age verification. And you know very well that Convention on the Rights of the Child is very much dependent on age, cutting age, because the children are defined as all human beings under 18. However, at the same time, we don't really, the convention is not really restricted by the age, because the convention used the language such as age and maturity. So it's a really challenging questions. Can we really set some access issue based on the age only? But currently the policy is very much using the age. So if the age is used, the two questions are: what is appropriate age first, and secondly, verification. And even on the offline situations, age verification is challenging. For example, still we haven't reached the achieved universal birth registration, for example, and it's not yet we went to the universal birth registration. So in this reality, even on offline situations, sometimes the age verification or age determination itself is a challenge. But when it goes to the online situations, how really actually we can ensure the application of certain age policy, age-based policy? The committee doesn't have the answer, really. So it's a common challenge, I think, and we need to continue discussing and finding some solution. Then coming to the regulation issue, yes, I agree with you that we are talking a lot about regulation. However, as the Sonia spoke, in the committee's drafting process, we also discuss a lot about something like safety by design, protection by design. But is that considered be regulation? If it is the voluntary, efforts by the business or the code of conduct, but if it becomes the regulation, it's again a regulation. So, and also we talked about not only to protect the children from risk and harm by regulation or law or implementation, but also children need to be supported, empowered to gain the skill to navigate the online, because we cannot fully take out all the harm, from online. So this is the committee's position, the policy when we discuss the DGC 25 regulation, and also empowering the children have to go hand in hand. So I think we also need to talk more about how to support the children and parents and how to empower the children. That's my view, but you raise a very interesting point, such as the fragmentation of regulation among the states, but also the regional. I mean regional meaning the municipal levels, or in a context of U.S. State level, or in a federal countries state level, but other countries there are municipal levels. I think it's interesting because the committee has a dialogue only with the states, state parties. However, many things around, concerning the children are happening and actually impacted by the municipal level regulation on the programs or policies. So I think we really need to engage with the municipalities or the state levels. And I don't know how those actors are here in this forum, but for example, the SDGs, many municipal levels engaging with the SDGs. And so I think we need to have more conversation at the environment, because which is the environment closer to the children and impacting the children. Finally, also you raised a very interesting point, because it's not only about the online child safety, but about whole children's rights, because the Convention on the Rights of the Child is a universal or international standard. However, when it goes to the actual implementation, we really need to understand the context, the local context, which doesn't mean that we say that cultural issues can be used to justify non-implementation of the international standard, but we really need to understand. So I think the challenge for the committee, we have country review, country by country, and our dialogue is focusing on one country, but the committee is not a forum to collect the good practices or compare. So I think that kind of good practices that if we call the minimum standard at international level, or fragmentation is not in a negative way, but the positive way to find good practices. So this kind of forum or other forums or UNICEF work, I really appreciate your collecting the data, and also researchers and academia. We should learn from those who are collecting the information, who can help us to understand how the international level of policy and standards can be implemented in a positive way.
Wonderful. Thank you so much, Mikiko. Please, Valdemar, are you online? Oh, we have one more
Vamos
question.
lá. Nossa
here.
primeira pergunta foi relacionada à verificação da idade. A verificação da idade, na minha
Age verification at the beginning of my talk, I shared with you what we've been doing along with TikTok. Age verification is one of our main concerns. We are checking if it's adequate, if it's being performed, and to verify we can hire audit. And it's something very important in international level. We have to seek information from other bodies that have already dealt with the topic that might help us. So sharing with other authority is important, and sharing information with other bodies within Brazil, the bodies that talk about this topic is helpful. Now talking about implementation of regulations in Brazil, we've been trying to regulate AI, and we have been discussing these topics in the National Congress, and the ANPD is always present in the discussions. We've been performing preliminary studies that show, for example, AI, when they deal with personal data, regardless of the technology that is being used, it's foreseen on our LGPD a certain level of protection. And so we have been taking part on the missions in the Congress, and we have been sharing our positions and things that the ANPD has been implementing firmly?
Thank you a lot. And I would like to thank all the panelists for answering the questions in such a complete way. And we have one last question. It's the final one, and then we do the final wrap-up.
Hi, good morning. Good morning, Francisco Libardia from Panama. After this interesting conversation, I would like to ask, what are your thoughts on using the existing international organizations like the Hague Conference on Private International Law, the OAS, the European Union, African Union, in order to move forward or to implement this protection of the rights of the children in the digital environment?
Thank you. I would give it a shot from the EU perspective. I shared before that one of the things that has been ahead in the past and in many legislations or conventions on the continent has been implementation. And I see it as maybe a problem that is probably because the approach to it is pretty much generic. There could be city level, community level actions that can propel towards the implementation of the things that were listed probably in some of these conventions for child protection. I'll give an example. I have seen city level strategies of cities in the US that have gathered or sped off quickly because they were city level and community level. Nobody was waiting for state government to make a change. It starts from grassroots and then running supports and then moves upward. I'm thinking that once people know that these exist, first I'll see another problem would be they don't know that these even exist and can be guidelines. On the ground, then there can be guidelines for them to be able to maybe help with their processes and to follow some of the things that have been listed in there for the work they do in community level, in city level. In Ghana, we have regions, so in regional level, that will be helpful to propel. People usually just look for what the broader perspective is instead of taking it from pretty much the granular details and running with it. I feel like that is how implementation can kickstart. Thank you.
Thank you, Lily. Do you want to?
Yeah, thank you very much. So my view is that we should utilize whatever existing legal instruments and mechanisms, platform available in action-oriented way. This is my challenge, as a committee members. There are so many, platforms, and we really don't know who do what, and it's really challenging. The Committee on the Rights of the Child is one of the, key mechanisms for the child protections. But I was not aware of actually the IGF, Internet Governance Forum, and I'm learning a lot sitting yesterday and today. And it's so fast. Everything is, the discussion is, technology progress is so fast, and we are not fast enough. We are slow. And the children, as I said, are all human beings under 18. When we were talking, for example, the general comment, I said, generally we take 2 years from the decision of the choosing the topic and until the adoption of the general comment. In 2 years, children grow, and 16 years, children will be adult. And after the adoption of the general comment, we talk about implementation, how the general comment is used and implemented. So it takes a lot of time. So I'm not in favor of creating a new instrument or new platform. My challenge is how we can use existing ones. But to do that, what is the, mechanism? Maybe you want to respond to what I said. I understand that you are not suggesting, but the challenge is that how we can, effectively use.
Don't get me wrong. I'm not saying to develop new instruments. I am saying use the international organizations as instruments for implementation. For example, in the Hague Conference on Private International Law, they used to develop like guiding principles, model laws, also like guidance for application of treaties. So my question is oriented not to develop new convention. No, no, no. Don't get me wrong. It's like using the international organizations as a vehicle for implementation.
Someone? Maybe Valdemar wants to comment? Are you there?
Ok. Eu acho que o tema é importante,
Think
extremamente.
that it is an extremely important topic. And the more help we get, the better it is. So working along with other institutions is central. Brazil is part of the hybrid American network, and within this network, we always rank priorities, and it is it's a group that is made of members of many different types of people from different bodies. So this exchange of information and experience amongst international bodies is something that is extremely helpful. It helps each country to develop their own policies.
Okay, perfect. Is that good? I think now it is. We can have lunch together and talk more about later. Okay. Mano, do you want to say some words to wrap up before I finish?
I think just one final comment. It's very nice that we are here discussing digital platforms and digital regulation, but also on the videos that we saw at the beginning, the children were saying a lot about playing on the streets and these contents, and that they don't feel safe for this anymore. And to think about child well-being in a holistic approach, we have to think about the safety on the digital environment, but it is also very important to think about the environment and how this affects children, and on security of the cities and the right of children to play online safely, but to play on the cities safely and to have this holistic approach for child well-being. So I think this is very important so that we don't isolate the worlds, because we live in the same world, the digital, the offline, the online, it's all mixed up right now. So how do we integrate this debate so we think more broadly? And with this, we are proposing, of course, seeing the General Comment 25 with the General Comment 26 that talks to the child rights access to nature and the importance of this dual approach for understanding child rights. And this could be a discussion on the next IGF. Thank you.
Thank you. So I'm afraid you have to finish now, but we're so thankful for this session, and I hope you have learned with it as much as I did. As Valdemar said, tomorrow is Children's Day in Brazil, and we wish them and all children and auspicious present and future online. Thanks once again, Mikiko, Lily, and Valdemar, Alana, colleagues, and everyone who joined us today on helping us raise proposals on child's rights for and with the Global South and on international level. Thank you so much again. And we have our colleague there brought some example publication, General Comment 25. Is it over there, here? Yes, anyone who wants to know it better is here. Juta, okay? Thank you so much once again.
Meu Deus. Amiga, tá em PB. Você quer em preto e branco?
Só correndo.
Ah, tá. Essa água daqui. Congratulations.
I would take it and run away.
Thank you very much, Lily. It was awesome.
It was a really great session. Are you both from Milan?
Yes.
Okay, great. Okay.
And she's also.
Oh, very nice. Okay, very nice to meet you. I am Steven from UNICEF, and yeah, I've met Pedro, Dr. You do wonderful work.
Yeah, she made a run for it, didn't she?
I really like the work you did. It's connected. It's not an online world, it's an offline world. And we have a paper coming out soon, a digital equality framework. And we use it to analyze digital equity policies. And the point that you made clearly is that sometimes to reduce digital inequality, and
Offline
yeah,
equality.
exactly.
Offline equality.
Parabéns, gente. Um dos melhores painéis, viu? Só não precisava do cara da independente. De resto, tava explicando.
Foi muito bom, gente. Acho que aqui foi suave. Acho que foi difícil para quem estava acompanhando em português. Pro Valdemar.
Porque a moça não conseguiu traduzir.
Deu para ver que ela...
Uai, gente, mas eu falo mais rápido que a Lili? Eu falo mais difícil.
Não, tu não falou rápido.
Não, é porque tava a gente reclamando que a tradutora do português não estava conseguindo. É aquela companheira que ela estava falando rápido.
Quem?
A tradutora do
Ah, sim. Mas não era só, não era tipo uma pessoa, era todo mundo.
É todo mundo, né?
Ah, tá, desconfiei.
Ei, tem um celular aqui, gente.
Deve ser o meu, né? É o meu. Ligeiro de todo mundo, deixei pra trás.
Tava aí cuidando de todo mundo.
E toda hora falando, gente, o celular aqui. Obrigado. Agora, eu acho engraçado, porque espanhol eles vão se falar um, mas a maioria dos povos que trabalham falam um, não espanhol. Aí eu tento aprender inglês, e eles não aprendem espanhol porque sou poliglota, tem que ser poliglota para trabalhar com essa bola.
start the meeting and say this meeting started at 1:15. I just but I think it is actually your original message that I posted as 1:15. So she was looking at my calendar, whereas I'd actually told her that I would stand 25 past. I think
Good afternoon, ladies and gentlemen. We will get started. This is the session that we attempt to try and have a discussion around taxation. It's a very broad topic because the world of taxation is huge. We're going to start a little broad and then hopefully narrow down to how we actually deal with the large technology companies. And we're going to try very hard to look at this issue of taxation from the point of view of majority world or global south countries. The conversation around taxation is more important than ever now in light of the fiscal squeeze that many countries are facing in the global south. High inflation, high devaluation of local currencies, COVID have all meant that the need for revenue is very high. There is also a conversation around data and digital justice when a lot of the content is provided and the user base is also from the majority world, yet very little of the revenue from taxation goes into those countries but are collected by a handful, including America and China. This is a timely conversation. There have been many global, regional, and national level efforts to also try and collect some of this tax revenue. There is no sort of winner at this point. There are various options which we will present and we will talk about. To do this, I'm joined by two speakers online and two here with me on the podium. Online, we will have Abdul Muhid Chowdhury, who is Senior Program Officer at the South Center. The South Center is an intergovernmental organization of developing countries based out of Geneva, and they help developing countries to combine their efforts and expertise to promote common interests in the international arena. They conduct extensive work on international tax cooperation through the South Center Tax Initiative. To my right, we have Dr. Alison Gilwald, who is the Executive Director of Research ICT Africa, which has been a long-standing evidence producer about the state of connectivity, about the state of digitalization and digital rights across Africa, and who we work closely with. And next to her, we have Ms. Gaine Hurulle, who is a Senior Research Manager at Learn Asia, who is working on some of the tax issues that Learn Asia looks at. Online, we also have Matthew Bongjibola, who is the Coordinating Director at the Federal Inland Revenue Service of Nigeria. And Nigeria is interesting because they have a tax that's a country-specific tax, but Matthew also is co-chair of the UN Tax Committee, who also has another proposal on tax. So he's a very interesting he sits on both sides. And finally, we are also joined by Victoria Hyde, who is the Policy and Communications Manager of the Asia Internet Coalition. Now, the AIC is an industry association representing the internet industry across the Asia Pacific. Their members include Meta, Google, and Amazon, so certainly all the big platforms. And to my left is my colleague Isuru, who will help, who's a research manager at Learn Asia, and will help with online moderation. So to get us started, what we've asked is actually for Gaine to set the stage, because I think this is a conversation that needs a little bit of data and framing to get into. Oh yes, before that, we have the pleasure of actually quickly asking, this is meant to be a debate because there are actual options humans face, in these countries. But first we want to do a quick Slido. If you could please go to www.slido.com. This is, I promise, 2 minutes or less. Even the online audience. And enter 2238752 and fill this poll. And the question is, should countries be exploring policy options to impose taxes on big tech? This is not necessarily an obvious answer because many have talked about, well, let's not tax because the benefits of digitalization are so high and using the platforms. Let those actually, the economic revenue from that compensate instead of taxes. So what do you think? And we want to see if you'll change your mind at the end of this sort of 90-minute conversation. The code again is 2238752. Sorry. Okay, so about 70, just under 20% sitting on the fence, but a majority, 75%, saying yes, we should be taxing big tech. Right. Thank you. Let's move on. As I said, I've asked Gayani to show us sort of a little bit of why this topic is important and maybe present the policy options that are facing developing countries in particular right now.
Thank you, Helani. If I could just get my slides up. Wonderful. Okay. So we've very helpfully called this session Taxing Tech Titans. What I'm trying to do here is, as Helani said, just frame the conversation and give you a sense of what the different policy options are. So what you'll see is that many of the internet users in the world right now actually live in the global south. So to give you a little bit of context, ITU data indicates that over 60% of the world's population, that's about 4.9 billion individuals, are now online. But we're seeing that a majority of the internet users now reside in the majority world. And India, Indonesia, Brazil, Nigeria are amongst the countries where most of the internet users in the world live. Now, many apps, sorry, just give me 1 second. I'm having a little bit of a tech issue. Sorry. Not sure why this is happening. All right, I think we're good. Okay, yeah. So if we hone in on the case of India, for example, LearnAsia's national representative survey that we conducted in 2021, that was in the midst of the COVID-19 crisis, found that 47% of the population aged 15 and above were online. And given India's growth trajectory, which was very stark, this is likely to be greater now. But then the question really arises, what apps and platforms were they using? And we found that the most used apps and platforms when we did our survey was YouTube, Facebook, messaging apps such as WhatsApp and Viber, and Instagram. So then the question again is, what's the common thread between these? One perhaps is that they are social media type apps, but the other is also that they are that they are products of large tech MNCs. And despite operating and having users in the global south, many of these platforms still largely derive their revenue from the global north. So Meta, who we've given an example from here, derives 70% of their revenue from the US, Canada, and Europe in 2022. But while the global south accounted for a smaller percentage of revenue, that's about 30%, it's still sizable and therefore quite lucrative for tech companies. So for example, if you look at the graph on the right, you'll see that Meta made $24 billion in revenue from the Asia Pacific in 2022. And this number doubled over 4 years. So this market is not only sizable and lucrative, but also growing. Now, despite making sizable revenue from the global south, big tech often lies outside the formal tax nets in the countries in which it operates. And this has multiple impacts. The first, of course, is a no-brainer. It impacts government revenue. And then if the funds were present, it could go into a consolidated fund, which then could be used to achieve other developmental targets, education, healthcare, and whatnot. But it can also impact the competitive landscape. So we in Sri Lanka, for example, have seen calls from the local ride-hailing operator. To give you context, there's a local ride-hailing operator, PickMe, and then another, an Uber, which operates in the same market. And we found that the local ride-hailing operator has been calling for the country to introduce digital taxes because they claim that they were paying more taxes than Uber, which impacted their cost structures, which then in turn created an uneven playing field. So we've seen calls from the local tech companies to impose digital taxes to kind of create a level playing field. Now, Despite the benefits, some countries have been quite delayed in implementing digital taxes. Therefore, taxation of the digital sector has been limited to long tax sectors like telecom and IT imports, for example. And then these issues have been confounded by the lack of agility associated with the legislation of some countries. So, for example, in many countries, the Income Tax Act deems it necessary for a company to have a physical presence in the country, which then allows for companies like Google and Meta and whatnot who don't have a physical presence in the country to stay outside the tax net. But it's also worth mentioning that this issue of digital taxation is also sort of, there's an underlying issue around defining and sizing the digital economy. And this is a complex one that many countries, even countries in the global north, have found quite challenging. And we've found that organizations like the IMF, OECD, UNCTAD, ADB, and so on have also been grappling with trying to size this digital economy and figuring out how to define the bounds of it. So in fairness, it is a tough exercise, possibly one that countries, particularly ones in the global south, are waiting for some direction on. And in the case of digital taxation, there have been multilateral processes in place, which I'll get to in a minute, that countries may have been taking a little bit more of a wait-and-see approach to. However, there are several policy options for countries on how they can tax the digital economy. I'll start with talking about domestic measures, and there are a range of options within this. One is using direct taxation measures, such as digital services taxes, which is where you tax a company based on the revenue that they make from a country. Another is an indirect tax or a consumption tax, which you levy a specific tax based on the point of consumption. You'll see this in the case of digital service VAT, GSTs, and whatnot. But just for the purpose of streamlining our conversation today, we'll focus on the direct taxes. And you'll see that countries in the global south several countries in the global south have already implemented these direct taxes. We've illustrated some cases from South and Southeast Asia. So we've seen that India, Pakistan, Nepal, Vietnam, and Malaysia all have some sort of measure in place, but they're also quite heterogeneous. And even if you hone in further on digital services taxes, which is one subcomponent of the direct taxes, you'll see that they do tend to vary quite a bit. So even in South Asia, you'll see that they call different things. They call the equalization levy, you'll see being called the fee for offshore digital services, but it really boils down to the same thing, where countries tax companies on the percentage of revenue that they derive from the country. And if you look at the three systems in place on screen, and sorry, this is a little wordy, but we wanted to make sure that we just put out all the information here that we can go back to. You'll see that India, Pakistan, Nepal, they're quite different. And this actually does speak to the benefit of one of the benefits of a local DST in that it's customizable and flexible, which is what you don't really see in some of the other multilateral or treaty-based options that we'll talk about later. But it also speaks of a cost to companies because they have to deal with different tax regimes being in place in different countries and therefore have quite high transaction costs in trying to pay taxes. So compliance costs are quite high. So if we just look at the differences in these three country measures, you'll see that they have different tax rates. So India and Nepal, for example, have a tax rate of 2%, while Pakistan has 10%. There are some countries that have taxability thresholds, so like revenue floors to protect small businesses, but it is absent in other countries like Pakistan. Then you'll remember that I spoke earlier about this issue of archaic income tax acts. Pakistan has amended that act to allow for digital taxation through their existing act, but India and Nepal have introduced separate legislation outside the taxes, outside the acts to impose these taxes. So you'll see again the approach to digital taxation, even through these DSTs, can be quite heterogeneous. Right. Now, while these domestic measures have been put in place and discussed, there have also been parallel efforts to explore treaty-based options. And this is the benefit of having a treaty-based option, is that it reduces the risk of double taxation. And there are two main treaty-based options on the table, one put forward by the UN and the other by the OECD and G20. And there are various different subcomponents within this as well, but I'll focus on the two elements that are seen as alternatives to the digital services taxes that we discussed earlier. That's Article 12B in the UN Model Tax Convention and Amount A in the OECD G20 Inclusive Framework Two-Pillar Solution. So there are a couple of differences even within this, and again, I won't get into too much detail here. Hopefully we'll be able to talk about this in more detail in the discussion. But it's worth noting that the UN's Article 12B is to be implemented through a bilateral treaty negotiation. There has been some conversation about a multilateral option, but right now what is clear to us and what is available in the public domain is this bilateral mechanism. So, for example, if a country X is headquartered in the US and if a company is headquartered in the US and a company would need to have a country would need to have a treaty with that particular country to tax the company that's within that sort of locality. And this builds on the domestic measures while reducing the risk of double taxation. It can be quite cumbersome and impractical in its current form. Then there is the OECD's Amount A Convention, which is the most well-known and debated in the public domain. This is the multilateral convention. It defines which companies are eligible not by listing services, which is what you'll see in the case of Article 12B and in many of the local digital services taxes that we saw earlier, but by providing revenue and profitability thresholds, both at a global level and also at a market level. And it has a fixed rate across countries, which is attractive to platforms. But there are also sort of negatives, which we'll get to later. Now, while these different options have their relative merits, they have the potential to give countries different quantums of revenue, which I hope Abdul will be able to comment more on. They'll have different impacts of competition, and they'll have a lot of different costs of implementation, be it negotiation costs, compliance costs, and so on. I won't get into a lot of detail here, but hopefully we'll hear about this more from our speakers. So just before I hand the floor back over to Helani, I'd like to highlight that there's a crucial decision point that countries need to make in the next few months. The OECD and G20 has indicated that they hope to implement their multilateral solution in 2025. And have asked for countries to sign up for the Amount A Convention by the end of 2023. And this is important for several reasons. This could be the beginning of a multilateral system, which is a first best solution. But if countries sign up for this program, they agree not to impose domestic measures until the end of 2024. And then there's the actual implementation of the convention is contingent on the US signing this. And that's a lot of power in the hands of a single country. So there's some apprehension and skepticism on this as well, which perhaps we can talk about in more detail. So it's for this reason that we thought that we'll center our discussion on whether countries in the Global South should sign up for the OECD and G20 multilateral convention by the end of 2023. I'll stop here and hand the floor back over to Helani, looking forward to hearing more from our speakers. Thank you.
So just to clarify, Gayani, December last year, I believe, was the initial deadline set for the negotiations to happen, the US and countries to agree on the proposed taxation with the OECD. That didn't happen, and now December this year is the new deadline. So the options for countries is, if you sign up to the OECD convention, you can't do anything until end of 2025.
Until end 2024. So it's a one-year goal post that keeps getting shifted.
That keeps getting shifted. Okay, so you can't then go ahead and do some local taxation and so on and so forth. However, there are countries that have done national level taxation policies and said in the policy itself, until such time OECD agreement is reached, this shall remain in play, right?
Yes, possibly. And there are also other countries who have implemented their own DSTs and then signed up for
and then
the
still
solution
signed up for the OECD and waiting.
afterwards.
Okay.
Because what that convention specifies is that you can't implement a DST after you sign up for it. So
but
they've been
presumably
quite
for
tricky.
these countries, like so presumably you said India has a national level digital services tax, a DST. If the OECD thing comes into play, they can somehow sunset the national level
Yes,
stuff
I
and go with
believe
the
you
OECD.
can.
Okay,
I believe
right,
you can.
that's where we are. Great, thank you. I'd like to bring in Abdul from the South Center. Abdul, you know, you've been really working on this, and the South Center has sort of been leading the charge on the UN proposal, which is what expects every country to bilaterally negotiate with other countries in order to be able to tax. So, and one of the things actually I asked Gayani to do is to frame your discussion just to put some numbers that, you know, your reports have calculated. Because for countries, one of the big considerations is revenue potential. Where can I get more tax revenue from which option? So keeping that in mind, could you talk us through, in particular, the UN option and why that might be a preferred solution for countries, Abdul? And can we unmute?
Helene.
Oh, thank you.
Yes, thank you, Helene. Good morning, good afternoon to, and good evening to everyone. It's a pleasure to collaborate with LearnAsia at this event. And my greetings to Mr. Matthew Gubanjibula, the co-chair of the UN Tax Committee, and I'm honored to share the panel with him, who in fact has been a champion of the developing countries in taking Article 12B forward. So in response to your question, Helene, as we can see from the data, Article 12B has two methods, the gross method and the net method. And just to highlight that countries don't really need either option. They can just introduce domestic law measures and start collecting taxes. You know, this thing of that you need a treaty is really this hullabaloo around a treaty comes more from the developed countries, because they want to actually reduce the taxes which their companies face when they go to developing countries and derive revenues from there. Because tax treaties, they don't grant taxing rights, they restrict taxing rights. I would repeat, tax treaties don't grant taxing rights, they restrict taxing rights. Even without a tax treaty, the residence jurisdiction can always give unilateral relief to its taxpayer. So if Uber works in Sri Lanka and Sri Lanka introduces a digital service tax and there's no Article 12B amount, if there's no treaty-based solution, the US can always tell Uber that, okay, you paid taxes in Sri Lanka, so we'll take that into account when you pay taxes in the US. So those unilateral relief options are always there, and we're there actually, because even now it's not like every country in the world has a tax treaty. So just to mention that even without tax treaties, countries can collect taxes. Domestic law is the basis for collecting these taxes. Even if they have treaty-based solutions, but no domestic law provisions, they cannot collect anything. Tax is a fundamental aspect of sovereignty, and this is something countries should keep in mind. Now, with that out of the way, if we look at Article 12B, the revenue estimates which we came up with, you have, the comparison should be with Amount A, the 20 billion euro threshold, and Article 12B, with the two options of ADS only and hybrid ADS. Now, why is the UN option a better option by and large for developing countries? One is because if we see most developing countries don't actually have a very big tax treaty network. So it's not like they have so many treaties to renegotiate. You have a few large countries which have lots of treaties, but by and large for most small developing countries, especially the countries in this list, many of them would not have a very extensive treaty network. So it's not like they would have to negotiate so many treaties. And then there's a revenue potential. We can see that Article 12B with a broad scope, ADS companies and hybrid ADS, and ADS is automated digital services like online advertising, income from search engines, income from supply of user data, income from cloud computing and things like that. So that kind of income, if a country goes with Article 12B, and has a broad scope, we can see that it gives almost more than twice, and in some cases up to 3 times what the OECD solution gives. So in terms of revenue potential with a broad scope, Article 12B has much better revenue potential if you're talking about the gross method. But if you look at the narrow scope of, if Article 12B has a narrow scope, and by narrow scope, I mean in Article 12B, paragraph 6, you have a list of digital services. And if you look at only those digital services and apply the tax only to those specific digital services, then the amount is comparable with amount A, which would come from the OECD solution. And actually, if you look at the net method, that actually gives the least revenues, and in fact, it gives even less than the OECD solution. So
and what's the difference between the gross method and net method? Abdul, you're not talking to a bunch of tax people. I think this is a very general digital governance audience, so you do need to explain acronyms.
Yes. So the gross method is basically a digital service tax. So and the net method I'll get to in a second. So the gross method was brought in to because many countries, as Gayani mentioned, brought in digital service taxes. So the United Nations developed the gross method to provide a treaty-based solution to eliminate double taxation for digital service taxes. So gross method is the same as the digital service tax. The net method, what the gross method does is that on every payment for a digital service, some portion of that payment is withheld as a tax by the government. So it's a transaction-based tax. It's not that at the end of the year the company files files the return and pays the tax at one go. It's on every single payment which is made for a digital service. So, for example, if $100 is made for online advertising, and you have a 3% rate, then the company, which is like Google, which is providing the online advertising service, would get 100 minus 3, $97 or whatever currency that is. So that's how the gross method would operate. The net method, on the other hand, is a tax which is paid at the end of the year. So it's not a transaction-based tax like the gross method. And the way the net method operates is that it provides a simple formula through which the company can arrive at the net profits. And this is important. It's called the net method because net refers to net profits. So they give a formula to calculate net profits. And this is important because the big question in the digital economy was, how do you calculate profits? Because normally, if you look at the brick and mortar economy, you have a factory in your country, you can audit, you can see how much do you pay on rent, how much do you pay on salaries and your input costs and whatnot. But in the case of Uber in Sri Lanka, where there is no physical presence, how can you audit? I mean, the company can say anything and there's no way you can figure out what the costs are. So, and especially when the whole business model is based on algorithms and intangibles largely, so it becomes very difficult to determine costs. So the Article 12B net method provides a simple formula where you basically see how much local revenue has been made by the company. So in the case of Uber in Sri Lanka, how much revenue did Uber derive from Sri Lanka? And to that, the profitability rate of Uber globally would be applied. So if Uber has a profit margin of, let's say, 10, 12%, whatever, that would be applied to Sri Lanka's local revenues. 30% of that figure will be taken. And to that, the local tax rate, Sri Lanka's 25, 30%, whatever rate that is, that would be applied. So that is how the net method operates, broadly speaking. And because of that, because it's a net basis tax, because it's not a gross basis tax, obviously the revenue collections are much lower because by and large, turnover-based taxes or revenue-based taxes tend to have much higher revenue collection.
Wonderful, thank you. So Abdul, you're basically saying as a matter of national integrity, everyone reserves the right. But in terms of being able to negotiate, what do you think are the transaction costs involved unless the UN comes up with a treaty with standardized rates, etc., that everyone can sign up to? Is it really a matter of Cambodia going and negotiating with China, let's say UK and the US, if those are the three big countries where the platforms come from? Is that what, sort of, yes. Is it left up to countries?
Yes. So this is the strength of Article 12B, that the decision of which treaty to enter into is left with the country. And now, of course, the question is, can Cambodia really negotiate with China or the UK or the US? And of course, that's not easy and that's very difficult. But it also depends on how Cambodia approaches this. So I just give a disclaimer, the tax world is opposite from the trade world in the sense that in the trade world, developing countries are always looking for market access. We want to export to the developed countries. And there the power is with the developed countries to open the market or not. In the tax world, it's the opposite. Here, the power of tax is always with the developing countries. We can tax as much as we want, and the developed countries are always trying to reduce the tax which is imposed by the developing countries. So in the case of Cambodia and China, or Cambodia and the US, if Cambodia introduces a digital service tax, keeps it out of the income tax law, so the tax treaties cannot apply. If they introduce it into the Finance Act, as Gayani was saying that India, Nepal, and these countries have introduced a digital service tax outside of the income tax law in the Finance Act, if that is done and the treaties don't apply, then if China doesn't enter into a tax treaty, it doesn't include Article 12B into the tax treaty with Cambodia, it is the Chinese companies and the UK companies and the American companies who will face double taxation. Cambodia will not lose anything. So if Cambodia doesn't include Article 12B, no problem, it can still collect taxes. Yeah.
Is market exit by platforms in particularly not valuable countries, like on a per user basis or on a gross per country revenue basis, a risk in this scenario? Take a country like Niue or Vanuatu or something like that, right? If the transaction costs are that high in compliance, would this company stay in? Is market exit the other risk? That you said there is no cost. Is that a cost?
I mean, I didn't mean to say there's no cost, of course. I meant to say that if Cambodia says that we want to introduce a tax treaty with the UK and the UK refuses, then if Cambodia introduces a digital service tax, keeps it outside of the income tax law, then they will not lose anything by that. It will be the UK companies who will face double taxation. So, and I didn't mean to say there is no cost. Now, on this risk that if Cambodia introduces a digital service tax, will the American companies leave Cambodia? So far we have seen digital service taxes have been introduced by many countries. I mean, 3 East African countries, for example, Kenya, Uganda, and Tanzania, the heads of the revenue service passed a resolution that we will all introduce digital service taxes with a 5% rate. Yeah. And I mean, so far we have not seen this evidence anywhere. We have not seen this evidence anywhere that companies have pulled out in response. The threat that is usually given and usually not followed up on is that they will pass the costs on to the consumers. But as I said, even that, there is very little empirical evidence that this is a standard practice. I mean, it seems to be more of the exception rather than the rule. And also, if you remember, the business models of many of these companies is, I mean, they burn a lot of cash. I mean, they are predatory companies looking to just destroy their rivals. So oftentimes they are just going with a cash burning approach, So it's not that profitability is like the foremost consideration on their minds all the time.
Yeah, so sort of dynamic effects of driving others out of the market and so on. Okay, let's bring in Matthew. Now, you have taken an interesting approach and you have this dual role. Can you tell us about the digital services tax that you did impose and what your approach to the OECD sort of, has been, so that the audience understands, faced with the real choice of doing something now or waiting, what your thought process was?
Thank you very much, Hilani, and good morning, Abdul and all colleagues on the call. I think we are having a very interesting conversation, which I hope is going to help our colleagues all over the world to make a choice. Now, to start with, Nigeria does not have a DST. We do not have a digital services tax. So I think, so that we are clear, what Nigeria has is a nexus rule that connects businesses of non-resident persons to Nigeria for tax purposes. And that gives the country the opportunity to bring the income or the profits arising from transactions done without physical presence to tax in Nigeria. Now, if we come back to the basic, we should ask ourselves, what is the problem that we're trying to solve on this issue of non-physical presence of businesses, which we call high-tech and all of that. It all has to do with being able to bring the income in respect of transaction done in a country to tax. Before now, and when I say now, I mean before the advancement of technology, businesses could only be done if the companies or the firms are physically located in a jurisdiction. And so you can see the business, you can see the premises, you can see the officers, the staff, and then you can see the goods or service. And then you can easily bring such to tax. However, with the advancement in technology, it is possible for a surgeon to be in one country and a patient to be in another country, and yet the surgeon will perform or carry out surgery. This was unimaginable 50 years ago. And so question then is, where does the income arising from such service, where should it arise? Should it be taxed in the place where the surgeon is staying or where the patient is? That had always been the problem. And now the approach of both the UN and the inclusive framework is to bring in some supposition, and which, just like Abdul said, in respect of the UN treaty base, it's difficult a little bit for many developing countries to implement, and that is because they don't have that many treaties. Then secondly, it is doubtful if Nigeria, for example, is negotiating treaty with the United Kingdom or with US or France, that the France or those countries will accept to have Article 12B as an article in the tax treaty. So it's almost an unsurmountable challenge. But even then, if you succeed in doing that, if you don't have a domestic legislation, then you still cannot operate that provision. Now, with the inclusive framework option of Amount A, we all know the challenges, not just the complexity, but we also saw a lot of elements that we believe are not working in favor of developing countries. And so the option Nigeria has taken is to say, look, what actually is the problem? The problem is I can't see these people, but I can feel them. I can see the businesses they are doing in my country. And so we therefore used the option of looking at significant economic presence to say, look, if you have enough transactions in my country and we have threshold and has exceeded this threshold, even whether or not I can see you physically, I would deem that you are in my country, and the income arising from that transaction will be taxable in my country. And that is what we have done. And this is not limited to digital services. It includes other services, management services, technical services, and all of that. And it is non-discriminatory. So it's not targeted towards any specific company or country. It is anyone who fits into the definition that we have. So that is the approach Nigeria has taken. And I can say clearly that it has worked for all, worked for Nigeria, and also worked for the businesses, because we also have simplification such that they don't have to go through very complex process of filing returns and all of that. So I hope my comment is useful. Thank you very much.
Yes, yes. Thank you, Matthew. Just to clarify, what is this test of significant market presence in your case? And how do you actually monitor that, I suppose? Because implementability and monitoring costs are the other side of sort of getting the revenue. Can you give us some thoughts about that?
Yeah, sure, certainly, Ilani, and thanks. Monitoring and putting values is actually not difficult because we have the financial intermediations there. If someone sits in one village in Nigeria and is transacting business with a company that is based either in the US or Russia, has to pass through a financial institution. Payment has to pass through our banking system. And so from there, we have a hand and we can see that. But beyond that, and in fairness, quite a number of the businesses are also people of goodwill who on their own, with proper engagement, are able to self-declare, to say into your territory, this is how much transactions we have made, and this is how much. So it is both ways. We are able to get data from our financial services, and we also have the businesses who have come to self-declared on the basis of the law that we have enacted in Nigeria.
We had a forum with about over 100 government tax officials, I think, last month. And it was interesting, both India and Nepal had imposed digital services taxes in country, but both said they're taking a very light touch approach because they do really want to sort of encourage compliance, but are not really triangulating with all other transactions which they can use across the financial sector, various other ways. Is that Nigeria's approach as well?
Certainly, the intention of Nigeria is not to strangulate businesses. It is just to ensure that taxes are paid where business transactions are carried out and where income or profit is arising, which is one of the reasons why we had to adopt simplification methods. And we also have adopted rates that, that will not significantly affect the profitability of the businesses done in Nigeria. And so, yes, I would say the intention is not to strangulate business. We do not want to stifle businesses growing up, particularly those in the technology sector. And so, but then everyone still has to pay the fair tax.
Great, thank you, Matthew. I'd like to bring in Victoria from the Asian Internet Coalition. So you, in a way, are sort of an industry body for the big platforms that we are talking about today. Are you of the view that countries should sign up to the OECD Amount A multilateral convention? Why? And also, could you talk about the cost of compliance of the various options that seen from the big tech platforms?
Sure, absolutely. And good afternoon, everyone. And thank you for having me here to speak today on this important issue. Yes, as you mentioned, as part of the Asia Internet Coalition, we represent multinational companies that we're talking about here today in this discussion around taxing these tech titans. And, you know, I just want to kind of give a bit of a brief overview of the digital services tax landscape in Asia. So when we look at this landscape, and indeed globally, it's clear that there has been, you know, evolving digitalization of goods and services. And we recognize the need for governments to raise revenue, especially in the wake of the COVID-19 pandemic and the fiscal squeeze that Halani mentioned earlier. And in Europe, we've seen several countries passing DSTs, and while others in Asia, such as Malaysia, India, and Pakistan, as Gayani referred to, have introduced taxes on imported digital services. And I think, you know, as was alluded to again in the introduction, these DSTs vary in their scope and their application. And while some countries tax only specific digital activities, others encompass a range of digital services. But these DSTs can, as you just mentioned, have some potentially harmful consequences. They may distort market behavior. They could potentially pass on costs to the consumers and cause double taxation. So countries have kind of experimented with these taxes in the absence of a global solution and as the second best approach. And one of the things that we tend to do as part of the Asia Internet Coalition is go to governments by presenting industry best practices. And one of the ones we use is often the G20 and OECD inclusive framework. So in the context of this discussion, around Pillar 1, just to be clear, it aims to ensure that profits are taxed in jurisdictions where consumers or users are located. So referring to this surgeon patient analogy that Matthew just mentioned. And also, as Abdul mentioned, the Global South is put in quite a favorable position. It holds a lot of power as there is a huge proportion of the consumer bases of these MNEs in the Global South. So if I think about, whether the question that you just asked me around whether big tech companies are of the view that countries should sign on to the convention, I think that the framework offers a comprehensive and inclusive approach to international taxation that holds substantial benefits for various stakeholders, not only multinational companies, but also, some for the Global South and the digital economy more generally. But I think we also recognize the need to tailor tax policies to the unique economic, political, and administrative landscapes that we're talking about here. So for the Global South, I think a couple of the positives that we want to call out are, the redistribution of taxing rights, promoting revenue generation in developing countries, and addressing the problems of profit shifting and tax havens and harmful tax practices, which have historically disproportionately affected the Global South. I think for multinational companies, which is obviously, the industry that we represent, the framework offers clarity and consistency and also transparency in international tax rules. It minimizes tax arbitrage opportunities, and it also reduces this risk of double taxation, which I just touched on briefly. It also promotes responsible tax practices from the multinational corporations as well. And I think this is something that countries and consumers are starting to expect of companies as well. And lastly, just for the digital economy more generally, the framework addresses some of the unique challenges posed by the digital age. We're seeing huge developments with relation to artificial intelligence, which I'm sure has been a topic of conversation throughout this forum. And we're seeing that this framework can provide a bit more of a predictable and efficient global tax system for the digital economy and its technology companies.
Thank you, Victoria. Now, if I were a skeptic, and I'm not saying I am, this could be viewed as a way for the big platforms to just overall pay less taxes because the numbers being talked about are quite low as a global taxation rate. Mm-hmm. And if I were a real sort of negative thinker, again, I may not be, I would think there's no incentive for the US to actually let the OECD agreement reach anything. That's what we saw last year. How would you respond to these two statements?
Yeah, I think that's a valid point, and I think around what Gayani also mentioned around sort of these implementation delays and sort of the moving goalpost, which we're seeing with this inclusive framework. It's completely valid for countries to sort of call into question whether this will actually be implemented. But I also think that it's important to recognize that this is an incredibly complex framework that's been put together, and one that is trying to achieve global consensus and is a major step forward in international tax rules. And a lot of the work that they've been doing is around, gaining stakeholder input, not only from the countries that are represented by, in the inclusive framework, but also from the industry, from trade associations like ourselves, from NGOs. And this is a really lengthy process, but it's ultimately crafted with the view to create long-lasting rules and avoid unintended consequences as well of these rules. So, yeah.
Abdul, you're on the other side of this debate. How do you react to what Victoria is saying?
Yeah, thank you, Gani. I'll give the background of sort of the context we find ourselves today. This negotiation on the digital economy has been going on since 2013. So it's been going on for more than 10 years. And actually, the digital economy is part of BEPS Action 1. Out of 15 actions under the base erosion and profit shifting project. And, the negotiation would have gone on till the end of time, because that's what the Americans, especially because most of these companies are American companies, that's what they wanted, that you keep talking, keep negotiating till the end of time and beyond. So the only reason why things have come this far is because countries began initiating national measures, or as they are called unilateral measures, but all tax measures are basically national measures. It's only when countries began introducing digital service taxes, including, I repeat, many OECD countries, UK, Italy, Spain, France, and Austria and whatnot, they all started introducing digital service taxes. Then finally, the Americans came to the negotiating table and said, okay. And grudgingly, they agreed to redistribute 25% of residual profits, which are defined as profits above 10% of revenue. So that's a very high threshold in practical terms. So only national measures by countries brought them to the table, and only continued national and unilateral measures will actually make this thing see the light of day. The Americans have not even agreed to share tax information. I repeat, the Americans have refused to share tax information on a multilateral basis. They have not signed up to these exchange of information agreements, the MCMAA and whatnot. They have a history of wasting people's time negotiating these multilateral treaties and then not signing them. So even the BEPS multilateral instrument, which would update tax treaties to implement some of the minimum standards, they have not signed. So when they have not agreed to share tax information, can you expect them to agree to share the tax base? And it is extremely unlikely. And I would say Victoria was talking about predictability and certainty. If there is one thing which is predictable and certain, it's that the US will not sign this agreement. And based on the current agreement in the July outcome statement, if the US doesn't sign this MLC by the end of the year, then countries can and should actually go ahead with national measures. And in terms of the revenue potential, and I'd just like to add another point on that. The companies, they tried very hard, to stop developing countries from initiating digital measures. Then they found out that countries are going to go ahead and there was nothing they could do to stop them. So then the next best thing was to come up with this so-called multilateral approach, which would basically force everybody to bring in a tax which would tax them as little as possible. So that is the key motivation behind this narrative which we are seeing, basically. Yeah.
Matthew, you've done a sort of a national level taxation regime. If and when the OECD optimistically treaty is signed, whenever, are you broadly aligned with that? You have elements of that, right? I mean, significant market presence, for example, is a feature of the OECD. They're not taxing everybody, the large companies. Because you have now sort of committed to the OECD protocol, basically, yes?
Again, for clarity purposes, Nigeria had been part of the discussions since 2014, from the time of BEPS 15 action points. And Nigeria is in alignment with quite a lot of the outcome that is out there. Now, as regards the current two-pillar solution, Nigeria has also been part of the discussions from the beginning, and we are still part of it. But you may remember that in the October 2021 statement, Nigeria did not sign on to that political statement. And that was because we had serious concerns with quite a number of the elements in the rules, particularly as regard Amount A. And my government has not changed that position even now. Of course, we are continuing to engage and be part of the discussions and the negotiations, but the decision taken by my government in 2021 had not changed.
Thank you. Alison, you've been sitting and listening to this. People who work in tax and the people who are going to have to pay tax talking about it. You work in majority world countries, mostly many poor countries, many emerging economies. From a social inclusion, equity perspective, what are your thoughts? From a capacity to get this done, what are your thoughts? And really, if we are ever lucky enough in our countries to get some revenue, what on earth is going to happen to that money in the kind of regimes that we live in?
This is a good 3-hour discussion, I think. But thank you, Helani. I will come to those bigger questions. I just wanted to say how important it is to be having these discussions, and that we've been doing this research over a period of time, because the complexity of, particularly with these intensifying global digitalized services and things, have made the tax issues, far more complex. And a lot of the arguments that were made around maintaining or reducing or just controlling local taxation on, for example, telecommunication operators, so that they could roll out those networks and reinvest in those networks and compel them to reinvest in those networks, or the failures of secondary taxation through universal service objectives, because in fact those weren't being rolled out, and the arguments that kind of let these services drive themselves more affordably and get that take up, and then you'd be able to tax corporates and people who are all going online and doing that sort of thing. So those arguments, were made from a very pragmatic point of view, acknowledging, and our work's all in Africa, the incredible constraints there are in revenue generation on the continent. Many of these countries, the mobile operators were primarily the tax base for the country, with a tax base of 1 or 2% of the population. So those arguments are very different from the arguments that we were having even 10 years ago, or maybe 8 years ago, around the end-user taxes that were coming with social networking, that was these over the OTT services that were coming on top of the telecom operators were. And there was, of course, a lot of argument around revenue share with those operators themselves, and issues of local competition and all of those things, which I think are completely pertinent to this discussion. I think what's really important about these discussions is that they're not just taxation discussions, that we're actually understanding the implications of taxation on trade, trade changes that are happening, on competition issues that are arising, because at the moment that policy is being done in a very siloed way, that goes to the issues of national sovereignty, but actually the kind of various imperatives, development and economic imperatives. The fiscus is looking very strictly at kind of maximizing revenue. The digital department, or comms, or whatever it is very much looking at kind of digital universal service and those kinds of things that would actually drive economic growth, but they're often not talking to each other. Trade is going off and doing a completely separate thing, possibly with some kind of alignment on tax, but not much else. But then we had the social networking taxes, and these were enormously regressive taxations on end users, introduced in some of the poorest countries in the world primarily, with actually very counterproductive effects. So, if you look at Uganda, for example, they were introduced at a time to have a sovereign debt repayment that was needed. So the poorest of the poor, who were on these social networks, were actually pushed off the networks with these 1% taxes on each transaction, on mobile transactions and those kinds of things. Not only did it actually undermine their Digital Uganda program, Universal Service Program, but actually it also made the telecoms operators less profitable. There was enormous loss of revenues from them, from corporate tax. So the long-term effect has been quite negative. And then it's overlaid with a political agenda. So the actual gazette, the regulation that refers to this, it says it's also trying to stop social gossiping, online gossiping and that sort of thing. And around a time of political dissent. So, I mean, you're getting a whole lot of really irrational reasons for taxation. So that we've made a very strong argument to get not taxing end users of these digital services. You're not taxing the titans. You're not taxing the people who should be paying for these services. And so often now the discussions around whether countries should be signing up to the BEPS and at least getting 15% of those big tech companies amongst multinational corporations that we have not been able to tax because of the lack of presence in country, to use this mechanism to at least get that 15%, which would be very significant in many countries, even with the low internet penetration rates and those kinds of things. And ideally releasing these end users from those kinds of taxes. And yet some of the people who, as I said, because this is complex and there's not an understanding that the social networking taxes in these countries at the moment, mainly in East Africa, are, but very attractive to other parts of the continent, are actually end-user taxes. There's now often been a kind of a knee-jerk reaction to taxing digital, digital companies under the BEPS regime, the base erosion and profit shifting regime of OECD's proposed regime. Is, we mustn't tax them either because it's going to affect, Facebook's going to move out of, Africa or whatever it is. And I think, we really need some complexity because I think we're all advocating for the same thing, but we need to understand those linkages, and how this whole ecosystem works. And as I said, not only within the digital sector, but affecting these other sectors. And so this work was really done in the context of trying to understand trade and taxation issues in Africa. Several interviews done with many countries, including Nigeria, and working, well, not working closely, but following the work of the African Tax Administrators Forum, who obviously represent the interests of many tax administrators across the country and therefore had to represent the position on unilateral taxation. I mean, country like South Africa, for example, corporate taxation is a minimum of 35%. Many of these other companies looking at higher taxation rates. So an offer of 15% is, just doesn't look like very much at all. And it has an effective tax regime, a collection regime, etc. So it is, I think it's very different for different countries. As I said, I think it's really important that one understands the different dynamics in these contexts. So for in the African context, besides the issues of sovereignty, is that I think, as Abdul was saying, pointing out, many of these treaties are limiting and binding. They're not seen as opportunities to actually be accessing that extra 15% or something. So this paper that, we interviewed a lot of people, and there was a lot of feeling that people, the fiscus would never give up the little hold that they had on something in order that they would get something bigger, or get something later on. And certainly didn't want to be tied into these moratoriums, which we're seeing anyway, from the trade agreements that are impacting on revenue generation. So I just wanted to say that was a kind of work that's been done a lot in Africa, but we've also done very important work, I think, with Learn Asia and with IEP, across the issues that I think we really need to understand where taxation fits in. Really looking at the interplay between digitization, increased visibility to the state formation, revenue generation, taxation, redistribution, because I mean we need those taxes to do the redistributive work that we're wanting to do post-COVID, well, during COVID and of course post-COVID around economic reconstruction. And that paper is actually out, being launched today, so please do watch our Twitter feeds for that, because I think the visibility that's coming through digital transactions has implications that can be used positively, both to for people who currently might not be paying legitimate taxes to be more visible to the state, but also for informal sector who have often not been able to be the beneficiaries of redistributive programs because they're not visible, now being increasingly visible through tax, and obviously don't qualify for taxation, so they'd be visible, but from a tax point of view, but they wouldn't qualify unless they do qualify for taxation, but then be visible in the social protection realm. So that's, I think, an important side from the ongoing post-colonial struggles around state formation in many of our countries, and the need to have the revenues to build those institutional capacities, and some of these really big development challenges that we face on the continent. But I think, as I said, I think specifically in terms of the taxation issues and the trade issues that are going on now, I think, well, the whole BEPS process was actually an acknowledgement of how outdated these tax systems are. But it's important to notice that the foregone potential revenues for states, particularly in the context of the pandemic, as I mentioned, and economic reconstruction, but it's compelled us to look at updating the tax system, of engaging in these various processes, and better representing our interests, which I think we've not been effective as regions, as the global South. And doing this kind of research to inform a more integrated position for countries and regions to take is very important. For Africa, I think the situation is even more precarious. As I said, very fragile or non-existent tax systems in place anyway, largely dependent on aid and with all the associated issues that raises for political economies. But then we've also got these big continental and international trade issues where we are seeing enormous amounts of foregone tax in agreements. So the African Continental Free Trade Area, which has come into force, although it's not operational in many ways, but there is expected to be a significant drop in conventional physical trade, although I should say that there's a sad amount of intercontinental trade anyway, so a lot of our trade is actually outside, but that will have significant effects, especially for those countries who are not highly digitized, not leading these digital services, spreading out throughout Africa. And as these trade barriers begin to ease across the region, and e-commerce is taking off, and the protocol, the Digital Services Protocol, is just being negotiated right now for the African Continental Free Trade Area. We're going to see those kinds of impacts of a digital single market on traditional trade taxes that have been there. And so this really makes this, this assessment of aligning, positioning our local tax regimes on the continent, some kind of harmonization we'll have to have in terms of the Continental Free Trade Area and the digital services underpinnings of it, with the international tax regime, because these are essentially, global digital public goods that we're very often talking about, data flows and these kinds of things. And I think, historically we've looked at global governance from a kind of harms and protection point of view. We've looked at, from a kind of trade and digital services and e-commerce point of view. But the taxation component of this, the actual generation of revenue for countries in order to service their needs. And I think, historically we used to be, don't put a secondary tax on telecom operators unless it goes back to the digital industry, because otherwise we never see it. But digitization is now so cross-cutting that it's absolutely appropriate that if proper taxation of, the extraction of data and stuff that's coming in, across sectors in Africa actually is used by governments responsibly to service their populations. And so, as I said, I think although there's been a strong feeling from our research that people will continue to pursue unilateral regimes while these other agreements go on, the World Trade negotiations, for example, with a moratorium on taxation, effectively on various mechanisms, while the e-commerce protocols are negotiated, and now that they've been so protracted, has been a very negative signal, not necessarily incentive, but signal to those other countries who, by and large in Africa, have not signed up. or to the BEPS for that matter, if they're continually pushed out, because they put into such a negative position in the interim with having to, have moratoriums on these things. So I think these are absolutely critical aspects, and if you're discussing the global international tax, you need to be looking at that in the context of a country where it's being used on end users, on poor people, effectually a very regressive tax that is, they're being taxed anyway, but in a very negative way. Rather get that tax from the people who are becoming, the wealthiest in the world, and allow it to be more effectively redistributed to meet the needs of countries.
Thank you, Alison. An interesting point you bring about the attractiveness of at least getting the 15%, even though you might have other options to get a lot more, but if you sign up with this, and if this comes to fruition, the BEPS or the OECD might give you something, whereas other option might maybe nothing or a whole lot, right? Okay, we are happy to open up to comments, thoughts, as well as questions from the audience. I know it's a bit of a, esoteric and complex issue. You can do it online. You can come up to the, we've wonderfully set up mics. If you would say your name and organization and either ask a question from one person or give your thoughts, or anyone.
Hello, good afternoon. My name is Mwendwa Kivuva from Kiktanet, Nairobi, Kenya. And Kenya is one of the countries where digital taxation has been introduced. And when digital taxation came, actually, it had mixed reactions. Some organizations pulled out of working from Kenya. For example, some cloud service providers, they terminated services, and users who were hosting their content in those services had to look for alternative places to host their content. But of course, others, for example, Netflix, actually reduced the cost so that they can have critical mass of users joining the bandwagon. So we are wondering what is the balance that countries should take, because as has been rightfully put, that organizations, countries need to survive, and the only way governments generate income is through taxation. So the local regime, the local government say that foreign organizations cannot just go to developing countries and extract resources, and there's no benefit that is put back to the economy. So what is the balance that should be put in place so that probably there is a sweet spot for both? And number two, what happens when these organizations, the foreign organizations, don't respect the jurisdiction of poorer countries? So for example, they still continue extracting resources and they don't want to pay taxes, because our tax regime is usually voluntary tax regime. So when these orders have been put in place, or these laws, but these companies are still not obeying those orders. So at Kiktanet, actually, at the end of this month, we are holding a session in Nairobi on digital taxation, and this is actually from requests from multinational companies, the big techs. They are saying that the tax regime has become challenging and also expensive to comply. So they want us to engage the stakeholders, the public, and the government, so that there is a common understanding on these issues. Thank you.
Thank you for that question. I'll actually let anyone from the panel respond. Abdul, Matthew, Victoria, Alison, and Gaini.
Yeah, thanks, Eleni, and thanks for the two questions. I think the first question is a policy issue of government in striking a balance between investment and generating revenue for government. And it is important that in aiming for where to put the dots, the government would need to consider a whole number of things, which should include what minimum level of revenue is required to run basic services, and also to also understand that we can't tax businesses out of existence, because if you do that, it's like you killed the tree and then you can't come around the next year to get fruit on it. So this is where the delicate balance is, and that is where based on the various options. I mean, if you are listening to Guyane in our opening presentation, I've given a spectrum between domestic unilateral actions or measures and multilateral measures. So you should be able to find somewhere in between where you believe you are able to strike the balance. But then there is no silver bullet that works for everyone. Every economy has to determine what works for it. And then as regards measures to ensure compliance, I think the starting point, and I'm happy with what Kenya is about to do, is to engage. One of the things Nigeria did in 2019, after we enacted the SCP rule, was to engage with various stakeholders, and surprisingly, most of the non-resident suppliers to Nigeria were willing to cooperate and collaborate with Nigeria. So I think engagement is one big route. Second thing is to also ensure that there is simplicity in the rules and that people are able to comply with minimal costs. Thank you very much.
If I could go after Matthew, Helen, if that's okay.
Yes, please go ahead.
Yeah, okay. Yeah, thank you, Mr. Gubanjubola, for that. I just have 3 points on the questions raised by the gentleman from Kenya. One is that, to my knowledge, Kenya initially introduced a digital service tax which applied to both residents and non-residents, but then later on they restricted it to non-residents. So it's only the foreigners who now have to pay the tax. So that option is always there with countries. Second point is that on extraction, in the digital economy, you can really see extraction in a raw form, because the classic argument that if you have taxes, then investment will go away kind of breaks down when we look at the digital economy, because these are not coming with money to set up a factory and hire local people and create jobs. These are by definition companies. I mean, as in the case of Uber with Sri Lanka, they have literally no physical presence over there. The only jobs which are being created, so to speak, are the Uber drivers who could get those jobs even from PickMe and other local companies. And in the case of online advertising companies like Google and Facebook, then you can really question, what is the actual investment coming into the local economy. So this argument that raise taxes, investment goes away, should be seen very differently when it comes to the digital economy. And we can really see, as I mentioned, extraction in quite a raw form. The third point, which the Kenyan gentleman had spoken about, was non-compliance. One option which is there for countries is what Pakistan has done, which is where they have told the banks that you collect the taxes of withholding and give it to us. So in the case of Kenya, for example, the company has to on its own come and pay the tax. And, of course, if they don't, then there are compliance issues. But there's always a Pakistan approach where the banks withhold it, so the company basically gets, gets the balance. Yeah.
Victoria, anything to add?
Yeah, I think if I can jump in here, I also want to reiterate the point that Matthew made around the importance of stakeholder engagement. I think it's hugely important so that both the government and multinational companies can set expectations. But you said that companies came to you with some concerns around the complexities of the arrangement that you have in Kenya. And I think this is where global tax rules can come in to reduce the complexity and uncertainty faced by MNEs due to sort of varying tax regulations and to sort of facilitate more transparent and predictable tax governance for them, as well as simplifying compliance by providing more standardized and consistent approaches to allocating profits. And this is where MNEs can more easily determine their tax obligations and ensure compliance across multiple jurisdictions.
Alison, Gaini?
I can just respond on a softer approach on the second part of the question, on what if the companies don't want to pay taxes. And I just want to reflect on a conversation that we had with the Nepali and Indian authorities when we had our forum a couple of weeks ago. And what those tax officials said is that so far they've had the companies actually playing ball and paying taxes, though they've taken a relatively light touch approach, like Hilani mentioned earlier. So so far they've had little issues, but the light touch approach was key. But the question really is this dynamic going to change if and when the Monterrey Convention comes into place? Because then there's an alternative. So these are also questions that we'll have to keep asking, in whether the sort of answers that we're giving today also continue to be sort of static and stagnant, or whether those also will change over time.
So I think that was just one of the points I wanted to make, because I think one of the issues you are speaking about, and I think one of the issues that have come up here, are really the issues around being able to tax the big tech companies in our context that don't have presence within country. And you're saying, oh well, they're playing ball. As they should. If you're looking at the kind of super profits that these companies are making, the kind of gratitude that actually they're contributing to these taxes just seems to be, it's really not addressing these kind of bigger problems. I mean, I think, yes, we must take and get that it must be fair, it must be transparent, but in fact, although the kind of agreed international formula on this would make things clearer, it's not worked in the favor of some of those countries. So we really need to, and we've got, the US holding out on things. So, unless everybody kind of comes to the table and we agree on it and it's binding on everybody, it's never going to get the kind of traction that we're looking for.
Thank you. We've got an in-person question. You have a question as well. We'll take 2 questions very quickly with very short answers.
Okay, hi. So excellent panel and excellent discussion. I'm learning quite a lot of things here. I'm Bagisha. I'm a PhD scholar, and I work with Internet Governance Project at Georgia Tech. Now, what I'm going to ask might be a little bit more fundamental because I'm still learning about digital taxes, so please bear with me. I am struggling to understand how the calculations of profits are done, or how the calculation of tax itself is done, in sense that I think Abdul mentioned initially about revenue from profits for services. It's easy when you have to calculate it for Netflix or something because you're paying for those services, but how is it done for a service such as a social media website where we're not directly paying for anything, right? And I think you also mentioned about how this trickles down to something that a user ends up paying for a Netflix or another digital subscription services. So just more fundamentally on how does one conceptually think about this? And yeah, that's about it.
Thank you.
I'm Kosi Amesinu from Benin. I'm from Ministry of Economy and Finance. It's not very clear for me now. Facebook is not physical in Benin, for example. But many people using Facebook service, how can we tax Facebook? Please make me information detail by detail, step by step, because my minister are waiting for that. Thank you.
There's also a question online. My name is Kunle. My question is for digital companies. How do you quantify how much they are to pay based on the fact that most of them are operating remotely? You're getting at this. So, I mean, this has to do a lot with what are the costs Facebook, what is the cost and revenue of Facebook in a country like yours? Advertising revenue and subscriptions like SMEs pay, you know, to have a certain type of page. We might buy advertising space to announce that, I don't know, we're running a conference. Hotels might buy advertising space. What are their costs? Our marketing, maybe some allocation of the policy staff, the marketing staff, which might be per country or shared across countries. I mean, those are the types of costs and revenues that these companies have, even if they don't have a presence. If they have a presence, then of course, there's sort of, you know, infrastructure that they run and so on, yeah? So I'll take a very quick set of responses, like really under 1 minute from the panelists, but I am going to put you in touch with Abdul so you can have a longer conversation, because I think that is important part of what we were really trying to do with the panel. This is one of the first panels at IGF, and I've been coming since 2006, that's really trying to get at some of the detailed elements of this. So we need to have a much longer conversation, so we will put you in touch. Reactions from panelists, please. Thank you.
Thank you, Helene. I'll just respond to the gentleman from Benin. I would say, sir, please look at the equalization levy of India, where they basically started out with a 6% tax on online advertising, which was targeted at Facebook and Google and these kinds of companies whose main revenue stream is from advertising. Broadly speaking, tell your bank that if somebody in Benin is paying Google for online advertising, then introduce a rate of 4 or 5% or whatever, and tell that bank to withhold that percentage as a withholding and keep it as a withholding tax. Whether Facebook or Google are there or not in Benin, that doesn't matter. The money will be restricted from them when they receive the payment, and they will be forced to come and file the tax return. And if they don't, well, that's their loss.
So before the money goes out of the country, the financial institutions are legally obliged to have a withholding tax and then remit it back to the tax authorities, what Abdul is saying. Anyone else wants to respond? Or we can go to our last sort of rapid fire. We've had very sort of, you know, interesting, there's some convergence, right? Abdul is basically saying national levels taxation is important because that is what actually brought the US and other people to the table. And we need to do this. It is also a matter of national integrity. There seem to be outs if, you know, somehow we have a longer term, you know, sort of country treaty option. Matthew is broadly, I think, along those lines. He's gone for an approach that somehow sort of, I think the devil is in the details, which, you know, we really do see. He's sort of had a threshold, so the smaller guys are not really impacted by this, but still has a mechanism to get revenue. Victoria is saying, I think, that this is sort of the OECD option is really a viable one. Compliance becomes easier. And related to that, Alison is actually saying that, you know, the countries stand to gain something because it's sort of like you can free ride along with this if this treaty happens, right? So it's a really interesting negotiation position of what the long-term game is and what might be the short-term approach that countries use. So we don't have conclusions. I want you to say in, you know, a sort of a 10-word tweet, Abdul, Matthew, Victoria, Alison, what countries should do, and then we're going to run a poll asking you in the audience what countries should do. So let's get the Slido up, but let's start with Matthew. Very quickly, what should be the approach of developing countries given these options? Should they sign up for the OECD treaty and wait?
I would say that developing countries should look very clearly, read between the lines if they intend to sign, and to be sure of the specific impact on their revenue.
Okay, so you're saying, I don't know, but look at it closely. Abdul.
Wait for the US and other OECD countries to ratify Amount A before thinking of how to proceed.
Okay, so don't commit until US and other countries ratify. Victoria.
I think that without a global consensus-based solution, the risk of further uncoordinated unilateral measures and retaliatory trade sanctions is a real concern.
So you're saying, yes, please sign up for the OECD. Alison.
Yes, I'm also saying sign up for the OECD, but very conditionally.
Yes.
I think that if enough countries sign up and there's enough pressure put, then there's a kind of block that can actually force these percentages higher so that they begin to align with what corporate taxation would be in their countries. And maybe that requires a digital multinational corporation pull-out of the 15%, because obviously that's not applicable to big, multinational corporations that just aren't these big giant monopolies.
So conditional, yes.
Yeah.
Gaini.
No, by the end of 2023. So very much like what Abdul is saying, because
Don't sign up to the OECD
only
for now.
30 countries, and with 60% of the market share, need to sign up. Global South doesn't fall into that basket, so it's not necessary. They can wait and see.
So
and
we can
sign up
free ride
later.
essentially and wait for them.
Exactly.
Okay, excellent. What does the audience think? The Slido is gone. Could we please go to... You have to connect it. Okay, slido.com, and the number for the poll is 2823924. Should countries sign up for the OECD Amount-A multilateral convention by the end of 2023? Half of the audience says no. Interesting. So close to a split opinion, I think, given the small sample size. 42% saying yes, and just under 10%, oh, okay. More moving towards no. This is a live situation, but still around 8%, I don't know. Okay, so I think it's quite close, which thinks, it's a good thing. We need to keep engaged on this. Thank you, guys. Thank you for staying. We're just on time. Thank you for the questions and the audience and the really good panel engagement on this. And we'll hope to see you next year with a much more sophisticated understanding of what we should do. Thank you.
Tô entendido. Eu fui tático igual Alisson. Mas eu até quero pedir para ela. 待会儿走着找是不是？Protection? No, that's my notebook actually.
Okay. No.
I think that's the point. How you combine those, right? Especially with what is the purpose of texting? If not to enable those qualities.
Hello, hello. Dr. Gong, are you here?
，Zoom。
Hello?
啊
Hello, could you hear me?
哎，龚校长，Hello,
哎，
Dr.
你
Gong.
好。
Okay, okay. Our workshop will start at
Okay.
at 15:7. Okay.
Let me try share my screen with my PPT file.
Okay. Okay.
Okay. Can you see my PPT?
Yes, yes.
And does it
You can-
move?
Sorry? Yes, it's okay.
It works? Okay, that's fine.
Okay, okay. Dear host, are you here?
Hello, good morning. For me, it's good morning. Good afternoon for everyone there in Kyoto.
Hello, host. This is Wei. You can test your PowerPoint from your computer.
Probably you would need to give me the permission for doing so. I think it's not automatic.
那个老师可以切换到那个就是切换一下这个Can you share your computer?
No, you give me permission. At the moment, you see the green.
Yeah,
now probably
now.
it.
Well.
Fine.
Well, this works.
It
Yeah.
works.
Yeah,
Yeah,
it's
thank
okay.
you.
It works.
Good.
Hello, Kei Gong. Long time we didn't meet.
It's a long time. I'm now in Prague.
Uh-huh.
Have the same time zone with you.
Oh, good. Prague, fantastic city.
Oh, it's the first time for me to visit this city. It's so beautiful.
Yeah, it's one of the key old cities in Europe. It's really a place. I travel. It's not so far. It's 350 kilometers from Berlin, and I travel with my wife 2 or 3 times a year to Prague for events. No, it's really good.
Fine.
We have 2 minutes left.
First, you may stop your sharing. Oh,
Yeah.
fine.
Okay, good afternoon, everyone. Welcome to today's workshop, session number 147. My name is Xiaofeng Tao. I am a professor at Beijing University of Post and Telecommunications. I'm also the vice chair of the Consultative Committee on Information Technology, China Association for Science and Technology. I will chair today's workshop, Green and Digital Transitions Towards a Sustainable Future. UN's 2030 Agenda Goal 13 demands action against climate change. This requires a significant shift towards green and digital energy systems. In today's session, we have 6 presentations. Our primary emphasis will be on addressing the important challenges and governance aspects associated with green and digital transitions. First, I would like to invite our first speaker, Professor Gong, to give us the first presentation. Professor Gong is the chair of the Consultative Committee on Information Technology of China Association for Science and Technology. His topic is on the 3 musts for accelerating the sustainable and the digital dual transformations. And let's welcome him.
Thank you, Professor Hao. Now I share my screen with all of you. With my title is The 3 Musts for Accelerating the Sustainable and Digital Dual Transformations. Because the theme of our workshop is green and digital transformation towards a sustainable future. I'm very pleased to be part of this workshop because it's really important. So talking about the dual transformation, my understanding is that these dual transitions are a historical process which is crucial to the future of the humankind. These 2 transitions, I think the goal is to achieve the sustainable development of the humankind and the planet. That's the value pooling transition. And it is the digitalization, which is a very important tool for us to achieve the sustainable development. So this transition, I consider, is a technique-driven transition. So these 2 transitions are interacted with each other. They are not just a parallel 2 transitions. They are interactive. And the digitalization, very, very important tool for us to achieve the sustainability. So at first, I would like to talk about the urgency of the dual transformation, especially the urgency to rescue the sustainable development goals. So all of us know 8 years or 7.5 years, 8 years ago, all world leaders gathered together in New York has made a sustainable development agenda, which is called Transforming Our World, the 2030 Agenda for Sustainable Development. In this agenda, there are 17 sustainable development goals is defined jointly by the all member countries of the United Nations. And under these 17 goals, there are 169 targets. However, this year is the midpoint of the whole agenda. 2023 is exactly in the middle of the whole process. Last month, the world leaders gathered together again in New York to review the progress of the Sustainable Development Agenda. However, at this middle point of the 2030 Agenda, the world leaders and the world people are shocked by the current progress. The latest global level data and assessments paint a concerning picture. So this is the concerning picture. The green one shows those goals are on track or the target met. The yellow one is fair progress, but acceleration needed. The red one shows the stagnation or recession of those targets and goals. So this picture shows us only half of them show moderate or severe. Not only half of them show moderate and severe deviations from the desired trajectory. More than 30% of these targets have no progress or even worse, regression below the 2015 baseline, below than 8 years ago. So this assessment underscores the urgent need for intensified actions to ensure the SDGs stay on course and progress towards a sustainable future at all. In short, the SDGs need to be rescued. For example, just have a look to the goal 1, no poverty in all its forms everywhere. So this figure shows you if we not come back on track, there will be 575 million people will stay in extreme poverty by 2030. And here shows the current world vulnerable population remain uncovered by social protection. For example, for children, only 8.5% received social protection. For the elder people, only 23% can receive the social protection. That's why the report, the Global Sustainable Development Report, GSDR, this report is every 4 years. And the newest report is titled, The Times of Crisis, the Times of Change. So we have to realize the urgency of this situation for sustainable development and take real actions to make changes. So that's the second point that I'd like to say. The second must is to take actions of using digital technology to implement, to rescue the United Nations SDGs. Indeed, if we talk actions, people pay a lot of attention to the digitalization. Let me quote what Secretary General Guterres said in the UN summit last month in New York. He emphasized the need to take actions in 3 key areas, including addressing hunger, transitioning to renewable energy, and leveraging digital transformation opportunities. Further, please allow me to quote some words from the political declaration of the United Nations Sustainable Development Summit last month in New York. It states, we acknowledge that important lessons were drawn from the COVID-19 pandemic in health, culture, education, science, technology, and innovation and digital transformation for sustainable development. It states we will continue to take action to bridge the digital divides and spread the benefits of digitalization. We will expand participation of all countries, in particular developing countries, in the digital economy, including by enhancing their digital infrastructure connectivity, building their capacities and access to technological innovations through stronger partnerships and improving digital literacy. And it states we will leverage digital technology to expand the foundations on which to strengthen social protection systems. We commit to building capacities for inclusive participation in the digital economy and strong partnership to bring technological innovations to all countries. So digital transformation is stressed again and again in the political summit last month in New York. That shows the importance of digitalization as a lever to achieve the sustainable development goals. So here, I just show you some examples. For example, for the electrification, digitalization, digital technology, Internet of Things play a very important role to achieve the further electrification with renewable energies. That's goal 7. And for goal 9, industry, innovation, and infrastructure. Here I show you how digital big data has been used for smart manufacturing. And here is an example of a city, famous city, Hangzhou in China, because Hangzhou city, internally, in the center of the Hangzhou city is a big, beautiful lake. We call it the West Lake, but that makes the traffic of this city very difficult. And this city was the top 4th traffic jam city in China. But with the help of big data and the implementation of so-called city brain empowered by artificial intelligence, and the 5th generation of mobile communications, 5G, this city has now become the 27th traffic jam of China. So a smart city helps the goal 11, and also for climate action. Here is another example used in China to use big data to help to mitigate, to find out the leakage of the water pipes, and to help to design the city more resilient to the climate change. So just a few examples shows that how digital technology can help in different sector, in different country, in different region, to help real actions to achieve sustainable development goals. So finally, I would like to stress the importance of cooperation, because the goal 17 is the partnership. Nobody can refuse the importance of the partnership. But here, I would like to stress the collaboration should in a interdisciplinary and intersectoral and international ways. So, for example, building information modeling and the geospatial engineering is now widely used in construction area. However, these technologies are deeply rooted in different areas of engineering, such as internet, information communication technology, satellite, construction, Internet of Things, and big data, with applications in the management of resources and utilities, telecommunications, urban and regional planning, routing of vehicles, parcel shipping, and so on and so forth. They hold great potential to the support of sustainable smart cities. So all these disciplines should work together with digital technology, because digital without disciplinary border. And here I show you the China Association of Science and Technology, in short, CAST, is a platform for interdisciplinary collaboration. Within China, we have natural science, industrial technology and engineering, medical science, technology and engineering, agricultural science, technology and engineering, and interdisciplinary institutions. Totally, there are more than 200 disciplinary-based institutions representing more than 40 million scientific, technological, engineering professionals. So this platform is ideal for interdisciplinary collaboration, but also for international collaboration, because we have the consultative status to the United Nations. So we have worked closely together with IGF, and we'll try to closer our collaboration. And another example is the World Federation of Engineering Organizations. Now I serve as the immediate past president. And this federation consists of more than 100 so-called national member organizations, such as CAST is the Chinese Chinese national member of this federation. So our federation is a comprehensive engineering professional organization representing tens of millions of engineering professionals across the world. And we are keen on to collaborate with IGF in the near future more closely to work with you all together for accelerating the dual transformations towards a sustainable future. I stop here. Thank you very much for your attention.
Thank you, Professor Gong. Appreciate. Our second speaker is Professor Liu. Professor Liu is the Director of Global Change Research, Data Publishing and Repository. Professor Liu, also a professor of Institute of Geographic Science and Nature Resources Research, Chinese Academy of Science. Her topic is about open science for green and digital transition. Professor Liu, you have the floor.
Thank you. Thank you, Doctor. And I'm glad to be here and share the information with you. Just like Professor Gong said, so we are midterm of the SDGs, so we need to accelerate for the actions. So now the challenging, what the challenge is, so now we are midterm to the 2030s. So less than half of SDGs in the world realized actually. So climate change, natural disaster, and the COVID, and all impact SDGs, especially in the mountain area, in the small islands, and the critical ecosystem regions. So this is what we next step. So what is the objective next step? So the only one thing is accelerate to the SDGs. We need to focus on the effort, and we need to work together for this target. So what's the solution? Definitely, everybody has their, all the different organizations has a different. Thank you. Sorry that. So the solution is we need open science. The science is also. This one. Okay. Oh, this is challenging. I already said. And objective is accelerated to the SDGs. The solution is open science. That actually, and the technology also. But the science need a link to the technology, so big data and the Internet of Things, and the link to the engineer, not only science technology, but also engineering, and working with the cases, and not only talk, but we need to start in the even a small village. So also we need to, together with the systematic management, and then culture diversity. So this is this solution, and so we need to cooperate together, all partners. So in this idea, so we in China, we start a new project we call the Geographical Indications, Environment and Sustainability. Short name is GIES, and this is a decadal program from 2021 to 2030. So this is if we do this, we need infrastructure. So there was a background. So there is a World Data Center we call Global Change Research Data Publishing and Repository. This is World Data Center. And then open data, open knowledge, open the geographical site. Let people to visit this to understand what you are and what you are doing. And this infrastructure got a VCS prize in the 2018. So, and then technology, we need the link to the big data and the Internet of Things, and make this how the product is traceable. So we give the identifiers and the DOI and the digital object identifiers and the science and technology identifiers, and the global change data and the World Data Center IDs, and also have a trademark, the trademark, and then the quick response system, and the people can very quick to find where your product come from. And then when GIS will take a network, that is internet. We internet in the wireless and the wireless. And then we have this, then the data publisher, articles, and products, and then even local observation stations, and also the package for the product packages, all linked together. So this is a network in everything together, so you can trace where the product come from, what the quality of the product. So in China now we have, during the last 2 years, we have 17 cases in whole different regions of China. So this is, there are many different kinds of things. So rice, maize, and burdock, and apple, and many different agriculture products and high qualities also. So the benefit, so right now more than 600,000 local people farmers get benefit. They got income, more income, and then customers, for example, maize is one of the customers. We are happy we got high quality products. So because we have some little bit more money to buy that, but we have less an idea which one is good. But from this project, we can identify which one is a good one. It's wider for me to buy that, to spend money. Many people like me go that. And also contributors got benefit. Money is the scientists and the government officers got credit. And then we have how to organize this kind. So we have different partners. We have the scientific committee and the program committee and some company programs, and we work together. And then the key player, this is the Geographical Society of China and the Institute of Geographical Sciences and Natural Resources in Chinese Academy of Sciences. And then in the very beginning, we have 40 partners to join this program 2 years ago. But now we have 101 partners, organizations to join this, and they are very, very happy. So now, and this is, work is and got graded from FAO. And FAO started in the new program as one country, one priority product in the world. And then we work in the FAO. It was this, and then just a few in Bangladesh, and so several countries in Asia Pacific. We start this program, and very welcome by different countries. So also we also support not only developing countries but also industry countries. We work with the European Union. In the geographical indications cooperation, there with China has the agreement. So we have exhibitions and change the products. From European, they are good wine, and China has good tea. They change this. And then both of us need to what the data is, what the quality is, where it come from, how about the culture, how about the socio-economic development, and how make the sustainable development. So the both information can open and end. So the summary, the GIS's innovative methodology is the keyword is open science and the multi-stakeholder engagement. But open science not only science, but linked to the regional geolocation and its environment, and linked to the product value chain, and open science methodology and technology and engineering, management, and geographical culture. Thank you very much.
Appreciate and thank you for your presentation. The third speaker is Ms. Tomoko Doko, the President and CEO of Nature and Science Consulting Limited Company. Her topic is on wildlife management in Japan for a sustainable future. Mr. Doko, please.
Thank you, Chairman, for introduction. My name is Tomoko Doko, and I have a PhD degree, but I got a hunting license in Japan after that, and today I'd like to talk about something about wildlife management in Japan for sustainable future. Okay, let's talk about the general background of Japan and wildlife. As you can see in the picture on the right side, Japan's main island consists of 4 primary islands: Hokkaido, Honshu, Kyushu, and Shikoku. And there are 97 terrestrial mammals in Japan, including 38 endemic species. Endemic species means the species only exist in Japan. Like the picture in the left side, the center one is Japanese sallow. That is one example of endemic species in Japan. Let's talk about wildlife management, why we have to focus today. Because wildlife management is a management process influencing interactions amongst and between wildlife, its habitat, and people to achieve predefined impacts. It attempts to balance the needs of wildlife with the needs of people using the best available science. Here I introduce the most important Japanese law related to this issue. The official name of the law is Wildlife Protection Control and Hunting Management Act. This act conducts programs to implement for protecting and controlling wildlife and manages hunting in addition to protecting and controlling wildlife by preventing the risks related to the use of hunting equipment. There are 3 main components related to this act. The first one is control of population. That is the main purpose of today's topic, related to that we need reinforcing capturing. Second component is management of habitat of wildlife. The third one and the last one is countermeasures of damage prevention. Today, I introduce 2 species of Japanese mammals. One is shikadeer and another one is wild boar. Those 2 mammals make troubles in Japan. And what kind of troubles is, for example, in the crop damage. Another example is forest area damage. Both shikadeer and wild boar make significant damage in 2 domains. This is just example of the picture how the shikadeer make damage to cropland or forest. The geographic distribution of 2 species become a critical problem in Japan. As you can see in this graphic, from 1978, both species tended to have expanded their geographic distribution. Therefore, Japanese government decided to change the law. So revision of the law was done in 2015 and new goal was set up. The background why we need to do that is negative impact of ecosystem and crop damage by shikadeer and wild boar has become more severe and we can't ignore anymore. And people who can do population control of shikadeer and wild boar has become reduced due to hunters' population decreases or aging. Therefore, new system of certification of wildlife capture program so that the government can reinforce more capturing and grow up next generation of hunters is implemented. And Ministry of Environment and Ministry of Agriculture, Forestry, and Fisheries did set up a new goal, that is, by year of 2023, the government of Japan aims to reduce the population of shikadeer and wild boar to their half of the one in the year of 2011. This is the structure of the act, and due to the time constraints, I focus on the second component, what is control of capturing wildlife. As you can see in the illustration, shikadeer and wild boar are designated as wildlife species for control capture program. Very briefly, I introduce what countermeasures we should do. Either we do game shooting or trap hunting. For the trap, as you can see in the picture ABC, there are 3 types. Okay, and for example, for the wild boar's case in picture A, wild boar walk without noticing the location of the trap, and then the leg can be captured by wire. The second one B is there is a box, and we use a bait to attract wild boar or cicada, and when they touch the bait, the trap box will be closed. And the third one is large-scale box-type trap. The picture in C is a kind of a small one, but it could be much larger, like 10 or 15 cicada or wild boar could be inside. Okay. Then for the digital transitions and green transitions, there are some ICT systems and technologies were proposed and implemented in Japan. These are the examples. Basically, there are three main technologies using. For example, drones are used to monitor habitats or are used for sensing technologies. And remotely monitor the system, like in the forest, for example, deer and wild boar are passing in front of the sensor system, then they can report to the user directly through the wireless network. And also the last one is, for example, the system to count numbers or identify animal types. So they can differentiate the cicada or wild boar or how many wild boar are there. Then for this case, they can choose the timing when to close the door of trap by this kind of ICT technologies. This is for the current situation and the future. So far, we are doing good. The population of two species tend to be decreased, but we have data until 2019, so we don't know right now. We should continue to reinforce capturing. Thank you very much.
Excellent presentations. Thanks. Our first speaker is Mr. Kremers from Codata, Germany. His topic is on digital twins in action, complexity management, including process models and workflow standards. Mr. Kremers, you have the floor, please.
Yeah, thank you very much for the introduction. Dear colleagues, best greetings from early morning Berlin time, Germany. And I'm very sorry not to have the opportunity to be with you in Kyoto because it's a fantastic city in Japan. I have been there myself, and I hope you enjoy the time also besides IGF conference in the city. My topic today is on digital twins in action, complexity management, including process models and workflow standards. There are some words in that title that I personally hope that even in the sum up of in the discussion, we may find opportunity because there is a little bit of deficit what we are doing the last years and what we need to do next years when the complexity of what we handle becomes even much larger than we ever thought before. I'm working in the Sustainable Development Goals, in resilience topics, in disaster prevention and disaster information management, urban information systems, and in that combination, there are my background is in disasters and hazards. That is what can happen to our environment and to our fellow citizens. We have to try to do our best to be better in many things, as that introductory presentation by Professor Kegong very convincingly stated. We need to support our society at large. So in all these things, I don't want to go into details. You can download my slides in a download link I give in the last page. But nevertheless, all these can happen, and it happens if you remind your newspapers. Then you see that our life is not very easy because we have to deal with all these things. there are certain facets for dealing with complexity issues, of certain facets of urban resilience, where we start not only from collecting data and see what we can do with the data, but we have to do a strategic approach, see the whole problem, and then look into the details, how they fit together. We start from a holistic approach to information management for intelligent cities, and smart cities, what we call it, which is characterized by societal demands, current problems and challenges in technology, financing, and so on. More advanced requirements of urban infrastructures, advanced requirements that we have been working in urban infrastructure since minimum 30 years in 3D. That is when 30 years ago, 25 years ago, we started with 3D urban models. And of course, that is now very much advanced in technology and gives also much more problems in information management. There is technology behind that, laser scans becoming better and more sophisticated day by day. Then from the topics of safety and security, we have internal security, which is the security of citizens in the city, and the disaster prevention, that is what happens regularly. We cannot avoid the disaster, but we can better prepare our citizens to have not so many deaths and also not so many big loss of damaged infrastructure and so on. Ecological and climate perspective, sociological issues in the city, and fractionalized production and supply chains. This is one of the major things which makes a city being live, active, with the perspective that is that everything can happen, but it is not just facts. You see, not just static facts, but it also deals with what happens, and what has to be done. Other facets of urban resilience is growth, agglomeration, and what have you. You see the problems of the real big cities, which in other parts, not only in Europe here, but much larger cities are in other countries in our world. And there are development problems, there are ecosystem problems where we have to deal with health and things for our citizens in the city. And what I want to take your attention to is urban ecosystem services. That is the sustainable development principles of not only seeing what is the ecosystems, but what does the ecosystem do for our citizens. Make life enjoyable and have service for urban development and so on. So this new topic which came up 2 or 3 years ago only, very sophisticated systems of ecosystem services. I come back to these things also when I touch the aspect of processes. Without taking too much time to read, the last point is intelligent transport systems. That is where actually at the moment there is here in Europe, also in Germany, very much work done in transport, railways transport, air transport, and so on. And much money and development put in intelligent transport systems with a lot of details, sensor systems all over. And that is a real streams, multiple streams of information coming just in time. We have the notion, we come from 3D urban models of different stages of granularity. now to the term of urban digital twins. Now, digital twins, this is not about robotics, but it's about having different, more sophisticated digital representation of what we call the urban sphere. That there are certain principles to start from the beginning. It's common good. There's a value behind that. We have to deal with quality, adaptability, openness, security and privacy, curation, standards, and in totally have federated models. These in principle, these principles are not really absolutely new, but they have to deal with what I call much more massive information that becomes a bit available. Granularity comes down to the fraction of millimeters, and information goes not only on top of the landscape, but it's in the landscape, and it's in the ground below the landscape. In urban terms, all the pipes and things below the surface of the urban infrastructure is absolutely important, together with all the function of water pipes, sewage systems, and so on, metro systems, underground tunnels for transport and everything. To have these things with at least the same high-level digital principles of what we did on top of the ground with the typical 3D models. That is something which is the challenges also for the future, but not only challenges, but of course also perspective of doing much more of organizing our common space in the city. Herein, we have to organize these massive data and active data streams which come from censoring certain aspects in all these systems. We have to organize this in data spaces, and I just give you an overview of the recent data spaces that the European Union is working in, and that is from manufacturing to Green Deal, mobility, health, financial, energy, and so on. And on the right of the slide, you see smart communities, also mentioned for our action space. This is an open system where, of course, much more other spaces can be joined, and but here is a lot of activity going, especially in mobility. The third entry from the left. Mobility is, as I said, of absolute priority at the moment, and you see all the kind of industrial ecosystems that deal with that, is from construction, tourism, textile, proximity, automotive, health, and so on. And that is what we don't have, actually. We may discuss that later. We don't have real good means how to deal with that complexity of information. The ontology of the urban digital twins, that is kind of the common conceptualization, and the digital semantic models and procedural models, what we are dealing with, that starts with terms, properties, identity, status, annotations, role, causalities, the semantic networks, what is more or less known as a principle, and nevertheless we have to do much more with procedural networks, because there is action in the digital twins. They are the most challenging difference is that we don't have only static facts, but as I said previously, all these things are on the fly with sensors all around, information streams coming from every side, and the whole thing is not just for presentation, full stop. Then you have the presentation, anyone else can take it, the presentation, but now the whole system is for direct steering the city. I'm not favoring a direct robot working behind that. Nevertheless, for traffic management, traffic light management, traffic optimization or something, there is a lot of interactive connection to this, to physical and digital, between physical and digital. But not in all cases that would be possible. But for handling this, we need procedural networks. That doesn't have happen just by chance. But we have to do a model, models, and discuss the models of this. And the ontologies that we set up would have, as ontologies on the ontology level, capabilities of comparison, different ontologies through globally and through different cities, because at the moment a lot of different proposals for having ontology of urban cities is on the table. There's not yet a real international standard for it. We have to compare these ontologies. We have to do that automatically because it's so complicated systems. Data management, imagine a data management plan for the whole digital urban twin. And so that is rather complex, and for comparison, we need that automatism to do it. We have the function of union of ontologies. We have different subdomains, which we model first, and then we have to merge these to get to a more complete, holistic aspect of ontologies of digital twins. We have to do generalization in the ontologies because we have to deal with technical detailed structures, and we have to support upper management in the city doing for decision support on very different organizational levels in the city. Coherence analysis, that is the question of, is that ontology and the details of data stored coherent with legal boundary conditions, with financial boundary conditions, with ethic boundary conditions, and so on. So this list is large.
Excuse me.
There is discussion in detail for this, but we don't have the time at the moment.
1 minute.
We have to homogenize the terminology. We do work on the formats and meta information. Nevertheless, the most important thing for the future would be the standardized workflows for standard operating procedures in this big information flow. We, at the same time, for doing these logistics just in time, we need to do something not just right just in time, but we have to implement just in time. This implementing just in time is a thing that we also have not very good experiences at the moment. Behavior models, the challenges. I come to the end of my presentation. Beside cloud computing, you see that is all things that is discussed, but also in the end, you see also my hint to implementing just-in-time demands. This is absolutely new science needed behind that. Recommendation of action is we have to record, work with scenarios, work on complexity management. We have absolute deficits in doing models of complexity management. Sorry, but we have to that is really urgent that we do about it. And for the full management, you see also the entry on the right side, audits, to have independent control of plans, implementations, and does it work? Does it have the effect? Does it reach the goal what is planned for? Thank you for your attention, and I'm looking forward for the discussion. And here you have the download link of the presentation. I have more material for those who are interested in digital twins. I'm very happy to have direct contact later. Thank you.
Thank you. And our fifth speaker is Professor Ricardo from Mexico. His topic is on challenges and commitments in digital technology and sustainable environment according to the United States, Mexico, Canada agreement. Let's welcome Professor Ricardo from Mexico. Thank you very much.
Thank you very much. Hello, everyone. I would like to thank to Dr. Liu, Dr. Tao, Dr. Tomoto, and online to say hello to Ki Gong and Dr. Hurst. Well, I would like to talk about the challenge and commitments in digital technology and sustainable environment according to the United States, Mexico, Canada agreement that is called USMCA. First, I would like to show how the legal framework is formed in Mexico, since it's important to efficiently address two issues of challenge in the green and digital transitions towards to a sustainable future. In general terms, our Mexican Constitution stands as the highest legal system, followed by the international treaties, federal laws, and local legislation, along with the official Mexican regulations. In human rights, both our Constitution and international treaties occupy a place of equal importance, ensuring the protection and promoting of human rights in accordance with pro-person principles. Within our Constitution, Article 4 expressly recognizes that every person has the right to an environment adequate for their development and well-being. This underlines the relevance of environmental sustainability on our fundamental legislation. At the international level, Mexico has signed 62 international instruments on environmental matters, including notable events such as the United Nations Conference on the Human Environment in Stockholm and the United Nations Conference on Environment Development in Rio de Janeiro, Brazil. Among the most important treaties, USMCA seeks to establish a framework for economic and commercial cooperation between the three neighboring nations. Although the USMCA does not address specifically the use of digital technology in the environmental sustainability, it is undeniable that these two areas are crucial to the future of our societies and economies. Chapter 24 of the USMCA focuses on the environment and establishes goals to promote the protection and sustainable management of natural resources. This includes a commitment to create and effectively enforce environmental laws and comply with the international environmental agreements to which we are a party. Although the agreement addresses uses concerning digital technology, e-commerce, and data protection, it is important to consider specific technological aspects with application in the environment. Harmonizing regulation and policies around these issues is a crucial challenge. Regarding the Mexican national legal framework, the environmental law, which is called in Spanish, Ley General de Equilibrio Ecológico y Protección al Medio Ambiente, in Article 5 promotes the application of technologies, equipment, and processes that reduce pollution and promote scientific and technological research in favor of environment. As I mentioned at IGF 2021, authorities and civil sector should consider using big data to generate and use clean and renewable energy. And the question is, what can we say about the use of artificial intelligence that is discussing during the current IGF in Kyoto? Well, I think this is important to know its operation and applicability to protect the environment. Nowadays, the demand of sustainable and efficient electrical energy is an unavoidable priority. In this context, AI emerged as transformative tool that can revolutionize the generation and management of renewable energy. AI, through big data analysis and autonomous decision-making can improve the efficiency and reliability of renewable energy sources such as solar and wind. As we can see, we have a solid legal framework to address the green and digital transitions towards a sustainable future. However, we need more. In addition, it is essential that authorities join together and collaborate closely with private business corporations, civil society, and academia to achieve the national and international levels. Moreover, with the support and advice of world experts like my colleagues in this workshop, we can, on one hand, learn from their experience, and on the other hand, exchange ideas and strategies to build a green and sustainable world with the support of the technologies. Only by working together, we can take full advantage of these political and legal instruments and build a sustainable and equitable future for all. In addition to above, some of the challenges where technological strategies must be implemented are reduce greenhouse gas emission and in all economic sectors, promoting the adoption of more clean technologies as sustainable practices. Second, to continue with regional and global cooperation and investing in digital infrastructure, thus facilitating the transition to a digital and sustainable economy. Third, ensure equity and social justice in the transition through training and skills development so that communities affected by changes in the industry can fully participate in the digital and green economy. And final, continue working on the harmonization of standards and norms related to technology and the environment between the three countries, thus facilitating trade and cooperation in areas crucial to the sustainable future of North America. Thank you very much for the invitation again.
Thank you, Professor Ricardo. Maybe there is a technical problem, so the sixth presentation, the presenter is offline for the time being. So we move to open discussion. First of all, I have 3 questions for our expert. After that, let's see any on-site or online participant have some questions or comments. The 3 questions. The first question focuses on key challenges and government issues. The second focuses on strengthening the cooperation among multiple stakeholders. And the third focuses on policy framework, policy guideline, regulations, something like this. So I hope our expert select maybe 1, 2, 3, or please. First, Professor Liu.
I think this is challenging, and for the digital and green transition, I think challenging is the I think challenging is how to make the weak people, developing countries, at least, and especially for the mountain areas, small islands, countryside, villages, they're so weak people. We need to call all communities, government, international organizations, pay more attention to these people. These people need help. They really need just hunger-free, poverty reduction, for disaster, save. So I think the challenging is how we can pay more attention to these people not only cities, not only rich people. So this, from my experience working with these guys, these people, I pay more attention to this. I think the challenging is science, technology, ICTs, everything, commercial issues, whether we can work together in a best way for them. This is my opinion, my experience.
Yes. Thank you, Professor Liu. Professor Ricardo?
Well, I would like to ask the same question. And I'm going to talk about the law point of view. And as I said, it's important that the authorities get actively involved in the international forums such like this, the IGF. In fact, I am especially happy because some Mexican parliamentarians, who are interested in the internet governance issues attended this IGF in Kyoto. Without any doubt, this is a great start. Now it's important that they do an excellent job in materializing the creation of laws and their due promotion to achieve the goal of taking advantage of the digital and green transitions for sustainable development. Thank you.
Thank you. Ms. Tomoko?
Okay, about the question A, the challenges, I would like to give my opinion to probably the developing countries and industrialized countries' situations are completely different. But how I feel now is, for example, the governmental officers, scientists, and private sectors, there are many people who work on those issues very seriously. However, they tend to work independently. In a way, I feel they work separately in isolation sometimes. In that case, what I feel is some people or organization who can bond these people are lacking. So the people or organizations who could function like a bridge or a bond will be necessary for future as a challenge in my understanding. Thank you.
Thank you. And Mr. Kremers.
Yeah, I think on governance issues is something where in science we lag behind. There is a lot of new methodology, not only develop existing methodology, but new methodology needed for complexity and processes. And but science is not working alone. As also other speakers, I'm very also interested to learn more from Ricardo experiences in Mexico. We have to deal with the administrations, people, and I say they are, as I know here from Germany, for big data and complex data, administrations are not so really well equipped. And sometimes it's an educational setting also needed. So how do we need the needed competencies? Because after science experience and it works, the whole thing normally goes into administration for operational, long-term systems running for the service of citizens. That is not only a scientific part. And this kind of governance needed to set these up in a participative mode, as Ricardo also said, we not only with the government, but also with citizens. Citizens are not general citizens. There are engineers, there are doctors, there are health-specific agencies, and so on, in the service of people. These kind of actors need to discuss with us, and that is what we need to support. Thank you.
Thank you. Please close this one, this presentation. So, do on-site participation have any questions or comments for our 4 speakers today? Please.
Yeah, hi, good afternoon. My name is Tariq Hassan. I'm the head of the Digital Transformation Center Vietnam, working on behalf of the Federal German Ministry for Economic Cooperation and Development, GIZ Vietnam. My question is to Tomoko-san. I was very inspired by the work you do, since we also focus on facilitating the green and digital twin transition. I was wondering more on the ministry collaboration, because I think you mentioned 2 ministries, the Ministry of Environment and the Ministry of Rural Development, or some sort of ministry focused on biodiversity. Sorry that I don't have this name in the top of my head, but I was wondering what the division of labor is also with the role of the Ministry of Internal Affairs and Communications. So is this more within the sort of jurisdiction of the Ministry of Environment? Is also the Ministry of Internal Affairs and Communications of Japan also working on biodiversity issues? I think this bounces back to the question of, do the green folks work on digital, or do the digital folks work on green? And what are the sort of collaboration mechanisms surrounding that? Thank you so much.
Thank you for your questions. Maybe I can show my PowerPoint again. Zui, could you show my PowerPoint?
PowerPoint, please.
Around page 9.
Page 9.
Okay. The 2 ministries you are talking is first Ministry of Environment, that's called MOE in English, in short. Another one is Ministry of Agriculture, Forestry and Fisheries. In short, we call it MAF, M-A-F-F. Page 9, please. Okay. Maybe I can control it. Okay. Yeah. And what's the different function of these 2 ministries? MOE is, for example, what I introduced this law, the Wildlife Protection Control and Hunting Management Act, that was proposed and revised by under the authority of Ministry of Environment. And what is another ministry, MAF, is doing is they are in charge of agriculture. And they have the land, for example, if their land belongs to the government, we call it national forest. They are in charge of national forest too. So MOE and MAF have a lot of overlapping issues, especially about this cicada and wild boars population control. They need to collaborate. Due to the time constraints, I did not introduce very much in detail, but basically there are the consultation between 2 ministries. The introduction I did about this new goal. New goal was set up together by 2 ministries. So this is a common goal by 2 ministries and also common goal of Japanese government too. And also inside, under the ministry, there are the prefectures. And under the prefectures, there are the cities and villages too in Japan. So how to collaborate is, I did not explain very much, but in this figure, red color means country's work, and blue color means prefecture's work. So they work together in some domain, like I mentioned the second component, control of capturing wildlife. Government should do something and the prefecture should do something together. But some work is divided independently too. Yeah, so basically a country prepares basic guideline and law. And under that, prefectures do the practical programs. The implementation of programs will be done by prefectures. That is how they collaborate each other. Did I answer your question?
The question that for us is really interesting is how do you build up capacity within the ministries? Because you mentioned like IoT devices that are being deployed. So is that technical capacity for digital transformation you build within the ministries? Is that something that you outsource? Do you work together with the digital ministry, or does the digital ministry actually have a role in that?
In my understanding, there is an agency of digital ministry was newly developed inside of cabinet, but they are in charge of issues about, for example, the number identification of human, for example, and not doing how say this kind of work very much. The ICT techniques and technologies I mentioned and introduced today were proposed by private sectors. And so what we are doing is from the top level, high level, Ministry of Environment and MAF collaborated together to set up a goal as a government. And for necessity, they sometimes need to change the revised act. And based on this revision, private sectors and prefectures start to work on it. I belong to private sector, so I got the certification of implementer of this program. So prefecture develop a program, and we are implementing this program. So like that kind of collaboration is occurring in Japan. Thank you.
Thank you so much.
Thank you. Any more questions on site? Please.
Yeah, we talk about the twin transition. So what kind of data could be accepted? For example, how do we know the data is good data or poor data we are using? To Professor Liu.
Please. Thank you very much.
Okay. Yeah, good question. So there's big data in the society now. A bunch of data comes, but how to identify which data is trustable, which data is good, can be used for your research or for your business. So this is really challenging. A good question, thank you. And then there for the data divided to different sources. Some data from government, some from private sectors, and some from the research, university research sectors. So this is there are different policies, and then how open there. And for research part, for most of the research part, I'm from Chinese Academy of Sciences. There in the whole world, we have World Data System. World Data System is under the International Science Council. Totally there are 86 World Data Centers in the system. So there is a peer review for the data set for peer review, because all the data come from research part. Different scientists, there are different ideas, different methodologies, and different results. So how to make sure this? There we should control it. One is whose data, so who's author of the data. So we need to protect original authors, where the data come from. And then where the data, how the data produced, in which model, in which methodology, and make this, you need to have a curation about the data. And second one, we need to check this data security. Different policy, different countries, different organizations, whether this is private, our personal security, business security, and so on. We need to check this. And then we need to check the security, and then check the quality, data quality. So how to data quality for geographer? I'm geographer, so geographer they are different. For the table, taste and then the raster, geolocation, different resolution, and it's very complicated. But we need experts to review this kind of data. So there is our data center is global change research data publishing and the repository. Through the publishing the methodology and the peer review go data, and the data could be very trustable. So we call this trustable. So I call you, and if you have data, you go to the World Data Center system. That data is, there is an international regulation, and put them, make this trustable. Thank you.
Thank you. Because our sixth presenter now is online. Professor Daisy, are you here? Professor Daisy, are you here?
Yes, one.
Yeah, please.
Yeah.
Yeah, maybe you have only 7 minutes. Can you share your presentation? Can you hear me?
This is the South African. She is a very good expert in the information management, and she also is joined the International Association for Science and Technology in the CODATA, and also is working with us then many years for the developing countries, share the data in developing countries. I think that I had Daisy, are you online?
Yes, the internet is a challenge where I am.
Okay, go ahead, please.
Opening up. Yes, let me go ahead.
Yes, please.
Okay. Thank you, colleagues. What we want to highlight with you is how we actually look at open access repositories as an accelerator in enhancing our South African SDG hub. And these are all the 17 SDGs that we are all aware of. So I just want to move quickly based on the time that we are aware that the African leaders have responded to the SDG agenda by setting the regional priorities based on the common African position. And then post to that, we also looked at the African Union Agenda 2063. And this is what highlights us for sustainability issues. And the African Union Agenda places prominence on research and innovation for sustainable development. An important development is the formulation of the SDGs with the universal recognition of the importance of quality education, especially in the Global South, which is on Goal 4. And when we look at the Goal 4 targets of particular relevance to us who are in knowledge management and knowledge production, we look at repositories, data stewards, libraries, and information specialists, which is aligned to Goal 3, which is how to ensure the livelihood and the well-being of our population. So how do we come in from where we are with what we want to do regarding sustainable development and sustainability? We look at Goal 3 and then Goal 4. And in Goal 4 on education targets the issues around who are the actual role players, especially those who are involved in knowledge production, and who bears the responsibility on the complex and interrelated issues of accessibility and affordability of knowledge resources. And I just want to indicate that knowledge management and its impact on SDGs is highlighted within the 4 areas, we're looking at availability, accessibility, acceptability, and adaptability. And here we're looking at how do we actually facilitate sharing of information, accessibility, the roles that information literacy programs play, and acceptability, making available open source academic journals, because if we want to address the SDGs, we need to be looking at all these things. The other aspect is the issue of adaptability. And here, well, how do we consider the training of researchers, policymakers, citizen science, and public outreach support to ensure the application of knowledge in solving the key global disaster health problems. And I would just want to indicate that we have the indicators that are key to us in the global south, and especially in Southern Africa where we are. We look at the amount of research and development spent around the gross domestic product, which we spend 50% of our annual investment is in research and development performed in South Africa comes from international partners. We also look at the indicator on qualitative measurement of use and access to ICTs, and especially now we're looking at the fourth industrial revolution. Also the ability to produce high export technology, and also the issue around higher education internationalization, because we know that our scientists and researchers and our postgraduate students, they are international, and they co-publish and so forth. And like what we are doing today, we are co-presenting. And also we look at the indicators on the number of scientists the country produces and the number of patents that are filed in our country. And what's important also is the number or the impact of articles published in highly ranked journals. And these are the indicators that are highlighted. And quickly, the influencers of our indicators, especially in Southern Africa, is the issues around government's strategies on national research development strategy, the higher plan for education, for example, the plan for science, technology, engineering, maths, which is the 10-year innovation plan from our Ministry of Science and Innovation. And we also have our South African Open Science Draft Policy that's also assisting us. So I will now leave to my colleague, Lazarus, to touch base on how do we support the knowledge for sustainable development and how do we capture the SDGs. Lazarus, you can come in.
Morning, colleagues. I'm just going to touch quickly because of time on some of the things that we are doing. So in South Africa, through the National Advisory Council, our strategy is to support repositories. As you can see here, working with universities, research councils, national facilities, institutions, museums, and others. So these are basically where we are trying to ensure that they fall within the institutional policies that they are prioritizing to ensure that they can generate content that they are producing and link it into all the repositories that we can push. So in terms of this, there are the two policies, which the first one is research outputs, which each and every university produces. And then the second one is the creative outputs. This could be your film arts, visual arts, music, theater, design, etc. So what we have so far tried is to ensure that all the universities have a repository, both for publications and data. And also through the University of Pretoria, there has been a project where we have developed the South African SDG Hub to harvest all the collections that are within the universities. This also has to be the issue that Daisy raised, that we need to train our librarians to be able to index some of this content to ensure that they fall within the SDG criteria, and through a taxonomy, a national taxonomy that is also supported by the national development agenda of the country. So if we look, I'm not going to touch much. There is, so the leverage is for open access is through these, the library experts that we are also capacitating within the repository fields, and to ensure that, you know, the repositories also fall within the best practices around the world. And so we work with other organizations, with colleagues in KUA and other organizations where we learn some of the skills that are required. Then we pass it on to our community of practice here in South Africa. So one of the elements that we have also pushed is to ensure that each university has an open journal system, and also they have a choice. But most of the universities are using DSpace as a software, and through DSpace we are able to collaborate to fix problems that can happen, and etc. So these are some of the repositories that are in the institutions, and also you can see the data repositories that have been created so far from some of the research-intensive universities, and also the OJS system. Thank you, Chair.
Thank you, Professor Daisy and Mr. Lazarus. I'm right? I'm sorry. So I think Professor Zhou is a remote moderator, so whether there is any questions from or comments from online. Professor Zhou.
Yes, Professor Tao.
Yeah, one
I
question.
think quite a few questions online, but due to time restriction, I'm not sure if our speaker can respond to all the questions. There is a question from the Andrei Khrushchev from Common Funds for Commodities. He indicated global commodity value chain is very complex. Could the speaker speculate how technology could support their green transition, food security, energy efficiency? I think also Horst raised his hand. I don't know if he has any response or any question. I pass the floor to the on-site chair. Professor, talk to you.
Yeah, thank you. Just a short remark, because such questions are unusual in our normal working groups. There are professions around, like as Andrei represents, which would be needed to join the whole thing for all these consequences of what we're doing, not just collecting data. We are doing these processes for certain purposes. And as Andrei said, that for green transition, for food security, energy efficiency, and so on, transport efficiency, all these data spaces that I mentioned in my view graphs, they come together, and we have to find out how to put them together. There are models in food security, there are models in energy efficiency. In the other view graphs, I said we have to join these ontologies. This is a problem for itself, and I hope to stay in contact for doing more in that direction.
Okay, thank you.
Okay, thank you.
Due to our limited
time.
I
think there is no more question right now.
Because
I think
the time limited. Okay.
Yes.
Okay.
I think on-site can have.
Okay, thank you, Professor Zhou. Due to our limited time today, and all of the speakers presented many excellent points of view, I might need maybe another 1 or 2 hours to conclude. So this is the end of this workshop, and we want to extend our most profound appreciation to all the experts for their expansional presentations, to both on-site and online participants for their insightful questions, and of course to organizers whose dedication and tireless effort make this workshop a success. Thank you very much. Thank you.
I would like to call all of you to come here. We get together to take a picture. Okay?
Very good.
Good. Come on. So maybe we know to each other, and the next year we can meet again. Thank you.
I'd like to take the opportunity to give my regards, special regards to Liu Chuang, for we work together now more than 20 years in these topics, and hope we can do so for the future. Thank you.
Thank you very much.
李道长，那个线上的一起照一下。
线上照的张。So everybody come on.
在线上的，从这儿吧。
下边到下边省着那个亮。
现在这儿不亮。
不，跟你脸。So come on. Everybody try together.
那个线上的有吗？
线上放的啊，线上的把这个拿下去。来 ，come on. Everybody come on. Yeah. Everybody come on. 换一下。
就是线上的两个人。
把线上的那个，那谁照的要想拿下去？呀，good。
good。
啊 ，nice。Come on. Yeah, everybody.
Okay. Upstage.
Yeah,
That's a good idea. With the picture, please.
With the screen.
Yes.
Tomoko. 下来照。下来照啊，你得 start 背景。啊？那背景啊。啊，对。这背景是这个，是吧 ？Next step.
Bye, Daisy. Glad to meet you.
Yes, so nice to see you again.
I was wondering why you are not didn't appear at the beginning of the session, but finally we have you here. Great.
We're sitting at another conference in Cape Town.
Okay.
Yeah, and then it's clashing. So the presenters are late. So we were supposed to present now, but we're happy you are here. Yeah. Okay.
Great.
I hope to see you in Beijing soon. Maybe next year. You need to organize.
Great. I'm looking forward to see you in Beijing.
Organize a meeting in Beijing. Are you coming to Salzburg, to Vienna, to Austria?
Maybe not.
For conference.
There is geoplanary this November, but
Yes.
I'm not planning to go because you know this is a very busy season for us,
Yes, yes, yes.
especially for myself. But I
Okay.
do miss you. It's
Yeah, so
quite
next
a
year,
long time no see. Yeah.
next year, can you plan something? Let's plan something in Beijing. Let's plan something in Beijing, you know?
Yes, that's what I want to say. We need to plan events in Beijing.
Yes, yes.
Mhm.
Let's do that. Then
Okay,
we'll come.
I
Yeah,
will
my
send you
members will
email.
come and present.
Okay.
Yeah, yeah, yeah.
Mhm.
Okay. Bye-bye, my friend. That's all. Say bye-bye.
Bye bye.
Bye. See you. Bye-bye.
Bye bye.
That's the idea.
Be happy because we did a good job. Happy.
So we will want to work together.
Yeah, good. Thank you. Let's have a follow up. Let's follow up. Each year come.
Yes, she will come everywhere.
Yeah.
Everywhere.
And the next time maybe you have your speaker panel. Maybe.
Yes.
Yeah.
She can do it well.
You are a lawyer. Yeah.
She's a lawyer. And
Yeah,
she
you're
can do it
lawyer.
well.
Yeah, it's a kind of. Yeah.
Thank you. You're very proud.
Yeah,
I'm a lawyer.
exactly.
She's a lawyer too.
Yeah, you're a lawyer. Yeah.
You know, I don't know how can I use the WeChat. Someday, yeah. One day actually, I lost the connection and I couldn't connect to again. WeChat, yeah. I'm going to download again. Let me look at this. If you can help me.
Yeah.
Because
刘教授，你刚拿电脑了吗？没有啊。这是线。我不知道是谁的。这儿。So you are the next.
Yeah.
Okay.
Sorry to keep you. just double check.
No, that would make sense. I'm pretty sure. Yeah, if you both think it's B1, then I just memorized the wrong thing.
The thing is, I've been in B1, I've been in B2. I was in B2 yesterday and we were saying it's the opposite one.
Yeah.
So I'm pretty sure it's B1.
B1.
Okay, so I memorized the wrong thing.
Just like Millie for Hillary and then for, yeah. Yeah, that's the perfect number.
Well, we know Joyce is coming in to meet us.
I hope so.
Where did you put her back?
I don't know where you want to sit. Shall we just wait for one more minute while people are coming in? Sorry, we're just waiting for 1 or 2 more minutes. Thank you for your patience. Hello everyone, so I think that we'll start now, and one of the speakers should be arriving soon, so we'll just start now and then take it from there. So thank you everyone for coming, those in person and online. I can see that there's quite a few of you online. Good morning, good afternoon, good evening, wherever you are. So my name is Yasmin Afina. I'm freshly appointed as AI researcher at the UN Institute for Disarmament Research, where I conduct research at the intersection between AI, international security policy, and international law. And I was until recently research fellow for the Digital Society Initiative at Chatham House. So welcome and thank you for joining us. The session today will have 3 parts. So first of all, we'll hear quick presentations by the brilliant panelists we have here today, both in person and online. And then we'll have a quick set of reflections before we then eventually move to moderated discussion between the panelists and the audiences joining us today. Please take the opportunity to engage. This session is not just about presentations and a Q&A. The IGF is a unique opportunity where we have such a diverse group of stakeholders all together, both in Kyoto and in the cyberspace. So we want to hear from your perspective too. And before we start, just a few housekeeping notes. First of all, I will be moderating the discussions throughout the session. My colleague Rowan Hill will be helping me monitoring the online discussions as well. So if you're joining us online, please submit your questions in the chat. Or if you're joining us in person, please raise your hand. And the room is quite big, so don't hesitate to move forward. Or raise your hand really high, even do a little dance so that I can see you, just so, yeah. This session is recorded, live streamed, and will be available on YouTube. So despite being held by Chatham House, it's not under the Chatham House rule. And third, you will see flyers and little notes scattered across the room. So it's either the link to our polis, which Rowan will talk about a bit more in a minute, but using your smartphones, your laptop, whatever device you're using, please go to this link and submit your vote. For those joining us online, we'll pop the link of the polis in a minute. And for those in the room, you'll also see QR codes on flyers where you can see some of Chatham House's most recent projects, papers, and commentaries in the AI space. So without further ado, here next to me is Rowan Wilkinson. She's Program Assistant for the International Law Program and the Digital Society Initiative at Chatham House. Rowan is the primary engine behind Chatham House's work on international law and tech policy, so including our work on AI, which we'll hear more about from Rowan herself. So now over to you.
Thank you. So hello, thanks for joining our session. My name is Rowan Wilkinson, and
I work for the Digital Society Initiative and International Law Programme at Chatham House. So just briefly, for those of you that are unfamiliar with our work, Chatham House is not just a rule. We are an independent-based think tank in London working in international affairs, and we work in many thematic areas within this field, but my team, the Digital Society Initiative, focuses on research and policy for the better provision and governance of technology. And to this end, we explore 4 key areas: big tech platforms, digital public infrastructure, international digital cooperation, and artificial intelligence, which is why you're all here today. But this event is not a standalone piece. It's part of a broader stream of work that we have on responsible AI in practice. And this project really aims to support a lively and inclusive public debate on what responsible AI is, its risks and benefits for our common information space, and also provide a multi-stakeholder platform to inform AI development. It also hopes to build mutual understanding between AI developers and public stakeholders and surface core concerns, questions, and assumptions that we hold around AI. So we began this project in the spring of this year with the support of Google by establishing our Responsible AI Task Force, which is a diverse group of experts from across the globe: Argentina, Kenya, the US, Indonesia, Iran, I could go on. And what we're doing is we're hoping that beyond the normal aims of a task force to inform and guide a project, we're also looking to them to challenge our perceptions and bias as a UK-based think tank. And we're lucky enough to have 3 of those members today: Millie, Kathleen, who's online, and also Hilary. And then a second strand of this project was also a Proust questionnaire, which you have links to on the tables in front of you, and I will share a link in the chat later on. Which hopefully gives you a moment of pause and deep reflection in what is often a very busy space of AI, to really answer and reflect on some, what we hope are very interesting and creative questions, such as, if I were worried about AI, would you reassure me about the future? How does AI affect the social contract? And does AI need democracy, or does democracy need AI? So if you're interested in this project, we also have an essay collection to be published towards the end of this year, which showcases different perspectives on AI and covers topics like CERN for AI, public interest in AI, revolutionary potential, AI and the COVID response, public interest, and lots more. And yes, as Yasmin has said, there's some further work that we have on AI on your desk, including data equity and governance, and also using digital democratic tools and processes to bridge the recursive public. So yeah, if any of this interests you, please come up to me and say hello at the end of this session, and check out the QR codes. So as Yasmin has already said, we're going to be using Polis to kind of gauge the audience's opinion and see consensus items in this debate today. So we urge you to have a look at that. And for those that don't know, Polis is an intuitive consensus building tool where you're able to agree or disagree to certain statements that are posed by other participants. So hopefully we'll be able to raise some of those as they come in throughout the session.
Thank you, Rowan. For those joining online, I've shared with you the link towards the Polis. So how it works is that there are some statements, as Rowan mentioned. You just need to vote whether you agree or disagree with the statements. You can also submit the statements that you think are relevant when in the context of our discussion. So please do submit your votes. We're really eager to learn more about what you think about this question. So without further ado, we're going to the presentation. So we'll hear short presentations by our panelists joining us today. This workshop is about hearing perspectives on how communities and collectives can frame and guide the responsible development and use of AI technologies. So beyond the usual traditional state-centric models of governance on AI, which in a way are important, of course, but they may perhaps not be enough in certain contexts. And so without further ado, let's move to our first speaker. So Millie here on the left. So Dr. Millie Zimeta is a freelance tech policy consultant based in the UK and also senior visiting fellow at the College of Graduate Studies at the University of South Africa. She was formerly head of policy at the Open Data Institute and has led digital tech programs at the Royal Society, UK's National Academy of the Sciences, and the Alan Turing Institute, the UK's National Research Institute for AI. So without further ado, Millie, over to you.
Thank you, Yasmin, and thank you for that fantastic introduction. And thank you all very much for being here today. It's great to see you, and really looking forward to hearing your perspectives and experience in the Q&A and discussion section of the workshop. So my background is really data policy, and what got me interested in data was AI. I realized that there are many ways in which the availability of data is what has made or created the conditions for the kind of developments in AI that we're seeing today. It's quite foundational. So the data that you have access to, the quantity of it, the quality of it, and the content of it, the nature of it, is really foundational in the kind of AI systems that you can then develop. And what that means is the governance that we put around that data governance, is also going to be quite foundational to the kinds of AI systems that we can develop and that we can implement. So I see data governance as foundational to responsible AI. And what's been really interesting in the field of data governance is we're seeing community-led approaches as establishing a new kind of paradigm. And that's what I'm going to be looking at today. So before we get to data governance, I think we can, sorry. So before we get to data governance, I think we're probably maybe more of us more familiar with data protection, in particular the European Union's General Data Protection Regulation, GDPR. So GDPR was the first major international attempt to write a data law, and it was massively influential from having that first mover advantage of being the first. So GDPR has as its starting points the notion of individual rights, the notion of consumer rights, and the protection of privacy. So GDPR, which has really influenced data protection around the world, is founded in individual rights, consumer rights, and protection of privacy. And it was really brilliant for what it established. But we're starting to encounter the limitations of it in the field of AI, and that's where the opportunity for imagining something else comes in. So let's start with privacy. Although AI, in particular large language models, is getting a lot of headlines at the moment, something that we're seeing in stealth mode that's likely to take off in the next few years is privacy-enhancing technologies, also sometimes known as PETs, P-E-T-S. And what a privacy-enhancing technology allows you to do is analyze data while maintaining the anonymity of that data. And what that means is you can use a PET, you can use PETs to work with data while potentially being compliant with GDPR, but still working with quite sensitive, quite personal data. And this creates a really interesting dilemma, because you could potentially be compliant with GDPR, but doing something maybe quite unethical, you know, and that's not covered because everyone assumed that, well, you know, as long as you're aligned with GDPR, it's, you know, it's covered because of protecting individual privacy. Well, now we've got a category of technology where actually that might be bypassed. So it's really brought home that privacy is not sufficient. And in the context of AI, what that tells us is that privacy, again, can't be sufficient for thinking about the governance of AI. And we might need to think about a different kind of benefits, different kinds of risks, and different kinds of harms. So on individual rights and consumer rights, I'll take individual rights first. So think about genomic data. That's data about your genome, your genetic code. Your genetic data, your data about your genetic makeup is also data about your biological family. So even if you give consent for your genetic data to be collected and to be analyzed, that collection and analysis is going to have relevance and give insights about your biological family, and they may not have given their consent. And this really shows that individual rights, individual consent, individual decision-making may not be sufficient for how we think about data and how it's used, how we think about the consequences of data collection and data analysis. Individual rights are not sufficient. We need to think about the group, the community, and the collective. And again, in the context of AI, what that tells us is that harms can also be collective. So you sharing, say, personal data about yourself with consent, with permission, may harm other people who have a similar kind of data profile as you. So we need to think differently about harms and about rights. But on the consumer rights side, we also need to think differently about benefits. So a lot of the value and the power of data comes from aggregating it and treating it as a public good. So think about, when Rowan was mentioning the role of AI in COVID response, a lot of what made public health responses workable was aggregating data, collecting data from around the world or within a country from different parts of the country in order to be able to act quickly. So in those cases, the benefit of data comes from the aggregation and the collection and the collective benefits. In those cases, individual rights may not be the only calculation. And we see that in the field of AI as well. So part of the power of analysis comes from comparing data points. So one piece of data by itself is not as valuable as having multiple pieces of data and being able to map across them. And that has implications for how we think about the value of data, how we think about data markets, how we think about buying and selling and reusing data. So again, we need to think about collective benefits, what's good for the collective, what's good for the group, what's good for the community. So what we've seen is this approach to individual rights, individual consumer rights and privacy is not sufficient for the future of data governance. And we're seeing a need for collective rights, collective harms, and collective benefits. European GDPR in its current shape doesn't seem able to navigate that. But this could be an opportunity for regions and blocks that are now drafting their data protection frameworks, that are drafting their data regulation, to think about taking it further than GDPR, taking it a different direction, and to factor in that nature of collective benefits, rights, and harms. And I would also just mention that there are really good reasons to think that the majority world might be particularly well placed to take advantage of this, given those cultures tend to also be more collectivist by nature, and so the legislation would also be reflecting how decision-making works in those communities already. I'll stop there. Thank you very much.
Thank you, Millie. I think that was a really fascinating introduction to the issue of community-centered governance of AI and the importance of it because of the collective harms, but also the collective benefits of it. And one of those collective benefits and risks are related to targeted communities like the youth. And without further ado, now I'm transitioning to Hilary, who will be talking to us more about the youth perspective.
Can you hear me? Okay, great. Thanks, Yasmin.
Sorry, I just forgot to introduce you. Hilary is an associate program officer at the UN Office of the Secretary General's Envoy on Youth. And she leads the office's work on sustainable development, in particular on innovation and climate action. So she's really great, and I just presume that everyone would know her. So here you go, Hilary.
Thanks, Yasmin, and thanks for having me here. I really like actually how you frame this workshop, that it's not only about sharing, but also about learning. And I think just from hearing from Millie earlier, I've learned so much, and I'm really hoping to learn more from the people in the room as well. But maybe perhaps let me start with sharing some insights on what we found while working closely with young people. As you know, young people of today is not only one of the largest populations, they're also the most connected generation. And of course, the generation that is most likely to carry or feel the impact of the decisions that we take today, or the decisions that we do not take, right? And decisions on policies that significantly affects their lives, including policies on AI specifically. So earlier this year, our office, together with partners from the UN like UNICEF, asked young people from around the world on their take on the digital future. We launched a global poll that reached nearly 80,000 young people from across the globe, and we asked them what they think because we really want to hear it directly from them. And what we found is that 41% of young people said that they're mostly worried about how technology will change the world over the next decade. And the top 3 concerns that they have voiced out, the first one is access to internet. And I think we hear that a lot here in the IGF. But the second one and the third one, I think is very much aligned also to what Millie has brought up, is actually they're very much concerned on the control of data and information. and also the protection of human rights in this online, protection of human rights online in this digital age. So, and AI is of course in the center of these conversations among young people. So to add to that also, I think from the survey or from the poll, we learned that only 3 out of 10 young people feel like they have much control about their digital future. I think this last finding is very interesting because it kind of highlights that there is a sense of lack of trust at the moment within communities and lack of assurance that they can help shape, right, how this process is going, shape the outcome of their digital future, shape the outcome of and the process of AI. So young people have all this concern, and they're very much rightly and very much rightly so, right? If you look at the reality today, the prospect of our digital future, especially the future of AI, has not yet been the most inclusive, right? I mean, I think we could do so much better. We know, for instance, only 22% of AI professionals are women, and when we look into most of the panels on AI, clearly we can do better in terms of diversity, both in terms of age, geographical, race, and age representation. I think this is actually one of the panels where it's all women, so that's very exciting. And I think that should also be the norm and not the exception, so that itself. And I think when you take even a step before that and look at the larger picture of policymaking process, both for AI policies, but also for many other policies that shape young people's life, young people are still very much missing from that decision-making table. I mentioned earlier that young people is the largest generation of the world. Nearly half of the world's population is actually under 30, but only less than 3% of them sit in the parliamentarians, where decisions are actually being made, right? So when we talk, to your question, when we talk about community-driven responsible AI, we need to also address the need to make this process of shaping responsible AI very much open and accessible to communities, right, including young people. I see that within this week, but also in many of these conversations that we're part of, multi-stakeholder approach is being embraced more and more, which is very exciting. I think it gives a lot of entry points for young people as part of the community to be part of this work and engage. And a while back, we actually supported one of UNESCO's work in defining the building blocks of having multi-stakeholder-driven process for AI policymaking. And just to be mindful of time, I would really love to highlight like some of the building blocks that I thought was very interesting in the context of youth participation. Is that the first one is that in the context of developing AI policies, it must be developed through an open and inclusive consultation process, right? And I think that's a given. I think most people agree with that. But the second one, I think is the most important one, is that we need to commit to incorporating what we hear back from the consultation, right? All the feedback, all the recommendations. Young people are often consulted in this process or often being asked to share what their take on this, but we need to make sure that we're actually taking these recommendations into account and putting them in place. When we talk about multi-stakeholder approach, when we talk about community-driven AI, it needs to be not only open, but also meaningful. And so from a youth perspective, I think young people have already voiced out a lot here, but also outside these walls, outside of IGF, that they want to be included and they're ready to be included. And we saw this in many of the recommendations that young people have developed through different intergovernmental processes, but also even just now in the IGF, in the Youth Summit on Sunday. So, but they cannot achieve this by themselves, and they shouldn't have to. We really need an intergenerational support to help achieve this. We need leaders, both in policy process, but also industry leaders that could be allies that could start engaging young people as part of communities, not only to be consulted, but also to be engaged as partners in shaping responsible AI. And I think only then, when you engage young people and other parts of community as partners and experts, you can have a community-driven process that is really meaningful.
Thank you, Hillary. You know, I appreciate the sort of learning opportunity that I get from everyone, and I think that, you know, I really like your point about the need for engagement, of course, but then it also needs to be meaningful. And I think one of the key points that struck me the most was the point you just made about the importance of representation, but that in reality, there's still so much to do. And you know, when you look at communities and who are actually at the forefront of these efforts, it's just so inspiring to see them, you know, doing a lot of the heavy work, but they just can't do it alone. But we're so lucky today to be joined by someone who is actually leading one of those community efforts for representation in the AI space, who is Kathleen Siminyu. She's joining us online. She is a writer, primarily of prose, but she has found herself detouring to write mostly code in her career. So she is a machine learning fellow at Mozilla Foundation, where she has been building speech recognition for Kiswahili. Kathleen, over to you.
Thank you, Yasmin. And thank you to the entire Chatham House team for having me and for accommodating this virtual participation. I hope that you can hear me okay. So I've been working on a project known as the Mozilla Common Voice project. And briefly, by way of introduction, Common Voice is a project to build open speech recognition datasets. It is a project that is important because a lot of datasets that do exist are proprietary, so they belong to organizations that are not opening them up. And many times we may find that the organizations have access to language datasets that they do not prioritize in terms of building products because these languages may not be a priority for them for various reasons. So this is the gap that Common Voice tries to bridge. In addition to it being a dataset, I also like to tell that it is a platform that can and is used to build these open datasets. So we encourage communities to organize using the Common Voice platform. They can mobilize community members to start building data for the languages that they care about. And one of the things that I really like about it is that the engineering and maintenance of the platform and the technology is taken care of by Mozilla. And this weight is then taken off of communities and they can focus on the building of the data set. There are over 150 languages available on Common Voice. And actually, in many instances, we find that the communities self-organize completely independent of the Mozilla Foundation. But in the case of Kiswahili, it was a bit different. There is an African language program that is growing within Mozilla, and Kiswahili is one among several African languages that's received funding from the Bill and Melinda Gates Foundation, GIZ, which is a German development agency, and the UK Development Agency to build this particular data set. Similar work that preceded Kiswahili is for Kenya, Rwanda, and similarly, we've had work done to build data sets for Luganda, all languages in East Africa. So when it comes to community building, I'll briefly describe how the platform itself works and how we have gone about engaging the Kiswahili community in this case. The essence of a speech recognition dataset is that you have audio that is aligned with text. There's various ways that we can go about getting a dataset of this specification. The way we do it on Common Voice is that we first start by collecting text. This text is then segmented at sentence level, and then we upload them onto the platform. There's a validation step, of course, because we want to engage the community in creating the text, but then in also validating that this text is representative of their language. Once the text is on the platform, participants, community members, contributors can then come onto the platform and read the text out loud. And the platform then facilitates that you can record yourself reading the text. And this is how we arrive at text and audio aligned data sets. In terms of community engagement, what this has looked like is me and the wider team working on this, looking for opportunities to create this data with the community. It has been a lot of partnership building. In terms of building the text, we've had a partnership with a network of writers in Mombasa in Kenya. And for it to be a similarly beneficial relationship to both us and them, what we do is run a quarterly writing competition. So the writers have a platform and the incentive to create content, they send it in, they get the opportunity to win prize money, but then also have a panel of judges review their work and give feedback. And at the end of the day, all the content that is created through this process gets uploaded onto the platform. Another relationship we have is with a university in Kilifi in Kenya known as Pwani University. And with them, we work with their language department, which has Kiswahili students. And they have, well, with the lecturers, we've worked to build a program, which is a semester-long program where the students are taken through creative writing workshops. We invite external consultants who in their work primarily with language. In the past, one has been a rapper. We've had a podcaster come on board, and the idea is to give to the students in terms of gaining skill, but then also exposure to what their expertise in language can mean in terms of professional opportunities. And then at the end of the day, they also they have writing workshops and essentially essay competitions as well. And again, this is content that gets onto the platform. We've organized similarly with Collecting Voice. This has been events maybe at tech hubs. Tech hubs are very common here. We've had a network of what we call community champions. These are individuals within the community who have shown an affinity for wanting to work either on Kiswahili or particularly on the Common Voice project in collaboration with us. And what we have done is resource the community champions to then have events, whether it's at tech hubs, at their places of work. Some have organized events at churches or church groups because these are the spaces where they have access to their communities. And so the data set has been built in this manner. I'll try to rush through the rest of my points. In our work, we realized that actually learning from the rest of the world, we realized that with AI, there is a lot of opportunity for bias, primarily gender bias. And then somewhat secondary age bias, and this is specifically in speech recognition. So at the outset of our work, we were very intent to make sure that right from the beginning, we are being intentional about looking for and including these populations that are likely to be underrepresented. And then, this results in a biased data set and biased models or end user products. So we've had a gender participation guideline that has guided our work. And actually on Common Voice, Kiswahili is one of very few languages that has an almost equal balance between male and female contributors. And then we also do give individuals the opportunity to not share their demographic details. So it's about a third between male, female, and those who chose not to share. In terms of opportunities for bias, we've also realized that there are things within our context that we need to consider. So with Kiswahili as a language, it's a big language, but then it does have related dialects and variants whose existence has sort of been pushed somewhat to extinction, but then maybe just to less use because of Kiswahili and its influence. So we wanted to make sure that the work that we do for this language can benefit some of the related dialects, which in the past have been negatively affected by Kiswahili. So we've worked with linguists and they have helped us develop subsets of the data set that are representative of these dialects. And at the end of the day, we're then able to evaluate our models to see how well they perform on these related dialects as well. And I'll hand over the mic back to Yasmin. Thank you.
Thank you very much, Kathleen. I think the project that you're doing is fascinating. And if there's one thing that your efforts are showing is that, as what Hilary and Millie also mentioned, is that you just can't do it alone. You need allies across the multi-stakeholder spectrum. And we're very lucky today to have Zoe joining the panel. She's a senior manager on the consumer trust team at Google, where she focuses on building responsibility and trust in products for Google Search, News, Maps, and Assistant. Previously, Zoe worked in Microsoft and Facebook, and prior to joining the tech industry, she served in various capacities within the UN and the US Department of Justice. We're very lucky to have Zoe here today, so now Zoe, over to you.
Great, thank you so much. I have a couple of slides, and I'm going to take this in a slightly different direction, and one that's very focused on product. I am on a product team, and as Yasmin mentioned, work on products like Google Search. So that's what I'll talk about. So one of the issues for responsible AI lately really has to do with how do we build tools that are trustworthy? How do we build products that are trustworthy? And what does trustworthiness mean in the era of generative AI? So today I'm going to think about how we at Google are thinking through these types of topics. And what I'm going to do is kind of take us back to the early days of the internet. And at the risk of aging myself as a child of the 90s, can I just see a quick show of hands of who remembers any of these tips? Is it sharing at all? I'm seeing a different slide. There we go. Who remembers any of these? Watch out for senders you don't know. Check for grammar or spelling errors. Don't click on unexpected attachments. Yes, great. And so what are the types of tips that we're telling people today now with generative AI tools? We're seeing things like this. Watch out for wonky fingers and arms. Beware of overly smooth textures, and check for weird shadows. And people want shortcuts. They want easy heuristics to figure out whether something is trustworthy or not. And I get it, we're all really busy, but we can end up in some traps here. And so we have to think as a community how to build strong information literacy muscles. So let's just double click on one of these tips, which is telling people to check for weird shadows. And using this as a trustworthiness check is actually really hard to do sometimes. So this is a very classic example. It's a famous photo of Lee Harvey Oswald, and he's ostensibly holding a rifle and communist newspapers in his backyard. And since this was released and published in the press, rumors have swirled about this photo and its authenticity. And the main argument is that this photo's been faked because there's no way these shadows could be real, with one going down and one going on the side. And yet there have been many scientific and technical studies over the years that have debunked this, but this conspiracy theory really just still persists. And so most recently, Hani Farid debunked this yet again. And he is a world famous expert in computer science and imagery. He's the father of photo DNA. He's not, in other words, your average user. And it actually took a lot of compute power to just check the shadows here. And we can't just do this for every image on the internet. So what we're learning is that these shortcuts are neither 100% reliable nor are they durable. So just like when we told people to check for .org in a URL, then spammers started buying up .org domains. And they also learned how to use spell check. And so in the future, AI is also going to be able to figure out hands, right? So these tips are not going to work. So we need more resilient tools in the toolbox for the information ecosystem and everybody in it. So I will just do a quick quiz, and you can grade yourself just to see how good you are without any training at being a visual literacy expert. So quiz number 1. Which of these photos, you can just take a note for yourself. Quiz number 1, which of these has not been created with AI? Give you a minute. The next one is, which photo is more or less as it's described? This one seemingly about climate change on the left, or this one about also about climate change on the right and water levels? I'll give you a moment to guess whether it's A or B. And then lastly, which of these is a real product? Either cheeseburger Oreo or spicy chicken wings Oreo. So please, again, grade yourself. It's actually the house on the left is a real place, whereas the house on the right is AI art. The tweet here on the right is actually from a news photo. The tweet on the left is it's a manipulated photo, not through generative AI, but it was cropped to appear as two different times when it's actually the same photo, same time. And then lastly, unfortunately, spicy chicken wing Oreos are real. So how many of you got 100% of these correct? Okay, so I'm not seeing anybody taking credit for that. And that's because we're actually pretty not great at this. And so big thanks to Sabrina Caldwell at the Australian National University and her co-authors for inspiring this quiz. They did something very similar. They actually had study participants and track their eye movements. And what they found is that people are not good at this. Their accuracy rate is a little bit better than a coin toss. And moreover, they're not very good at identifying what's wrong in an image, what particular thing has been manipulated or not. So we need better information literacy tactics as a community, and those tactics need to evolve to prepare for more AI-generated content. But the question that is this AI is not the same as is this trustworthy? And we are seeing a lot of conflation of these two questions lately. So here on the left, we have a non-AI generated image. It's supposed to be of trash left by climate activists in Hyde Park. And so the claim here is that they're hypocrites because look at all the trash they leave around. But actually, it's from a 420 weed smoking celebration, which makes a lot more sense. And then here on the right, we have a photo that I prompted an image generator to create with the prompt Art of Hyde Park, London with trash. So which one is trustworthy and which one is not? The context here really matters. And mis and disinfo can happen with generated images, and they can happen with plain old vanilla taken out of context images. So sometimes real maps onto trustworthy, and sometimes it doesn't. So I'm gonna go ahead and skip over some slides just for the sake of time. And I'm going to go to one area that people have, it's been a really hot topic in the area of responsible AI, and that's assertive provenance. And so what we mean by assertive provenance, we're talking about metadata, labels, meta tags, marking, watermarks saying, this is generated by AI. Now, I'm not going to talk about the technical feasibility of this. What I'm going to do is talk about possible user perceptions of labels. So recently at Google, we did a study with about 8,000 participants, now they're US only, and we showed them an image with one of 3 labels. And we asked them questions about their interpretation of what this label meant, their confidence in the accuracy of the label, and how trustworthy they thought the labeled content seems to be. And what we found was that comprehension really varied by label, and it was actually lowest for unlabeled content. And one thing I want to point out is that 14% of participants totally misinterpreted the meaning of a piece of content that had no label. The correct interpretation of no label means we don't know. We don't know if it's generated or not. But these participants thought that it meant that the image was not changed at all. And here we need to talk about what some call the implied truth effect, which is a phenomenon where when some content is labeled as false, users infer that unlabeled content is true. And so we actually tested this. We presented respondents first with labeled content and asked them how trustworthy they thought that it seemed. Some of them saw labeled content and then unlabeled content, and some saw unlabeled content and then labeled content. And the TLDR here is that the presence of an AI label on some content seemed to make unlabeled content more trustworthy in the eyes of participants. But that's not what it means. It just means we don't know. So what does this mean? It doesn't mean that labels are bad. It just means that we do need to approach all of these solutions, quote unquote, technical solutions to responsible AI very carefully. Otherwise, we could inadvertently increase user misperceptions or misinterpretations. And I know that people really want easy answers, but I think one thing we're seeing is we need many tools in the toolbox. Labels may be one of them. But nothing is a singular silver bullet. Misinfo is sticky, it moves fast, people have low attention spans, but at the same time, we actually have to craft messages that appeal to all and will actually get read. So thank you so much. I'm gonna pass it back, and thanks for entertaining me while I talk about assertive provenance.
Thank you, Zoe. Now I really don't trust myself anymore. And you know that it's a good presentation when you just change your perception on things. So I think that we had a really brilliant set of presentations here, and I think that not only do I learn about more, and I think that I realize how much I don't know about. And one of the key patterns that have emerged from this diverse set of presentations is, how do you sort of, there's so much to do, but at the same time, how do you operationalize that? How do you make sure that we don't have any spicy chicken wing Oreo anymore? No, just kidding. But no, how do we sort of, how do we make sure that, we are more trustworthy as humans, but in the context of AI, how do we make sure that the youth are more engage at the table? How do we make sure that data is equitable in the context of AI development? And so, before we move on to the open discussions, I'd like to ask the panelists a quick fire round of questions. You have 60 seconds to share with us, based on your experience in engaging with communities and or research, what would be your one recommendation to operationalize responsible AI in a way that is meaningful and impactful, again, based on your research and your respective areas of work? How can policy making in this space be relevant, whether it is to better engage with communities, whether it is to build the silver bullet to make us and technologies more trustworthy? Zoe, over to you.
I think from my presentation, the main point that I want to take away here is that there aren't these easy, quick solutions. And what we really need to do is follow the research. So we did user research. We do user research all the time. That's kind of one thing that tech companies are pretty good at. But I think in policymaking or in governance discussions, sometimes we're thinking of things that feel intuitively right or feel intuitively good. And labels is one of them. And I do think labeling has to be part of the answer. But I think that you have to think through, okay, academics are telling me, watch out for the implied truth effect. I'm going to go ask my UX team to study it, and then I'm going to act upon the findings, whether it seems to support my original hypothesis or not. So that is my personal recommendation, which is like have a hypothesis and actually test it and be informed by the best academic research and evidence-based practices. Thanks.
So you are more of an experimentalist.
Yeah, yes.
Kathleen, what is your one quick fire sort of recommendation?
I see a lot of data collection activities ongoing, and since data is the basis of AI, I would say to engage communities as you are collecting the data, educate them on what it means that they're giving that data, what the opportunities are, what can be built with this data, and then beyond that, to give them decision-making power. They should be able to decide what can and cannot be built, or what should be built and what should not be built.
I think that one of the key lessons that I've personally seen as valuable is from the health sector and what they call informed consent. I think that it's really interesting to see the importance of being informed, not just on substance, but also the choices and opportunities and risks that come with it. Hilary, what would be your recommendation?
I think for the first part of my recommendation, it's also very much aligned with Kathleen. It needs to be inclusive, right, and transparent, as I've said before. But I think the other part that is also important is that it needs to be agile, so it can respond to evolving needs of the communities, right? So maybe this year it's labeling, maybe next year it's something else. I think it needs to have that agility as well.
Thank you. Finally, Millie?
Yeah, so I'm in agreement with the other panelists. I think that we need to think about data governance as building trust over time. So think about it as a relationship. You know, sometimes you'll make mistakes, but what counts is how you deal with the mistake. And sometimes having made a mistake can actually help make a relationship stronger because of how you work through it. So think about building trust over time, and that will include agility, responsiveness, inclusivity, but also recognizing that contexts change and needs will change over time. I would also just say on one thing slightly different is that I think the nature of the outcomes will also influence the stakes that are placed on that trust. And if we're in a digital economy where the winner takes all, where there's significant power asymmetry or significant incentives to kind of, you know, to have certain amount of control, then that will actually make that kind of mutuality and cooperation harder. And I think that the greater the power asymmetry, then the more likely it's going to become a race to the bottom. So I think equity and not just inclusiveness.
Thank you, Millie. So now, without further ado, we will be moving to the open discussions. So again, this is not a Q&A. I'm inviting you, everyone, for discussions. Of course, participants are very welcome to ask questions to the panel, and you know, it's brilliant. It's not always every day that we get such a brilliant set of panelists, and I will ask them to intervene for our discussions. But we'd love to hear your thoughts, your experiences on community-centered models of governing AI technologies. What has worked in your experience? What has worked less? What would you like us to learn from you? A few housekeeping notes again. For those in person willing to speak, raise your hand. For those on Zoom willing to intervene, use the chat or Q&A function. And due to the limited time, please keep your intervention short if possible. But we would really welcome your thoughts. And to kick us off, perhaps, one of the questions that we got already online, Rowan, would you like to read it? Because she's our online moderator as well.
So we have one question that's come in from James. He says, how can AI and emerging technologies be harnessed to address pressing global challenges such as climate change and healthcare access whilst ensuring ethical and responsible development?
Yeah, I'm happy to take that because I think we have a couple of very clear examples here. So for climate change, for example, one of the things that's very important is building resilience for communities. So we're using predictive models for both flood forecasting as well as wildfire detection. And actually using these models to tell people right on their phone, okay, expect a flood that's about knee high or about stomach high or about shoulder high. And giving them a little bit earlier warning than they necessarily would have had, not only to save lives, but also to save livelihoods. And on healthcare access, one of the things that we're using AI for is just to bridge the gap for how there is a lack of centralized data on healthcare, for example. So in the US, there's no centralized database, for example, about whether a certain provider accepts this insurance or that insurance. And so what we're doing is using an AI tool called Duplex to call up healthcare providers to say, do you accept Blue Cross Blue Shield? Do you accept Aetna? Blah, 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 blah. And we're putting that now right directly into search and maps. And also Medicare and Medicaid. So people are getting more accessible information at their fingertips while they're not having to do as much work on their own. And also relieving some of the burden on healthcare providers as well, who used to be getting call after call after call, do you accept my insurance? So those are just a couple of examples, but I think the opportunities are really limitless here. I haven't even mentioned generative AI and the way that could help with protein mapping and also possibly personalized medicine. But I am not an expert in that, but those are two examples.
Hilary, given your work on climate change, do you wanna come in on this one at all?
Yeah, maybe just very briefly, right? I think I was actually just in a panel before this one, and we talk a lot about how do we flip the narrative of seeing technologies and online or digital platforms instead of them being a source of harm and risk, but more of a source of opportunities. Actually, I think there have been a lot of youth-led solutions specifically that caters or that tries to use AI to bring good in like global challenges like identifying actions for climate. A few weeks ago in New York in the SDG Summit, actually one of the youth-led initiatives, there was a platform that was created by young people to actually, similar to what was mentioned by Zoe, to provide an early warning system on fire, especially in places in the world where they have heat waves are more frequent and getting more frequent, especially in the global south. There's not a lot. They were using, I believe, data from NASA on this to build an youth-friendly app that allows young people to receive this early warning systems and early warning notifications. And then on top of that, the other exciting thing, and this I think is just one of the many wonderful examples of youth-led solutions, they're also engaging young people to see how young people can help contribute in mapping out data in their communities on both deforestation and forestation efforts. So I think if we are also willing to look into a lot of grassroots solutions, community-driven solutions, there are many ways how young innovators have been using this to mitigate or help find solutions that could help adapt to crises like climate.
Thank you, Hilary. Now, I think that one of the things that struck me from what you just said is the importance of ownership in building these solutions, because I think that AI has a lot of potential to build to address global challenges, but at the same time, if we want it to be inclusive, it also needs to have a certain level of ownership from the communities. And I think that Kathleen, you're really good placed to talk to us about ownership through your experience. Can you tell a few words about that?
Well, I think ownership is interesting, especially ownership of data in this case. It's a great question because I think that many times the communities that are building the data or the communities that the data is about will not have the skills or the resources to participate in the building of AI tools, right? But then the nature of the AI ecosystem is such that when I take a data set and I build an AI tool, first, the transformation is massive, but it's also really difficult to assign back value, right? So it's difficult for communities to maintain ownership because I can take the data set, I can use it without their knowledge potentially, but then also there's no strong motivation for me to give back to the communities. And maybe I'll also piggyback on a question I've seen online from Alex. He asks, does community AI need open source or are they different? So where open source is concerned, I think because we're working with software, I can take a software, incorporate it into something I'm building, and then now I'm relying on this original software. And therefore I can donate back or I can give back by contributing to the code base to make it better. But there's incentive to make it better always. It's very different with data in the process of transforming it into a software or an AI tool. I don't see the strong pull to come back to the community that owns the data to give back or to contribute back to them in the same way, because there's no coupling between the AI software that is built out of it versus, yeah, there's no coupling between the AI software and the data. I feel like I'm rambling, but I think ownership is a great question. I don't think we have cracked enough yet how ownership can be maintained in communities, especially if they don't have the skills themselves to build the AI tools.
Thank you, Kathleen. And I think that, you know, it's the question of incentives is something that I'm trying to think about on a daily basis. What incentivizes people? And it's such an important question for when it comes to data governance, but also in terms of community engagement. And that sort of helps us seg into the second question that was asked by the fellow participants online on the importance of, you know, with the importance of data in the digital age. How can data governance frameworks be designed to balance the need for innovation with the imperative of safeguarding individual privacy and maintaining public trust? How do you sort of incentivize communities to engage, to build data solutions in a way that where they would be, you know, sort of reassured that their rights will be safeguarded and that I mean, those who build the solutions can gain the trust of communities. Millie, do you have some thoughts about that?
Yeah, just on that, I guess I would say that, look, ethical innovation is sustainable innovation, right? Because if you develop something and it's developed in an ethical way and the impacts experienced by people is ethical and fair, then they will carry on using it and it will be integrated into society and economy. Whereas if you innovate, develop something that's not seen as ethical and that's not experienced as ethical, then either it will just stop being used and you've wasted your time and your capital, or if it is used, it'll be used with mistrust and resentment and so on, and that will reduce your ability to maneuver and introduce something else. So I think it's seeing those kind of considerations for privacy, for sustainability, for, you know, kind of like equity and so on, inclusiveness, actually seeing them as good innovation, not just good in an ethical sense, but it's just good business sense, right? And I think that that's definitely something with GDPR when it came in. And I know certainly in the UK, the Information Commissioner's Office, they were really keen to stress, look, privacy isn't just kind of like compatible with innovation, it's necessary for innovation, otherwise what you're making is not going to fly. So I'll just kind of counter that dilemma a bit. But just to come back to that, the first question from James, if I may, I was just thinking as I was hearing the discussion, in terms of AI being useful for health and for climate change and so on, Zoe, I remembered the image on your slide deck about the silver bullet. There's no silver bullet. I think also, just because this technology is really exciting and can do lots of really interesting things, it doesn't mean it's the solution for everything. And I think it's really important to diagnose the problem and then understand what the right kind of tool is. Because if we buy into this idea that AI can do anything, AI is going to kind of, you know, change all our lives for the better, whatever, you're not taking a critical perspective on what AI is, what it's good for, what it's not so good for, what kinds of solutions are long-term sustainable solutions versus what kind of solutions are just band-aids and temporary fixes that are going to leave the underlying issues, the underlying policy questions, the underlying issues of inequality and so on, and existential risk to communities from climate change or lack of public health access. I don't think there isn't evidence yet that AI can address those, and the danger is that we use AI as a band-aid to cover those deeper problems, to avoid dealing with those deeper issues. And I think just this community-led approach is going to be really important for having those community questions about what are we going to do about climate change, what are we going to do about health inequalities, and so on. Sorry.
Thank you, Millie. And you know what you just mentioned, it reminds me of the concept of wicked problems. It's those problems that are related, like, first of all, you can't even agree on what the problem is, and then it feels like when you think of a solution, another problem comes up.
May I just respond to that? Exactly. Yeah. So wicked problems they're never completely solved, but what you can do is ameliorate them by building trust across communities. So once you commit to the process of this community-led approach, you're resilient to deal with the imperfections, you know? And I think that it's because I love AI, because I think the technology is fantastic and brilliant, that I don't want it to be misunderstood, put on a pedestal, and then it falls off the pedestal, everyone's really upset. It's precisely because I think it's such a great technology that I don't want it to be overhyped and oversold, and we need to kind of be realistic about what it is and isn't.
Zoe, you're from Google. Do you think that AI is overhyped? or is it not?
I mean, I would actually question the premise of the question because it's very hard to think about AI as one singular monolithic thing. So when you're talking about data privacy, for example, what Millie was discussing, the salient human rights and the calculus is different if you're talking about a robot vacuum than if you're talking about, you know, facial recognition software, right? Both AI. And so I think it's important to think through what are the systemic risks, what are the risk mitigations that you can put in place for various different types of AI use cases. And I really liked the conversation that Kent and others were having earlier in, on the main stage at IGF about what even is the good definition of AI. You know, should we be using something like a phrase like computational statistics? Because the idea of AI itself can become a little bit reified and obscure and stand for everything and nothing. And so I think we do kind of have to think through it use case by use case.
Thank you. I think that it's really important to think first, what is AI? You know, and one of the sort of components of it that a lot of people are talking about is open source AI. And I think that Alex submitted a question online on does community AI need open source AI? And I think that's something that we briefly touched upon through Kathleen, but I was wondering if Hilary, Millie, or Zoe, do you have any thoughts on the value of open source AI with regards to communities? Do communities need open source AI?
I mean, I do, but I was just speaking, so I don't want to take time away from other panelists. I think just like AI generated does not necessarily map on to trustworthy. I don't think open source always necessarily maps on to good, best, right. And so Google has long supported the open source community. It's been part of our ethos. I think there are like very important questions about, especially around safety and responsibility for open source models. As it becomes easier and easier to fine-tune models with less compute power, if anybody with a computer can do it, some people can tune something to be more hate speechy, for example, or maybe a little bit more biased. And so I do strongly believe in the open source movement. I also think just as you need responsible AI in development in the traditional sense, whether that's being carried out by tech companies or industry, we need a conversation about responsible AI in the age of open source large language models as well.
Yeah, I'm happy to, I guess, build on that. I think, again, just working a lot with young people, many young people I think have really benefit from open source AI in a sense that it makes AI more closer to their ownership, right? But I think the question that we also need to keep in mind is that exactly what was just said by now, is that how do we build capacities of young innovators who can leverage open source AI so that they would have the capacity to build tools and solutions based on AI that are safe, that are rights respecting, that are effective, right? So I think making open source available is one thing, being able to also support all the other building blocks that follows it, such as, you know, capacity building, providing really quality education on that subject as well, especially for young innovators or younger innovators. I think that's also something that we really need to think about as well.
Thank you, Hilary. This sort of got me thinking. The theme, the title of this session is revisiting the social contract. And one question I had in mind for the panelists here is how does AI affect the social contract? You know, we're talking about, for example, capacity building and awareness and transparency and openness and equity. But in the end, it's also a question of those who hold power and those who are subject to power. And so there is this sort of underlying assumption with the social contract that those who hold the power will at least conserve and safeguard the rights of those who are subject to power. How do you think that AI is affecting the social contract, and how does it affect the social contract with regards to the communities that you engage with? Sorry, this is a really difficult question. I think we can write a PhD about that. Kathleen, do you want to go first?
Not really, but I will. I think that it's very difficult for the social contract to be upheld or to be maintained if those in power are not giving power, giving an ear to those who don't have the power. So if the status quo is that those who already have are the ones who continue to build, and we expect that they will consider the perspective of the underrepresented, I think the opportunity for change or doing anything different or maintaining the social contract is very different. It's very difficult. And I don't so much like this idea of a social construct. It seems very centralized. I would opt for a more decentralized state of affairs where everybody has power to some extent in their local context, and they can then define what is right and good for that social context. And I think this is in line with just putting more power in the hands of the communities and letting them maintain whatever social construct is needed in that context.
Thank you. And I think the question of revisiting the notion of social contract and the status quo is so important. And we talk often about AI being revolutionary and disruptive and everything, but is it really disruptive? I know that, Millie, you are working on a piece right now on the revolutionary potential of AI. What do you think about that? How is it really revolutionary for communities?
I was thinking about the question, like, AI and the social contract, and I think that maybe there aren't yet enough use cases for us to be sure. So I can see a way to begin to answer the question about the internet and the social contract. And I can see a way to think about the last industrial revolution that we had that began in Europe that time. So thinking about the impact of the internet and digital economies and the social contract, I think if you think about vertical relationships between individuals and the government, I think that it's really important that the digital economy is seen as equitable and inclusive. Otherwise, if people aren't benefiting or don't see themselves benefiting from the digital economy, then I think the resentment towards government for either introducing it or allowing it to kind of, become part of economy and society, I think that will affect that vertical power relation. But then thinking about the horizontal relationships, peer-to-peer, I think one thing that digital economies have allowed us to do is find each other, and if you're from a minority community or from an intersectional group, being able to find other people like you is really important for solidarity, for empowerment, and even just kind of like sharing knowledge and building up a kind of, a community of language, of culture, of, tacit knowledge and so on. So thinking about how that affects the social contract, the horizontal opportunities and the vertical risks. Don't yet know about AI. I think I would just say that the last industrial revolution that began in Europe, yes, it brought around, huge economic opportunities. It was also the beginning of climate change. It was also the beginning of disability discrimination. It also created categories of disability. And I think that it's, we need to be aware of that. And if we're going to build an economy based on AI, or where AI has a really key role and call it the fourth industrial revolution, then we need to think about, well, who's it going to exclude? Which categories of people are going to find themselves experiencing new kinds of prejudice, and what kind of impacts on the world is this going to have that weren't there before?
So just to bring in a question that we've had online. So we're talking a lot about power, and power is also inevitably about money as well. So we have a question about AI training, and they're asking, does AI access paid resources and research ideas, articles, etc.? And if it doesn't, do we have any comments on that? Is that something that you think that should be changed to make it more accessible and make it more effective as well? Zoe, I was wondering if you want to come in on this.
I mean, I don't think we can necessarily use AI to circumvent copyright laws, for example. And we have to respect rights holders, of course. I think the most practical way I can answer this question is that from a very technical level, site owners, publishers can set their sites to be crawled or not crawled. And they use robots.txt, and they've used that for a few decades now. So there is not a technical solution that I think we would employ to say, oh, a paywalled piece of content, let me get around it with my crawler and crawl it and use it to open up information. I think what we're thinking through is how can we incentivize overall, and maybe this gets back to your question about the social contract, but how can we incentivize content creation on the open web? And how can everyone benefit from that? I think that's probably the most interesting question about the health of the information ecosystem, the health of the web. As you know, I kind of grew up with it, where every one of us nerds back in the day had an Angel Fire site or a Lyco site, or I certainly had my X-Files fan page, which I always talk about. And that type of content creation just isn't happening anymore to the same extent. I had a blog. Millie, did you have a blog? You look like you might have had a blog. Okay. Millie had an Angel Fire. So, I would love to capture some of the spirit of that age of the internet, and now that might be showing that I'm entering my middle age and getting wistful for days gone by. But I think that's where I would focus some of my energies. How can we change some of the incentives to make sure that that people are creating, sharing, consuming content in a more open environment?
Zoe, you're bringing me lots of PTSD with my teenager blogs. I'm not sure I want anyone to see that blog. But anyway, the question of incentives, again, it's so important. And Hillary, as a youth, engaging with the youth, I'm sure that you have lots of thoughts on what has worked and what has not worked.
In the context of incentivizing the youth?
To engage in the first place, because we heard from Kathleen that in her experience, when it comes to collecting data for training and her models, the problem is that the communities that are supposed to, that are targeted to help build those databases, don't see why they should do it in the first place. How have you dealt? Have you ever faced this issue? And if yes, what has worked?
Yes, maybe perhaps sharing a little bit of a different experience. I think, again, right, as I mentioned earlier at the start of this panel, fortunately, I guess, the community that I work with, the community of young people, are actually a generation of digital natives. So I think without actually prompting them, a lot of time they're actually just sign up to be involved and engaged, right? And you see this not only in tech. I think we talk a lot about climate crisis just now, or climate change. No one was actually tasking young people to march up and advocate for their rights to climate justice. No one is particularly tasking young people to create solutions on to create a more better digital future, but young people do it anyway, right? I'm sure you felt that. Many of us have felt that as well. And I think, of course, there's many reasons behind this, but again, it's mostly also because we are part of that generation that will really feel the impact of all of this, right? So not just 2-3 years from now, but 50 years from now, 10 years from now, 50 years from now, 100 years from now, I think, again, right, as a young person who lives in this age of time, for me, and I think if I can also speak on behalf of many other young people as well, if I don't engage, if I don't take part of being the solutions, even though the room might not be open for me, I would be afraid of not doing enough to change the discourse of my future, right? So I think when it comes to incentivizing the youth, I think they're already very much there and motivated and then putting themselves out there. But the question is that how do we incentivize partners across generations, across stakeholders to actually work together with youth who already signed up for this, who already showed up even when the world is not opening doors for them, right? So I think it's a slightly different experience, but I would have to say that it also takes a lot of privilege, right, to show up, to be a part of the solutions. Many young people, as you know, like they're in school, they just graduated. Some of them are still in school. Many of them are also still adolescents. So I think if we're serious in incentivizing youth, we also have to look into what are the enabling environment that's needed to help them to effectively contribute to this, right? It's again a privilege to be able to advocate for transparent AI process in a country where your rights is valued, your rights is protected. It might not be the case in many countries, and I think when it comes to, again, incentivizing youth, you need to look into all that other external factors as well, not just incentivizing them from a motivation perspective, but actually building a safe and enabling environment for them to be able to participate. So.
Thank you. I think that enabling an enabling environment for effective and meaningful contribution, I think that is really beautifully put. And that reminds me of a project that Rowan is helping to conduct on recursive public that she mentioned earlier in her introduction. Rowan, I wonder if you can say a few words about it.
Yeah, sure. We're conducting a project with OpenAI and vTaiwan, which is looking at using AI tools such as Polis to enhance the democratic process. And we're looking at AI policy in particular. So we have reached out to hundreds of different people from many different sectors to gauge their opinions on different statements around AI to help it try and inform policy and OpenAI's policy on AI. So yeah, that's the project.
I like how it's AI helping to shape AI policy as well. You know, when we think about the effectiveness and meaningfulness of contribution of communities such as the youth and everything, we often think about, as you said, those who want to contribute, but at the same time those in power who are able to help implement those solutions. And one of those who are in power, obviously the government, but then the other sort of entity that is there is the private sector. Zoe, I wonder if you can sort of share a few words on how Google helps to engage with those communities and sort of take forward recommendations and work on, you know, making sure that AI is indeed developed in a responsible way.
I mean, I think the most important thing to mention here is that we have an established process for rolling out and testing changes. So it's not necessarily that any engineer, we have thousands of engineers, that any engineer has a good idea and we just roll it out and push it into prod. There are different ways that we test to see whether things are actually better for users. And one of the ways that we do this is using search quality raters. And I actually think using search quality raters is a good proxy for communities because they are supposed to represent average people. They're not content moderators, they're not fact checkers. They help us understand if our changes are actually better for the people who are meant to be using our products. And so launches go through a rigorous battery of tests. Some are automated and some include human rating. And no one within Google, not even Sundar, can change the results of those evaluations. And we use those to understand whether we should actually launch a change or not. So that's one way, and that's a long-standing practice at Google.
And how can you become a search quality rater? Because you said that it's a way, it's a sort of proxy way of engaging communities. If anyone here is keen on becoming a search quality rater, how do they do that?
We do recruit. Through contracting services, and it depends on where we need rating at any given moment or time. So people can become raters. My colleague Jeff, who's actually now on our search public policy team, he actually, back in the day, just graduated from graduate school and decided to become a search quality rater as kind of a temporary gig in between jobs. So, so it depends. I don't know exactly every single country where we're looking for raters, but I can certainly share more information about the program to you.
Yeah, thank you, Zoe. So as we're wrapping up, just to remind everyone that this is a learning opportunity, and I wanted to ask our panelists in 60 seconds to summarize one thing that they have learned today. Millie, you're the first.
Thank you. Well, a surprising takeaway for me from the session is thinking about the different meanings of community. You know, community can be local, it can be geographic, but it can also be transnational. It can be a generation, as in, you know, what Hillary works with, or it could be a community of interest. You know, for example, what Kathleen works with. So just thinking about the different definitions of community, and then that also means that every one of us is a member of more than one community. So I think thinking about community-led frameworks, thinking about making them adaptable and resilient is just going to have to be the way forward, because I think we're all a lot more conscious of what it means to be part of different communities, and these communities are no longer as rigid and kind of bound in time and space as they used to be before the internet.
Thank you, that's really beautifully put. Hillary, what is your one surprising takeaway today?
Well, it's not surprising, but I think the one key takeaway is that there is a huge appetite, it seems, from different partners from across stakeholders to work together to build a responsible AI, which I'm excited to see how that will look like in the next couple of years as well. But I think the other key takeaway that I thought when I'm hearing all the panelists is like how this work is, and I think is still going to be very much ever evolving. And then in this process, it's important that every step of that evolvement or evolution, we need to make sure that community is engaged, right? Diverse set of community, inclusive community. So that's my one key takeaway.
Thank you. Kathleen?
The thing that resonated with me most is something that one of the other panelists said about thinking of the collective in this age of AI as opposed to individuals. So collective rights, collective harms, collective benefits, and then I will add collective power. Thank you.
And finally, Zoe.
Well, one very tangible thing is I learned more about the Chatham House project about AI governance. I'm quite interested in that. My dear friend Aviv Avadia has been writing a lot about this, and I've been kind of thinking through, well, what would that actually look like in practice? So kind of excited to see how you're going to bring that to life. Thanks.
Thank you. So I wanted to thank all the panelists here today for joining us either in person or online, and also the participants for their brilliant questions. To repeat, we'll be uploading a meeting summary and the key takeaways on the IGF's website, and you can find the recording of the session on YouTube. And you know, if you want to engage more on our work, whether it's the brilliant work that each of the panelists is doing or Chatham House's work, please feel free to contact us in person or by email. Thank you very much.
I think I'll be in London next month. So. Oh, that's great. Let's come say hi. Yeah, so maybe you guys come say hi because we have free food. Yeah. So.
Are you going to the Safety Summit?
No, doing some child safety work. Well, good to see you, everybody.